Today it is my honor to nominate to the Supreme Court
Amy Coney Barrett on the path to a seat on the Supreme Court.
I fully understand that this is a momentous decision for a president.
Facing a confirmation hearing just weeks before an election.
President Trump and his party have made it clear they will pick a justice who will get rid of the Affordable Care Act.
The stakes are high, and the future of the court hangs in the balance.
I think it's telling to see Senate Democrats openly affirming that Judge Barrett's actual judicial qualifications do not matter to them.
Special coverage begins right now.
Good morning to those of you just joining us. I'm Joe Fryer.
And I'm Savannah Sellers. We are less than 30 minutes away from the anticipated start of Amy Coney Barrett's confirmation hearing. The president nominated her to the bench 8 days after the death of Justice Ruth Bader Ginsburg.
A live look now inside the room where it will all happen. Today's hearing before the Senate Judiciary Committee is the first of 4 this week, and each day promises to be contentious. For one, Democrats didn't even want to be here today. They wanted to wait until after the election to fill RBG's seat. But Republicans control the Senate, and they get to set the timeline. If confirmed, Barrett would be the 3rd justice appointed by President Trump.
She has faced this committee before. In 2017, she was confirmed as a federal judge. The vote then, 55 to 43. Only 3 Democrats voted for her. There is one senator Barrett didn't face then, but will this time around, and that's Senator Kamala Harris, the Democratic nominee for vice president. But Harris won't be there in person. She'll attend virtually instead because she doesn't think it's safe due to coronavirus concerns.
It was Barrett's nomination at the White House that Dr. Anthony Fauci called a super spreader event. Republican Senators Thom Tillis and Mike Lee were both there. Both later tested positive for COVID. Tillis will attend virtually today. It's still unclear if Lee will as well.
Lots to cover, and we have 2 of the very best to kick off our coverage. Leanne Caldwell, NBC News Capitol Hill correspondent, and NBC News Justice correspondent Pete Williams. Pete has covered every Supreme Court confirmation for the last 27 years, starting with the confirmation of Ruth Bader Ginsburg.
So, Pete, let's start right there. RBG was nominated and confirmed in 42 days, but that was 1993. It was not an election year. How compressed is this timeline for Judge Barrett?
Lots, and the Republicans make no bones about it. I mean, they're quite straightforward in saying that they want to try to get this done while their president is still in the White House and while the Republicans still control the Senate. It's as simple as that, and that's why they want to try to get it done very quickly. Now, today will be a hearing in only the most loose sense of the word. She will spend her entire day hearing senators give their opening statement. So that's all that happens today. Everybody in the room gives an opening statement, all the senators, and then finally, at the end of the day, she will give an opening statement. She'll be introduced by some senators, home state senators and supporters. Then she'll give an opening statement and introduce members of her family, and that's that. So the questioning doesn't actually begin until Tuesday and Wednesday. But you're right, this is certainly a compressed time frame, and the Republicans are quite straightforward about they want to try to get it done while they still have the votes and the control.
Now, Leanne, as that was just mentioned there, we'll only be hearing opening statements today. Questioning doesn't begin until tomorrow. But set the stage for us. What will we see today? What kind of environment is Judge Barrett walking into? What do we know about the meetings that she did or maybe did not have with members of the Judiciary Committee?
Good morning, Savannah and Joe. So I think that it might be easier for Amy Coney Barrett to walk over hot coals directly into a fire compared to what she is going to face this week. That's because Democrats have made no bones about it how enraged they are that Senate Republicans are moving forward with this hearing 3 weeks before Election Day, as millions of people have already voted. So as Pete said, there is going to be no banter back and forth. Judge Barrett is not going to be able to defend herself. She's going to have to listen to all the opening statements, all the statements that these senators make. And you can expect Democrats to really focus on what they are calling illegal process, basically an illegitimate process, I should say, and also focus on the Affordable Care Act. They know that the week after the election, the Supreme Court is going to hear a case on the Affordable Care Act. They know that voters are voting about health care in these November elections, and so they are going to make that a prime focus. Expect Republicans, however, to defend Amy Coney Barrett, and we're also going to hear from her for the first time as well, where she'll talk about her biography and a little bit about how she views the role of a Supreme Court justice. Savannah, Joe.
Yeah, and Pete, we're hearing a lot about the ideological balance of the court. Well, RBG was still alive. There was a Pew Research poll that found that a majority of Americans, 56%, found the court to be middle of the road. Obviously, when you replace RBG with Justice Barrett, that is going to change. How much does it change? And do you expect this to be something that she's going to try to address this week?
I don't think she'll talk about how she would change the ideological makeup of the court, no. And I'm a little surprised by that finding, because this has basically been a pretty conservative court over the last few years, with some notable exceptions. And that'll sort of depend on who the swing justice was. When it was Anthony Kennedy, the court endorsed same-sex marriage. Just in the past term, the court said that the existing civil rights laws covered discrimination on the basis of sexual orientation or transgender. So those have been somewhat exceptions. It's pretty conservative court. It'll be a very conservative court if she's confirmed. You'd have 6 solid conservative votes. John Roberts, who to some extent was the swing vote after Anthony Kennedy retired, would no longer have that position, because even if he did vote with the liberals, you'd still have 5 conservatives, and in the Supreme Court, it takes 5 votes to win. Sandra Day O'Connor used to say, what's the most important thing to know about the Supreme Court? The answer is, can you count to 5? And there would be 6 conservatives if she's on the court. It was remember with Ruth Bader Ginsburg, if John Roberts switched, he could make a liberal majority if he voted with the liberals. So there's no longer a possibility for that kind of swing voting. It would be a more conservative court, no question about it. And the conservative supporters of Amy Coney Barrett are looking forward to that, and they hope that very much is what happens.
Now, Leanne, ultimately this process ends with a vote, and Republicans have the majority in the Senate, of course. So let's just get this out of the way. At this moment, is there any doubt from Republicans that Barrett won't get confirmed?
Nothing that we can foresee for the moment, Savannah. There was some concern, especially with the COVID diagnosis that have racked the committee and the Senate Republicans in recent weeks. There's going to be 2 members of the committee who have been diagnosed with COVID. Of course, that's Senator Thom Tillis of North Carolina and Senator Mike Lee of Utah as well. Senator Tillis will be attending the hearing virtually. Senator Cruz will as well, because he came into contact with Senator Lee. We're still waiting to hear on if Senator Lee will attend the hearing in person or do it virtually. But the COVID outbreak that has infected the White House and the Senate was one thing that might throw this off the game. But it seems now that all things are leading towards this being Amy Coney Barrett being confirmed before Election Day. But of course, anything can happen. Remember, just the last Supreme Court Justice nominee, Brett Kavanaugh, he was on a clear path to confirmation, and then these allegations came out about him. We don't expect any allegations like that, but I'm just trying to make the point that we can't predict the future, and while things look like it's on track and going to move quickly, we obviously have to wait and see and take it day by day.
Certainly can't predict the future these days. That's
2020,
for sure.
yeah. Okay. Leanne Caldwell, Pete Williams, thank you so much for your expertise.
You bet.
Let's now bring in our panel. We have Sahil Kapoor, NBC News national political reporter, Kim Whaley, law professor and author of What You Need to Know About Voting and Why, and Michael Beschloss, our NBC News presidential historian. Sahil, I want to start with something Senator Lindsey Graham said back in 2016 when Republicans refused to give Merrick Garland, Obama's nominee, a hearing during President Obama's last term. Take a listen.
I want you to use my words against me. If there's a Republican president in 2016 and a vacancy occurs in the last year of the first term, you can say, Lindsey Graham said, let's let the next president, whoever it might be, make that nomination. And you could use my words against me and you'd be absolutely right.
All right, so obviously we are using those words right now to set up exactly how does he explain that away, and how much time do you expect Democrats to spend on that fact right there, that we have that video?
Yeah, those words have really come back to haunt Lindsey Graham, and it's one of the reasons you see him facing an unexpectedly competitive race in his safe red state of South Carolina. Nobody really expected that seat to be in play, but he's facing a very well-funded challenge from a from the Democrat Jamie Harrison there. As to whether Democrats will use these words against him, I would expect absolutely yes, but I don't think it will be the main focus. There are other issues. There are kitchen table policy-related issues, like most notably healthcare, including abortion rights, including workers' rights, that Democrats want to focus on. So I do think Graham will have a bit of a tough time trying to explain this, because there really is no way to square those words with what he's doing now. What he has said in his South Carolina Senate debates is that he is absolutely determined to confirm Judge Barrett, make her Justice Barrett. And he has also argued to me when I asked him several months ago that the Brett Kavanaugh Supreme Court confirmation hearings, in his view, changed the game. You can look at that as a midpoint between what he said in 2016 and what he's doing now. People can decide for themselves whether that's a justification or, whether that's a guidepost to where he always wanted to end up in this scenario.
Michael, we've seen some confirmation hearings that were smooth sailing for the nominee in recent years, and we've seen some incredibly contentious ones. Has the process always been this politicized, or have we seen it change in recent years?
No, we've seen it change since the hearings over Robert Bork in 1987. That was the most controversial nomination in recent times, in which Bork was portrayed as a conservative who would change the status quo in America, and his nomination was blocked. Ever since then, people have been very conscious of not only the importance of a seat on the Supreme Court, but also the fact that a domestic political environment can change the outcome, as it did that year. And the other thing, Joe, is that if you're looking at this in history, Donald Trump has had now 3 nominations to the Supreme Court. That's a lot for a president. One might argue that Republicans have created all 3 of those vacancies in ways that would not have happened had they not been so aggressive. Just as you were saying, 2016, by denying President Obama the ability to get a justice on the Supreme Court his last year in office. Second time by urging Anthony Kennedy to get off the Supreme Court so that Trump would have a vacancy, and now by insisting the nomination and confirmation be rushed through before the 2020 election, something we haven't seen before.
Kim, let's now turn to Barrett and her approach to the law. Here's what she said during her acceptance speech at the Rose Garden. Take a listen.
I clerked for Justice Scalia more than 20 years ago, but the lessons I learned still resonate. His judicial philosophy is mine too. A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold.
Now, we hear her there referring to what's called this textualist or originalist approach to the law. Tell us a little bit about what this signals to you, particularly on the issue of abortion.
Well, I think textualism and originalism has taken on this mythical quality, and it's really kind of a ruse. And I say it because the Constitution is a very, very old document, and the language is vague, just like a biblical text or a poem. And so judges have to wrestle with ambiguity, and there are ways of doing that. You can look to precedent. What did the court do in the past? And let's be consistent with that, because then Americans know what to expect under a particular constitutional provision. You could look at dictionary definitions. You could look at what the framers meant at the time. You could also look at the normative objectives. Why do we have a constitution? What are the rationales behind this constitutional language? What Judge Barrett is saying is that, well, there's one way to read it, and I know what that way is. And I'm going to read it that way, even if the precedent suggests something else. So for Roe versus Wade, I think she'd be very comfortable saying, I know it when I see it. I know what due process means. It doesn't mean protecting women's ability to decide their own health care regarding their reproductive process in the face of government regulation. And so I'm going to reverse a decision that would protect that woman's right vis-a-vis the United States government. It's really unfortunate that this constitutional theory that really came onto the scene with Justice Scalia has taken on this sort of black versus white sort of quality with when people go to the polls and vote. It's just not accurate that there's one way to read clear language, and Judge Barrett knows what that way is.
So, Hill, if there's one issue that might get more or at least as much attention as abortion, it's going to be Obamacare, the ACA. The Supreme Court is going to be taking on a challenge to that law a week after the election. So how central will this be to the confirmation fight? I expect Democrats are going to be bringing it up every chance they get.
That's a bring up healthcare and the ACA today. I would expect her to get peppered with questions about the ACA tomorrow when the questions begin. And I spoke to one Senate Democratic aide about this, who said they're not under any illusions that she'll say anything useful here. Judges always dodge these kinds of questions. She's not going to, say anything about a case that could appear before her. She's not going to drop hints as to, how she views that relevant portion of the law and how she would come down in the Texas case. But if she dodges that question, that is a massively useful political thing for Democrats in their view, because they can continue to argue that she is a danger to the ACA, and that if she's confirmed in the Supreme Court, she could rip away, or her vote could end up being decisive in a case that could rip away protections from, millions of Americans and take away coverage from about 20 million Americans. The other thing I wanted to point out is that Judge Barrett is the product of a movement on the right that rose in a backlash to 1960s and 1970s Supreme Court decisions like Roe versus Wade and the decision that gave us Miranda rights. And the way she speaks, about judges and default the rule of law, not legislate from the bench, these are deliberate code words that conservatives have developed over the last several generations to speak precisely to that grievance.
All right. Thank you so much to our panel, Sahil, Kim, Michael. Stay with us. We'll be back with you shortly.
President Trump expects his nominee to be confirmed, but if somehow she isn't, he says it would be Republicans' fault. That's what he told Fox Business last week. NBCNews.com senior White House reporter Shannon Pettypiece joins us now. So, Shannon, what do we know about how the White House has prepared Barrett for this confirmation hearing?
Well, they are hoping to sell her to Republicans and to the president's core base of supporters as a solid conservative pick. You noted those comments of the president saying if she isn't confirmed, it's going to be Republicans' fault. Well, that's because Republicans are in control of the Senate Judiciary Committee and obviously in control of the Senate. So the president and his team have been setting her up not to appeal to moderates. They are not focused on concerns about whether she's going to undo Roe versus Wade, because this is a pitch to conservatives who sit on that committee, who are in the Senate, and then, of course, conservative voters who they're trying to drive out to vote for President Trump, even though they might have concerns about his character or his demeanor or some of his actions over the past 4 years.
So the president heads to Florida tonight for his first campaign rally away from the White House since testing positive for coronavirus. As a campaign issue, how important is the Supreme Court for the president?
The Supreme Court is important for the president to the extent that it gets people talking about, to stop, that is, talking about coronavirus and the president's health. So today, these hearings, the hearings we'll see and the votes over the coming days, those are all moments to get the focus off of coronavirus, because over and over again, polls show that when this election is about coronavirus, when voters' minds and attention is there, that is when the president sees his poll numbers go down. So, again, to the extent it can drive out conservative voters who may be hesitant about supporting the president by seeing a real solid conservative nominee he is putting on the bench, that is a reminder to those voters, why they elected him in the first place, despite their hesitations about his character, and they're hoping that that is going to drive them out again. And if nothing else, get people talking about something other than coronavirus.
All right, Shannon, thank you so much.
Thank you.
We know the White House thinks Judge Barrett would make a great Supreme Court justice, but what about voters? Steve Kornacki's at the big board with that answer. Steve?
All right, Savannah and Joe, well, here we go. Another Supreme Court battle, this one against the backdrop of a presidential election. So first of all, a bunch of polls have come out ahead of the hearings. Here's one on the basic question. Look, they're having the hearings. The Republicans say they're going to bring this to the full Senate for a vote. What do Americans think? The nomination's there. Should it be approved by the Senate? or should it be rejected by the Senate? Okay, we've had 3 different pollsters now in the last couple of days take a look at this question. If you average together the numbers, because they bounce around from poll to poll, here's what's interesting. If you average together all the polls out there on this topic, here's what you find. Dead even. Perfect split. 46% say confirm her, 46% say reject her. So the country really split right down the middle on that question. Now, what about what people think of the nominee herself, Amy Coney Barrett? Obviously, they will hear a lot from her in the hearings, probably get their deepest look at her yet. But, you know, there was obviously that ceremony in the Rose Garden. There's been some stuff out there about her so far. How are people processing this? What do they make of Coney Barrett? What's the first impression of her? Well, there's this from a CNN poll. They asked, do you have a positive or negative view? These are low numbers because a lot of people don't have much of a view of her yet, but it's 38% positive and 29% negative going in. How does that compare? This is the 3rd Supreme Court nomination for Donald Trump. At the same time, you know, right before the hearings for the other 2, Kavanaugh, Gorsuch, how does this compare? Well, let's take a look here. There's Brett Kavanaugh. Pretty similar, 33-29. Remember, of course, his hearings exploded into quite a drama. And then there was Gorsuch, 39-24. So it's sort of somewhere in between these two, but this is sort of what Supreme Court nominee. This is the baseline for a Trump-era Supreme Court nomination pick. We'll see what changes during the hearings, but it's right in line at 38-29 with what we've seen with the other 2 Trump nominees. And then there's the question about how does all of this play out in the presidential race. Here's one way of looking at it. We asked this in our NBC Wall Street Journal poll. We asked who would do a better job when it comes to Supreme Court nominations. And you see Biden leading on that question, 46-37. Voters saying, plurality there, that they favor Biden when it comes to handling the Supreme Court to Trump. Now, keep in mind, however, we asked the same question in October 2016. And remember, in 2016, there was that Antonin Scalia seat on the Supreme Court that Republicans were holding open. The court loomed as an issue in 2016 as well. At the same time, October 2016, we asked who would do a better job on Supreme Court appointments. Boy, doesn't that look pretty similar? 46-37 for Biden now. It was 48-38 for Trump in 2016. So actually, on this issue, Trump versus the Democrats looks pretty similar to what we saw in 2016. There is a question here of intensity. It's hard to measure, but when we get to Election Day, is one party going to be more exercised, or activists on one side going to be more exercised about this? But as a baseline question, folks seem to feel, generally speaking, broadly speaking, the same about Trump and Supreme Court picks now as they did when he was a candidate.
Steve Kornacki, thank you. Our panel is back with us. Sahil Kapoor, Kim Whaley, and Michael Beschloss. Kim, let's start with you. You've actually written about how one of Barrett's first cases, if she's confirmed, could be about this presidential election. So what does her record suggest about how she might handle that? Democrats are probably going to push for her to recuse herself. What's the likelihood of that?
Well, she's indicated that she would not recuse herself, and we're already seeing lots of litigation across this country. Essentially, as states are expanding access to the polls in the midst of the coronavirus, the Trump campaign and, frankly, the Republican Party are filing lawsuits to challenge that and make it harder for people to actually vote in a pandemic. The tricky part is that there's actually no affirmative, clear, spelled out right to vote in the original Constitution, which makes it easy for courts to basically bless efforts by states under the guise of election efficiency to make it harder to get to the polls. I mean, we've seen since 1969, 15 justices appointed by Republicans and only 4 appointed by Democrats. And what this has meant is not just this election, but across the board when it comes to voting rights, a conservative court, leaning court has not been friendly to voters. It's allowed unlimited amounts of corporate money into campaigns under the theory that corporations, which are legal fictions, have First Amendment rights. It's upheld with very little evidence, very strict voter ID requirements. It's struck down bipartisan legislation called, known as the Voting Rights Act, that made it harder for basically bad actor states that were making it hard for African Americans to get to the polls to have to run their changes by the Justice Department. The Supreme Court struck that down. So if this issue, an issue with respect to a a close race in maybe a swing state were to go to the United States Supreme Court, I think we could expect not just Coney Barrett, but the other conservatives on the court to vote in favor of the Republican side, and I say that because it's not so far been pro-voter. And this has implications well beyond this particular election. Of course, the question of the conflict of interest is, listen, she's being put on the court by a nominee to the presidency in the midst of, this very pitched battle. She should recuse herself and say, listen, I don't want to be perceived as biased and voting in favor of the person who gave me this lifetime appointment with extraordinary power. But I don't think we're going to see that.
Now, Michael, let's talk about Judge Barrett's religion. She is Catholic. We also know that she's affiliated with this group called the People of Praise, this tight-knit faith community who has since removed mentions of her and photos of her from their website. Now, Republicans have accused Democrats of attacking her faith, and the one exchange they point to is from Barrett's 2017 confirmation process. Let's listen to that real quick.
The dogma lives loudly within you. And that's of concern when you come to big issues that large numbers of people have fought for years.
Now, that was Senator Dianne Feinstein, who is, of course, still on that Senate Judiciary Committee. Now, Michael, put this in context for us. Should her faith have any bearing on this? Should this be brought up in a Senate confirmation hearing for something like this?
Her faith should not. But going back to the 1987 hearings that brought down Robert Bork, every single nominee for the Supreme Court ever since then has gone before the Senate Judiciary Committee and basically suggested that they were not that decided themselves on issues like Roe v. Wade, or perhaps they should not comment on issues that might come before the court. And so the result is that people have been looking very hard ever since then for signs of what the justice might do if they are made into a justice on the Supreme Court. So absolutely no justice should be considered in terms of his or her religion. But the problem is that this committee is looking for every single clue to tell them what kind of a justice they might be nominating. So it's a little bit of a quandary.
But we have a development here, too. One of the two GOP senators who had tested positive for COVID, Mike Lee, we weren't sure, was he going to be in person or was he going to do this virtually? He tells Hugh Hewitt today that I will be participating in person. He said he gotten the sign off from the Office of the Attending Physician. He's gone through the appropriate number of days and has been keeping his temperature under control and is no longer contagious. So one of the senators who had tested positive for COVID just within the last 2 weeks now says he will be there in person today. Now, Sahil, we should ask you about another person who is not going to be in the room but is on the committee. That's Senator Kamala Harris. She's the lowest ranking member in the Judiciary Committee, but she's going to have a lot of attention on her. How is she going to handle this? Because essentially this is the campaign trail for her this week. So is she going to try and stand out? Is she going to try and sort of make a big statement? Or is there some risk in that for her when it comes to questioning Barrett?
Yeah, the lowest ranking member and yet probably the most high profile member because she's the only one in that room who's on a presidential ticket right now. The background for Kamala Harris on this is that she has been a very aggressive, dogged questioner of President Trump's nominees to the executive branch and the Supreme Court. She got a lot of praise for the way she aggressively questioned Brett Kavanaugh, the president's previous Supreme Court nominee. So I would expect her to bring that same level of chops to this battle. She has said, by the way, she will do this virtually. She will participate in the hearings virtually from her Senate office, not in person, and she has blamed Republicans for not putting in a proper kind of full COVID testing regime. She said their behavior, the Republican behavior, is putting senators and members of the press and guests at risk on this. Kamala Harris's role, in large part, beyond simply the fact of her on the committee, will obviously be to carry the Biden campaign message here, and it tracks very neatly with how Democrats want to handle this. Expect, as we were talking earlier, a lot of questions about health care. That's probably the single biggest issue along with the coronavirus that Joe Biden is talking about. And it's a perfect storm for that presidential ticket because President Trump ranks low on this issue. He has high disapproval. He has said repeatedly that he'll pick judges who rule against the ACA. He was critical of Chief Justice Roberts in 2012 for voting to uphold the ACA's individual mandate and preserve most of the law, and said he wouldn't do that. The president is currently at the Supreme Court. His Justice Department, I should say, has filed a brief with the Supreme Court urging them to strike down the ACA. So there's a lot here for Kamala Harris to work with. I would expect them to stick with that. And I would expect Democrats to stay as far away as possible from questions about her religion and faith, because they know conservatives are going to be
all right, Sahil, thank you so much. We are going to get ready for the hearing, which starts in just a moment.
Here we go.
This is an NBC News special report. The Barrett confirmation hearing. Here's Savannah Guthrie.
Good morning, everybody. We are coming on the air to bring you live coverage of the Senate confirmation hearing for Amy Coney Barrett, the president's nominee to succeed Ruth Bader Ginsburg on the U.S. Supreme Court. This, of course, comes at an extraordinary moment for our country in the grip of a pandemic. And 22 days away from Election Day, we are taking you inside a look at this hearing room where we've seen some of Amy Coney Barrett's children, her husband, family members. It's a large hearing room on Capitol Hill where other Supreme Court confirmation hearings have taken place, but never quite like this in terms of timing and in terms of what the country is going through. That's one of the senators seated now. In a moment, we're going to hear opening statements from the senators. There's Lindsey Graham, the Republican chair of the Judiciary Committee, talking to his counterpart, Democrat Dianne Feinstein, who is the ranking Democrat on this committee. As we watch this unfold, these few moments before the hearing gets underway, I want to go to NBC's Casey Hunt, who covers Capitol Hill for us. And Casey, of course, this comes at a time when we're very close to Election Day. In fact, some people are already voting in states that allow early voting, and that itself is the backdrop and the controversy that underscores this moment.
So many ballots even already cast, Savannah, and that incredibly heated political crucible, really, that we are in is the backdrop for this hearing. And that is, of course, a big part of why Republicans want to move so quickly to try and put Amy Coney Barrett on the court. This hearing just 16 days after she was nominated, and they want to take this to a final vote on the floor before Election Day. And part of the reason for that is what we're going to hear Democrats focus on today. Just a week or so after the election, the Supreme Court is expected to hear arguments on the Affordable Care Act. It's a lawsuit that would basically strike down that law, and Amy Coney Barrett, if confirmed, would be in a position to potentially rule on that. So Democrats today, you'll see in a few minutes, planning on displaying photos of constituents who could stand to lose their health care if that were to happen. We also, Savannah, can report that Senator Mike Lee, who's in this room, and you pointed out how different this is because of the pandemic. Senator Lee was at the White House, was positive for coronavirus. He's appearing here in person today. Savannah.
All right. We are watching this hearing room. It's gaveling in right now. I believe we see the nominee walking in. Let's take a listen.
Learn about the differences in judging and maybe the differences in the party. If that happens, it'll be a successful hearing. As to the hearing room, I doubt if there's any room in the country that's been given more attention and detail to make sure it's CDC compliant. The architect of the Capitol, working with the attending physician, has set up the room in a fashion that we can safely do our business. Senator Lee is back. You've been cleared by your physician. Welcome back. The COVID problem in America is real. It's serious, it's dangerous, and we have to mitigate the risk. I would just let every American know that many of you are going to work today, probably already been at work, and I hope your employer will take care of your health care needs. But we do have a country that needs to move forward safely, and there are millions of Americans, cops, waitresses, nurses, you name it, going to work today to do their job, and we're going to work in the Senate to do our job. And one of the most important jobs the Senate Judiciary Committee will ever do is have hearings and confirm a justice to the Supreme Court. So for housekeeping purposes, the first day has traditionally been opening statements by my colleagues. We'll do 10-minute rounds, and everybody will have 10 minutes to talk about their views of the hearing and what this is all about. Then we will have a panel to introduce Judge Barrett, and she will make an opening statement.
We'll try to finish mid-afternoon if that's possible. Then Tuesday and Wednesday will be long days. There'll be 30-minute rounds for every senator, followed by a 20-minute round. My goal is to complete that Wednesday at some kind of reasonable hour in the evening. Thursday, we will begin the markup. I intend to hold it over and bring the committee back on the 22nd to vote on the nomination. So if I may, I'll start off with an opening statement and say, why are we here? Number one, Justice Ruth Bader Ginsburg died on September the 18th. What can you say about Justice Ginsburg? She was confirmed 96-3. Now, those were days that have since passed. I regret that. 96-3. Now, this was a person who worked for the ACLU, someone who was known in progressive circles as an icon. Apparently, just about every Republican voted for her. Her good friend on the court, Justice Scalia, I think got 97 votes. I don't know what happened between then and now. I guess we can all take some blame, but I just want to remind everybody there was a time in this country where someone like Ruth Bader Ginsburg was seen by almost everybody as qualified for the position of being on the Supreme Court, understanding that she would have a different philosophy than many of the Republicans who voted for her. 27 years on the court. Before becoming a member of the court, she was an active litigator, pushing for more equal justice and better rights for women throughout the country. Her close friend, until his death, Justice Scalia called her the leading and very successful litigator on behalf of women's rights, the Thurgood Marshall of that cause. What high praise. I can't say any more than that statement says. In my view, the person appearing before this committee is in a category of excellence, something the country should be proud of, and she will have a chance to make her case to be a worthy successor and to become the 9th member of the Supreme Court of the United States. On September the 26th, Judge Amy Barrett was nominated by President Trump to the Supreme Court. Who is she? She is a judge sitting on the 7th Judicial Circuit. She's highly respected. She was a professor at Notre Dame. 3 years during that tenure, she was chosen by the students to being the best professor, which I'm sure is no easy task at any college. She's widely admired for her integrity. She grew up in New Orleans, graduated from Rhodes College in Memphis, Tennessee in 1994, graduated summa cum laude and first in her class from Notre Dame Law School in 1997. So academically, she's very gifted. She clerked for Judge Lawrence Silberman on the U.S. Court of Appeals for the D.C. Circuit, and then for Justice Scalia on the Supreme Court. She practiced law in Washington, D.C. She joined the faculty at Notre Dame in 2002. She's published numerous articles in prestigious journals, including the Columbia, University of Virginia, and Cornell Law Review. She's been a circuit court judge at the 7th Circuit since 2017. She was confirmed to that position with a bipartisan vote. She has heard hundreds of cases in that capacity. She said, "I clerked for Justice Scalia more than 20 years ago, but the lessons I learned still resonate. His judicial philosophy is mine. A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold." She will give her statement but I think that is a good summary of who she is. That's who Amy Barrett is in terms of the law. In terms of Amy Barrett, the individual, she and her husband have 7 children, 2 adopted. So 9 seems to be a good number. The process. This is an election year. We're confirming the judge in an election year after the voting has occurred. What will happen is that my Democratic colleagues will say, this has never been done, and they're right in this regard. Nobody's, I think, has ever been confirmed in an election year past July. The bottom line is Justice Ginsburg, when asked about this several years ago, said that a president serves for 4 years, not 3. There's nothing unconstitutional about this process. This is a vacancy that's occurred through a tragic loss of a great woman, and we're going to fill that vacancy with another great woman. The bottom line here is that the Senate is doing its duty constitutionally. As to Judge Garland, the opening that occurred with the passing of Justice Scalia was in the early part of an election year. The primary process had just started. And we can talk about history, but here's the history as I understand it. There's never been a situation where you had a president of one party and the Senate of another, where the nominee, the replacement was made in an election year. It's been over 140 years ago. I think there have been 19 vacancies filled in an election year. 17 of the 19 were confirmed to the court when the party of the president and the Senate were the same. In terms of timing, the hearing is starting 16 days after nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. Stevens 10, Rehnquist 13, Powell 13, Blackmun 15, Berger 13. All I can say is that I feel that we're doing this constitutionally, that our Democratic friends object to the process. I respect them all. They'll have a chance to have their say. But most importantly, I hope we will know more about how the law works, checks and balances, what the Supreme Court is all about when this hearing is over. Why hold this hearing? A lot of people on our side say just ram it through. I hear that a lot. That's why I don't listen to the radio much anymore. So the bottom line is I think it's important. This is a lifetime appointment. I would like the world and the country to know more about Judge Barrett. I'm proud of you. I'm proud of what you've accomplished. I think you're a great choice by the president. This is probably not about persuading each other unless something really dramatic happens. All Republicans will vote yes and all Democrats will vote no. And that will be the way the breakout of the vote. But the hearing is a chance for Democrats to dig deep into her philosophy, appropriately ask her about the law, how she would be different, what's on her mind. It gives Republicans a chance to do the same thing. Most importantly, it gives you a chance, the American people, to find out about Judge Barrett. Judge for yourself. Is this person qualified? Is she as qualified as Sotomayor and Kagan? I think so. These were 2 nominees presented to the committee by President Obama. They had a different legal philosophy than my own, but I never doubted one moment that they were not qualified. I thought Gorsuch and Kavanaugh were qualified. The Senate in the past has looked at qualifications more than anything else. We've taken a different path at times. Bork, Thomas, Alito, Kavanaugh. I hope we don't take that path with Judge Barrett. She doesn't deserve that. I don't think it makes this hearing any better. And the American people, I believe, would not deserve a repeat of those episodes in the Senate Judiciary Committee's history. To my Democratic colleagues, I respect you all. We've done some things together, and we've had some fights in this committee. I've tried to give you the time you need to make your case, and you have every right in the world to make your case. I think I know how the vote's going to come out, but I think Judge Barrett is required for the good of the nation to submit to your questions and ours. This is going to be a long, contentious week. I would just ask one thing of the committee. To the extent possible, let's make it respectful. Let's make it challenging. Let's remember the world is watching. Senator Feinstein.
Thanks very much, Mr. Chairman. And I do want to just address your last statements. We feel the same way, and I believe we want this to be a very good hearing, and I certainly will strive to do my best to achieve that. Good morning, Judge Barrett, and welcome to you and your family. Less than 1 month ago, the nation lost one of our leading voices for equality. Ruth Bader Ginsburg left very big shoes to fill. Judge Ginsburg loved the law, and she loved this country. She worked all of her life to ensure that the opening words of our Constitution, "We the people of the United States, in order to form a more perfect union," included all the people, not just a few, elite few. She was a standard bearer for justice. Justice Ginsburg's nomination was the first one that I participated in when I came to the Senate, and it was a real thrill to be part of that crowded and celebratory hearing for someone who had broken down barriers and reopened doors and staunchly believed in a woman's right to full equality and autonomy. In filling Judge Ginsburg's seat, the stakes are extraordinarily high for the American people, both in the short term and for decades to come. Most importantly, health care coverage for millions of Americans is at stake with this nomination. So over the course of these hearings, my colleagues and I will focus on that subject. We will examine the consequences if, and that's a big if, Republicans succeed in rushing this nomination through the Senate before the next president takes office. But most importantly, in just a few weeks, on November 10th, the Supreme Court will hear hearings in Texas v. California, a case brought to strike down the ACA. The president has promised to appoint justices who will vote to dismantle that law. As a candidate, he criticized the Supreme Court for upholding the law and said, and I quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare," end quote. And when he appointed Judge Barrett to fill Justice Ginsburg's seat, the president said that eliminating the Affordable Care Act would be, quote, "a big win for the USA." Judge Barrett, you've been critical of Chief Justice Roberts for his 5-4 opinion upholding the law, stating that Roberts, quote, "pushed the Affordable Care Act beyond its plausible meaning to save the statute," end quote. This well could mean that if Judge Barrett is confirmed, Americans stand to lose the benefits that the ACA provides. So I hope you will clarify that in this hearing. First, more than 130 million Americans with pre-existing conditions like cancer, asthma, or even COVID-19 could be denied coverage or charged more to obtain health insurance. This includes more than 16.8 million Californians with pre-existing conditions. And we are just one state, but I think you should know how we feel. Secondly, some 12 million working Americans are covered through the ACA's Medicaid expansion. If the act is struck down, they lose their health care. Third, More than 2 million Americans under the age of 26 are covered by their parents' health insurance, and they could lose that coverage. Fourth, insurers could charge higher premiums for women simply because of their gender. And fifth, women could lose access to critical preventive services and maternity care, including cancer screenings and well-woman visits. Now, the bottom line is this. There have been 70 attempts to repeal the ACA, but clearly the effort to dismantle the law continues, and they are asking the Supreme Court to strike down the Affordable Care Act. This, I believe, will cause tremendous harm. Consider people like Christina Monroe Garcia of my home state. At age 60, Christina's eyesight started to fail because of cataracts. She had always struggled to obtain insurance because of pre-existing conditions, including C-sections and epilepsy. The cost of coverage, when it was even offered to her, averaged between $2,500 and $3,000 a month, far more than she and her husband could afford. In 2010, she was able to obtain coverage through the Affordable Care Act. Within weeks, she was able to have cataract surgery. This saved her life. Christina described her reaction when she was able to get coverage through the California Health Exchange following passage of the ACA. And let me quote, "It was like manna from heaven. I cried. After all these years of struggling to obtain coverage, I was able to get insurance through the California Exchange, no questions asked about my pre-existing conditions. The premium was worth $200 a month as compared to the $2,500 to $3,000 monthly payments I would have to pay before the ACA if I could even get an insurer to offer me coverage." As Christina further explained, and I quote, "People just don't understand what it was like, the incredible fear before the Affordable Care Act, having to worry about being able to cover medical expenses and not being able to find affordable insurance," end quote. We can't afford to go back to those days when Americans could be denied coverage or charged exorbitant amounts. That's what's at stake for many of us, for America, with this nomination. And that's why the questions we will ask and the views, hopefully, that you will share with us are so important. We are now just 22 days from the election, Mr. Chairman. Voting is underway in 40 states. Senate Republicans are pressing forward, full speed ahead, to consolidate a court that will carry their policies forward with, I hope, some review for the will of the American people. President Trump said last week that he had, quote, "instructed my representatives to stop negotiation over a COVID-19 relief package until after the election," end quote, and to, quote, "focus full-time on confirming Judge Barrett to the Supreme Court." When Justice Scalia died in February of 2016, Senate Republicans refused to consider a replacement for his seat until after the election. At the time, Senator McConnell said the American people should have a voice in the selection of their next Supreme Court justice. When asked in October 2018 if Republicans intended to honor their own rule if an opening were to come up in 2020, Chairman Graham promised, quote, "If an opening comes in the last year of President Trump's term and the primary process has started, we'll wait till after the next election." Republicans should honor this word for their promise and let the American people be heard. Simply put, I believe we should not be moving forward on this nomination, not until the election has ended and the next president has taken office. Thank you, Mr. Chairman.
Thank you very much, Senator Feinstein. Senator Grassley.
Welcome, Judge. On March 1, 2016, Justice Ginsburg delivered a eulogy for her friend, Justice Scalia. Justice Ginsburg said, quote, "We were different, yes, in our interpretation of written text, yet one in our reverence for the courts and its place in the U.S. system of governance," end of quote. Justice Ginsburg's remarkable life and legacy will be honored for a generation, and also Justice Scalia's. The Senate is now tasked with carrying out perhaps its most solemn duty under the Constitution. As we go through this process, we should heed Justice Ginsburg's words with a shared reverence for the court and its place in our constitutional system. This idea of place in our system of government is critical. Ours is a government of separated powers. The power to make, enforce, and interpret law isn't centralized in one person or one branch of government. That's not a mistake. You all know what our American Revolution was all about and what the Constitution is all about, because people at that time were sick and tired of one person, George III, restricting American colonies of freedom that English-speaking people elsewhere exercised. As Justice Scalia reminds us, the framers recognized the separation of powers as, quote, "the absolutely central guarantee of a just government, because without a secure structure of separated powers, our Bill of Rights would be worthless," end of quote. But this constitutional system only succeeds if each branch respects its proper role. A good judge understands it's not the court's place to rewrite the law as it sees fit. It's not his or her place to let policy, personal, or moral principles dictate an outcome of a case. We are fortunate. Judge Barrett's record clearly reflects this standard. She said, quote, "A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views that they might hold," end of quote. Judge Barrett's service reflects an exceptional intellect paired with deep commitment to the rule of law. So we look to those who know her well. She's received praise across the legal profession and ideological spectrum. Former colleagues at Notre Dame described the judge as, quote, "brilliant, industrious, gracious, and kind, and as a person of utmost integrity with an open mind and an even temperament that is prized in a judge," end of quote. She's also known as, quote, "a generous mentor." And she's known for her, quote, her humility, graciousness, and her ability, born of her credibility, to build consensus among differing views, end of quote. Her students, quote, "expressed awe with the power of Judge Barrett's intellect, with her mastery and organization of complex material, and with her professionalism," end of quote. Leaders of more than 200 liberty-supporting groups across the country say Judge Barrett, quote, "possesses the judicial temperament and philosophy necessary as a bulwark for our Constitution and institutions of government," end of quote. 24 state governors described Judge Barrett as, quote, a woman of great moral character who is devoted to her country, community, family, and faith like many Americans, end of quote. The Wall Street Journal editorial board says, quote, President Trump's nomination of Amy Coney Barrett for the Supreme Court is the highlight of his presidency, end of quote. A promise kept, a promise made, a promise kept. Liberal Harvard law professor Noah Feldman called Judge Barrett, quote, a principled, brilliant lawyer, a genuine and good person, highly qualified to serve on the Supreme Court. That's a pretty high praise. I just recited from others. Moreover, Judge Barrett is a tireless mother of 7. For decades, I've led efforts in the Senate to improve foster care and promote adoption. So it's a privilege for me to welcome a justice like that to the Supreme Court. To sum up, Judge Barrett's qualifications and character are impeccable. Unfortunately, I expect the minority will try to rustle up baseless claims and scare tactics as they've done for decades. Anything to derail the confirmation of a Republican nominee. Lately, the left is threatening to pack the Supreme Court in retaliation for this confirmation process. Even the Democrats' nominee for president and vice president have not ruled out such blatantly partisan policy grabs. Republicans are following the Constitution and the precedent. It seems Democrats would rather just ignore both. The left is also suggesting Judge Barrett's confirmation would be the demise of the Affordable Care Act and the protection for pre-existing conditions. That's outrageous. As a mother of 7, Judge Barrett clearly understands the importance of health care. So let's set the record straight. Then Professor Barrett criticized Chief Justice Roberts' conclusion that the Affordable Care Act penalty was actually a tax. Democrats say her viewpoint is radical and a preview of how she might vote on the court. First, her comments dealt with a provisional law that's no longer in effect. So the legal questions before the court this fall are entirely separate. Moreover, her criticism of Roberts' reasoning is mainstream, not only in the conservative legal community, but well beyond. I'm the chairman of the Finance Committee and was ranking member when Democrats unilaterally cobbled together Obamacare. I know a tax when I see one. This wasn't a tax. It was never discussed in committee as a tax. Even the Democrats who forced it through Congress insisted it wasn't a tax. Jeffrey Toobin wrote that Roberts' tax argument was, quote unquote, not a persuasive one. President Obama even said, quote, I absolutely reject the notion that it was a tax. Further, Democrats and their allies shouldn't claim to know how any judge would rule in any particular case. Just look at history. The left slammed Stevens for his consistent opposition to women's rights. They called Anthony Kennedy sexist and a disaster for women. They said David Souter would, quote, end freedom of women in this country. Ultimately, the left praised these very justices that they attacked. Their doomsday prediction failed to pan out. Democrats and their leftist allies have also shown that there is no low that they won't stoop to in their crusade to tarnish a nominee. And I saw it all as chairman of this committee when Kavanaugh came up. Some of my colleagues may once again try to misrepresent and outright disparage Judge Barrett's religious beliefs and affiliations. In 2017, they suggested Judge Barrett was too faithful or too Catholic to be a judge. One senator asked whether she considered herself an Orthodox Catholic. Another told her, the dogma lives loudly within you, and that is of concern. Let me remind everyone that Article 1 clearly prohibits religious tests for serving in public office. Mr. Chairman, I got 5 sentences left. Judge, you'll no doubt be asked how you'll rule on questions and issues and whether the case was correctly decided. I expect that you'll follow the example of Justice Ginsburg. A nominee should offer no forecasts, no hints of how he or she'll vote, because that's the role of a judge. That's the place of a judge in our system of government. Unbiased, fiercely independent, faithful to the rule of law, and a steadfast defender of the Constitution. Judge Barrett, I look forward to our conversation. Once again, congratulations.
Thanks, Senator Grassley. I believe Senator Leahy will now join us virtually.
Thank you. And I am here. I assume you can hear me all right?
Yes, sir. And we see you. There you are. Thank you.
Thank you. You know, as I listen to this, I think about the fact that I've served in the Senate for 46 years. During that time, we had 20 Supreme Court nominations, 16 confirmation hearings. And I can tell you right now, none looked anything like this. We're less than 2 weeks from Justice Ginsburg being laid to rest. Now, it's true, it's the responsibility of this committee to consider her replacement on the Supreme Court, but this isn't the way we should do it. We should not have had a nomination ceremony before Justice Ginsburg was even buried, while the nation was mourning her passing. We should not be holding a hearing just 16 days later when this committee has afforded itself 3 times as long to vet other modern nominees to our nation's highest court. We shouldn't be holding a hearing 3 weeks from a presidential election when millions of Americans have already voted. Now, when doing so requires that literally half of the Senate goes back on their word. Think of that, my Republican colleagues. Literally half of the Senate had to break their word, contradicting every argument they made 4 years ago about the American people needing a voice during election year vacancies. We should not be holding this hearing when it's plainly unsafe to do so. 2 members of this committee are just now emerging from quarantine after testing positive for COVID. And when other members have declined to get tested, and the chairman has refused to implement a daily testing regime to keep members and staff and Judge Barrett and her family safe. And I might say we shouldn't be spending time on this when we're doing absolutely nothing to pass a much-needed COVID bill. Every senator on this committee knows in their heart this total break with precedent, break with their commitments is wrong. More than 212,000 Americans have died due to COVID. Millions more are hurting. The virus is spiking again across the country. But Senate Republicans have nothing to say about that. The Senate is wearing blinders to the grim realities facing Americans. Instead of talking about COVID and doing something to help the American people, we're engaged in this mad rush to fill a Supreme Court vacancy on the eve of a presidential election. And why? I think the answer is painfully clear. With this vacancy, President Trump and Senate Republicans see the potential to wildly swing the balance of the court. They see the ability to take the courts from being independent to making them instead an arm of the far right in the Republican Party. The potential to accomplish through the courts what they failed to accomplish by votes in the halls of Congress. And the top of their hit list is the Affordable Care Act. It's no secret, it's no coincidence that Republicans are rushing to confirm Judge Barrett before the Supreme Court considers the latest Republican-led lawsuit to overturn the Affordable Care Act on November 10th. The president has even promised that any judge he nominates will overturn the Affordable Care Act. One member of this committee has promised he won't vote for a judge unless he has that commitment that the nominee will overturn the act. And for her part, Judge Barrett's writings have made it unequivocally clear she considers the act unconstitutional. In fact, overturning the Affordable Care Act has been perhaps the single most important policy objective of the Republican Party during the past decade. And if Republicans are now successful, the results will be nothing short of catastrophic for the millions of Americans who depend upon its coverage and projections. These are real people. You may, I believe you have in the committee, and I'm trying to get this so you can actually see it. This is Mary Naden Scott. She lives in Northfield, Vermont. That's just over the ridge from my home in Middlesex, Vermont. In her 20s, Mary was diagnosed with Friedreich's ataxia, a rare neurological disease. Like my wife, Marcelle, and I apologize for, I know you have this picture in the committee room. Mary worked as a nurse, realizing she would soon no longer be able to pursue the career she loved. She asked the hospital to rotate her through different specialties so she could help more people in as many ways as possible. That's who she is. And now she's in a wheelchair. She can no longer practice nursing. She does everything she can to take care of her two children. I actually had the pleasure of calling one of her sons on his birthday last spring. And Mary, I know, attends their soccer games. She helps with their remote school. She even brought them to tour the Vermont State House. Now, Mary can do this because her medication and in-home care is paid for by her insurance. But she's worried. Even with some state protections, she's worried what the Supreme Court case next month will mean for people with pre-existing conditions like her. For Mary, if she lost her insurance, her biggest worry is she'd lose her in-home support that allows her to continue living at home and taking care of her children. Now, she's a fighter. And when I think of what the Affordable Care Act means to millions of Americans, what's on the line with this nomination? I think of Mary. I think of what she's going to lose. And she's not the only one. You know, I talk to Vermonters all the time. Now think of another one, Martha Richards. She is an amazing, amazing woman. She's another Vermonter who reached out to my office concerned about the fate of the Medicaid expansion under the Affordable Care Act. Martha earns just over the minimum wage in Vermont. She works for the Vermont State Parks, and she's raised 2 kids on her own. Just look at this person. Soon after enrolling now in the expanded Medicaid program, she began experiencing debilitating pain in her ear behind her eye. It led to a series of expensive medical tests, including 2 MRIs. It would cost $6,000 each. She shudders. The thought what would have happened without the Medicaid expansion. If it's discarded now, as Republican attorneys general have requested a case before the Supreme Court, millions of Americans like Martha would be on their own. Now, I do not suggest that Judge Barrett personally desires these consequences or personally desires to devastate the lives of these 2 Vermonters. Far from it. But these are nonetheless the consequences if her stated views on the law prevail in the Supreme Court, and if Republicans are successful in filling this vacancy prior to November 10th. Well, then we know these views will almost certainly prevail. So that's what's at stake here. That's what weighs heavily on me as we begin these hearings. It also weighs heavily on the minds of the Vermonters I represent. And I've heard from them often and loudly. since Justice Ginsburg's passing. They're scared, Judge Barrett. They're scared that your confirmation would rip from them the very health care protections the millions of Americans have fought to maintain, and which Congress has repeatedly rejected eliminating. They're scared that the clock will be turned back to a time when women had no right to control their own bodies and when it was acceptable to discriminate against women in the workplace. They're scared that at a time when we are facing the perilous impacts of climate change, bedrock environmental protections are going to be eviscerated. And they're scared that your confirmation would result in the rolling back of voting rights, workers' rights, and the rights of the LGBTQ community to equal treatment. These aren't just thoughts. These are real-life implications of decisions made by the court. And a majority of Americans, like an overwhelming majority of my fellow Vermonters, don't support taking our country in that direction. Our Republicans first announced their intention to fill Justice Ginsburg's seat just 1 hour after her death. From that moment, this process has been nothing but shameful. Worse, it will almost certainly lead to disastrous consequences for Americans. Justice Ginsburg, I am certain, would have dissented, and I will too, on behalf of Vermonters, on behalf of the integrity of the Senate, and on behalf of the majority of Americans who oppose this process. Thank you.
Thank you, Senator Leahy. Senator Cornyn.
Thank you, Mr. Chairman. Judge Barrett,
we've been watching
you
as the confirmation hearing for Amy Coney Barrett to the United States Supreme Court gets underway. This morning, we've heard from the chairman of the committee, Republican Lindsey Graham, and the ranking member, Democrat Dianne Feinstein, as well as two of the more senior members, Republican and Democrat. And these opening statements from the senators will continue. Bit of housekeeping. Chairman Graham said that he expects to be able to hold a vote in committee on this nomination on October 22nd, which would clear the way for a final vote on her confirmation to the court before Election Day. And as I bring in Pete Williams, our justice correspondent who covers the court for us, we've already seen the outlines of where these fights are going to be over the next few days, Pete, having to do with the legitimacy of this process at all. And you know where Democrats want to take this on the issue of health care. And we've already seen those battle lines being drawn this morning.
Right. I think the hearing is going to be as much about President Trump and his nomination and the process as it is going to be about Amy Coney Barrett, because there doesn't seem to be much doubt that she is qualified in the sense that she has the credentials and the intelligence and the skill to do the job. Savannah, on the Affordable Care Act, it is true that in 2012, Amy Coney Barrett was strongly critical of the Supreme Court's first ruling that upheld Obamacare. The question was whether the individual mandate requiring every American to buy insurance was unconstitutional. How can Congress require everybody to buy something from a private business, went the argument. And the Supreme Court, led by Chief Justice Roberts, writing the majority opinion, said, well, it is a legitimate use of Congress's taxing authority, because if you don't buy insurance, you have to pay a penalty on your income tax. In the intervening years, the Republican-led Congress did away with the tax. So now what the states attacking Obamacare say is, well, you can't say it's a use of Congress's taxing authority because it isn't a tax anymore. So that's going to be a big question before the Supreme Court. And Amy Coney Barrett may well, if she sticks to her guns in the 2012 vote, say, yes, the individual mandate is unconstitutional. But that's not the end of it, because I think the big question in the case the Supreme Court will hear the week after the election is, well, what if that is true? Can the rest of the law be saved? And I don't know how she would vote on that.
Well, there's a case that has dramatic legal and real-life consequences and political consequences, as well, as we are in the middle of election day upon us, but of course early voting already underway. Pete, I know you'll keep your eye on this hearing, as will we. A little bit later, Amy Coney Barrett herself will be introduced and give an opening statement to the committee. NBC News will bring it to you live. For most of you, you'll return today. You can continue watching coverage on NBC News Now. I'm Savannah Guthrie in New York.
Discussions with my constituents that's really more basic and more personal. They want to know how you do it. How do you and your husband manage 2 full-time professional careers and at the same time take care of your large family? I'll bet there are many young women, like my own 2 daughters, who marvel at the balance that you've achieved between your personal and professional life. As is customary and important, I also look forward to revisiting the appropriate role of judges in our constitutional republic, something that you can see there appears to be some dispute about here. You and I both know that judges should not be policymakers. But could it be that one of the reasons these confirmation hearings have become so contentious is because some Americans have given up on the idea of fair and impartial judges who do not pick winners and losers, that they've given up on an independent judiciary? I hope not. Judges should not be unelected super legislators, giving their political allies wins they could not secure through the rough and tumble of the political process. Our founders, through the Constitution, provided that judges would be independent of political pressure. Chief Justice Roberts reminded all of us recently that we do not have Obama judges or Trump judges, Bush judges, or Clinton judges. And ideally, that is true. You've said judges constrain themselves by making a choice to follow the law where it leads, trying to check their own preferences at every turn. In the end, a judge's internal compass, her commitment to the rule of law, rather, is the most important constraint upon any sort of judicial willfulness. But you're being asked to abandon that, Judge. You stand accused of intending to violate your oath before you even take it. Further, our Democratic colleagues want you to guarantee a result in a case as a quid pro quo for your confirmation. It's outrageous. Well, they've said that if this confirmation proceeds, they intend to pack the court with more justices who will turn the Supreme Court into a genuine second legislative body. We heard what Justice Ginsburg had to say about that. That would be a terrible mistake. Judge Barrett, I'm confident that at the end of this hearing, your stellar character, credentials, and body of work as a judge will demonstrate that you understand the limited but important role of the judiciary under our Constitution. I'm confident that you will demonstrate that you will faithfully and fairly interpret the text of the law and the Constitution and dutifully apply them to the disputes that come before you. And I'm confident that at the end of this process, you will be confirmed to the United States Supreme Court.
Senator Durbin.
Thank you, Mr. Chairman. Judge Barrett, your family, welcome. We're at a critical moment in our nation's history, in the throes of a devastating pandemic, with over 216,000 Americans dead and over 7.7 million infected with this virus. Each day, we are reminded of how this invisible virus has changed our lives and changed America. And there is no end in sight. We face an economy in crisis with millions of jobs lost and crushing challenges facing workers, businesses, families all across America. And we're in the middle of an election season. Millions of Americans have already cast their votes. And this may be one of the most consequential elections in our nation's history. Because for the first time in the history of the United States, an incumbent president refuses to commit to a peaceful transition of power if he loses the election. This president, in his vanity and constitutional recklessness, refuses to commit to accept the will of the American electorate. And of course, we're still in the process of mourning the loss of an historic champion of justice and equality, Ruth Bader Ginsburg. Justice Ginsburg spent her entire life and every ounce of strength and talent she was given in the pursuit of America's highest ideal, equal justice under the law. Her absence is deeply felt. Now, this is the context in which the Senate majority Republicans are defying the traditions of the Senate and rushing forward with President Trump's third nomination to the U.S. Supreme Court. It has been recounted earlier that Justice Ginsburg was approved by the Senate by a 96-3 vote. This icon of liberal thinking, advocate for the ACLU, 96-3 before the United States Senate, and then Anton Scalia, on the opposite polar end of the political spectrum, approved 98-0. Amazing. Can this be the same Senate? It's not. The reason those votes were so overwhelming was because people lived by the rules, they lived by the traditions of the Senate, and they had mutual respect for one another. We know now that this process does not adhere to those guidelines. The haste in this pursuit that before us today is unfair to the Senate and unfair really to the nominee. The nominee before us was announced 16 days ago, the day after Justice Ginsburg lay in state in the United States Capitol. We received the nomination paperwork 13 days ago and have learned since then that some materials are missing. The speed with which Republicans are moving to fill this vacancy stands in sharp contrast to the approach taken by the same Senate Republicans the last time there was a vacancy in an election year in 2016. Behind me is the McConnell Rule. On February 13th, 2016, when Justice Scalia passed away, Senator McConnell said, and I quote, "The American people should have a voice in the selection of their Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president." This rock-solid statement of principle was made 269 days before the 2016 election. The Republican members of this committee fell obediently in line behind Senator McConnell's statement of principle. They even sent a letter on February 23rd, 2016, and I quote, "This committee will not hold hearings on any Supreme Court nominee until after our next president is sworn in." The letter noted that, quote, "The election is well underway," that was 269 days before the election, and said the decision was, quote, "born of a necessity to protect the will of the American people." Yet when Justice Ginsburg passed away on September 18th this year, Senator McConnell said that very same night, and I quote, "President Trump's nominee will receive a vote on the floor of the United States Senate." He made this statement a mere 46 days before the election. People had already begun casting votes, and my Republican colleagues marched in front of the cameras, looked down at their shoes, dutifully reversed their positions, and lined up obediently behind their leader again. It gets down to this. Either the American people do get an election year voice regarding a vacancy on the Supreme Court, or they don't. In 2016, Senator McConnell said, "Give them a voice." Now he says, "Don't give them a voice." It is a shameless, self-serving, venal reversal. Why are Senate Republicans so afraid to give the American people a voice about the future of the Supreme Court? First, they must doubt that Donald Trump will be reelected. Second, they want a 6-3 Supreme Court to carry out a Republican agenda that's really not very popular with the American people. And there are two dates on the calendar which explain their timetable, November 3rd and November 10th. We know November 3rd is Election Day. President Trump has made it clear he wants another of his appointees on the Supreme Court before the election because he anticipates court challenges over the vote, especially over mail-in balloting, which he has repeatedly attacked without any substance. President Trump has indicated he'd be perfectly happy to have a close election decided by a 6-3 conservative majority Supreme Court rather than by the votes of the American people. The other date, of course, is November 10th. We know that date well on this committee. That's the date the Supreme Court will hear oral arguments in California versus Texas. This is the case in which the Trump administration is urging the court to strike down the entire Affordable Care Act, including protections for tens of millions of Americans with pre-existing conditions. It's unimaginable that in the midst of a pandemic, the Republicans want to strike down a law that 23 million Americans rely on for their personal health insurance and millions more for the protections given to the writing of future insurance policies. On September 27th, President Trump tweeted he wants to see the Affordable Care Act, quote, terminated in the Supreme Court. Let's be very honest about this. This president has never suffered an unuttered thought. He gives us 25 tweets a day to tell us what's going through that fertile mind. We know what he thinks because he tells us what he thinks. And he made it clear that he wants his Supreme Court and this nominee to join him in eliminating the Affordable Care Act. This is his litmus test. How many times have we heard it? How many times have we heard his criticism of Chief Justice Roberts for failing to strike down Obamacare? When he was running for president, then candidate Trump tweeted, quote, if I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee John Roberts on Obamacare. Think it would mean what it mean if the Republicans wished to strike this down. All the people who would lose their coverage, which we have heard recounted repeatedly this morning and will hear even more. Republicans in Congress have been obsessed with repealing Obamacare for years, but they don't have the votes to do it. They couldn't get it done in the House. They couldn't get it done in the Senate, thanks to 3 brave Republicans, including John McCain. And now they've got to rely on the court to do their work. Judge Barrett, you're on the record. You wrote an article in which you criticized the NFIB versus Sebelius case, where Chief Justice Roberts was the deciding vote upholding the ACA. Now your nomination is moving forward at unprecedented speed. So what's at stake? Let me show you what's at stake here. I want you to meet Kenny Murray from Tinley Park, Illinois, and his family. Last year, I had a privilege of meeting the family in my Washington office. Here's a picture of Sue, Ken, their daughter Maddie, and their son Kenny. Sue and Kenny Murray told me that their son Kenny was diagnosed in utero with multiple complex congenital heart defects. Before his first birthday, Kennedy had 2 open heart surgeries at Advocate Children's Hospital outside of Chicago. He had surgery for the 3rd time at 14 months of age. 4 months in his young life, he was staying in the pediatric ICU, and his health bills had reached $1 million. When Kenny was born in November 2013, his dad's health insurance through his employer had a lifetime maximum cap of $1 million. Thankfully, the Affordable Care Act banned insurance companies from imposing these annual lifetime limits, including on employer-sponsored health insurance. That ban went into place in January 2014, 6 days before Kenny's first surgery. If it weren't for the ACA, Sue and Ken would have hit the lifetime limit for Kenny in just 4 months. They told me they would have gone bankrupt. Thanks to the Affordable Care Act, Kenny was able to get the care he needed. This last picture I want to show you, well, here it is. Wouldn't you want him on your team? I sure would. When she gave permission for me to share Kenny's story today, his mom, Sue, said, quote, Kenny is a real person whose life depends on the Affordable Care Act. Judge Barrett, your nomination for a lifetime appointment to the highest court in the land comes before us under a cloud. You have been nominated by a president who shows contempt for the Constitution, but does not hesitate to tell his loyal followers that you are being sent to the bench to do his political chores. Abolish the ACA, rule in his favor on any election contest, and even more. You cannot feel good about a president cheapening this historic moment. The future of the Affordable Care Act and so many other issues hang in the balance. Voting rights, civil rights, the right to privacy and choice, environmental protection, gun safety laws, marriage equality, dreamers, work protection. These are the stakes. If we wait just a few more days, we'll know what the American people have to say.
Thanks, Senator Durbin. Senator Lee, welcome back.
Thank you, Mr. Chairman. Welcome, Judge Barrett, and welcome to your family as well. Judge Barrett, you and I have a number of things in common. We're both raised in large families. In fact, we're both one of 7 children. In your case, as I recall, you're the oldest of 7 children, which means that long before you had your own 7 children, you were also the de facto mother to many others. The way things often work in large families is such that the oldest child very often takes on responsibilities at an early age. Those responsibilities have undoubtedly helped you throughout life, establishing leadership roles in your career as a lawyer, as a professor, and now as a judge. Those leadership roles, of course, mean something different in the judicial branch of government than they do in the executive branch or in the legislative branch of government. We've heard this morning a number of arguments that are essentially policy arguments, many of them geared toward actual policies, in some cases, actual pieces of legislation. We have to remember that we've got three distinct branches of government within our system. We've got two that are political, the legislative branch, where we work, where we make laws, the executive branch, headed by the president, where the laws are executed, implemented, and enforced, and of course, the judicial branch, where you work, where the laws are interpreted, where people come to disagreement as to their meaning. The branches are sometimes referred to as equal. I don't think this is the best description of them. I think the best description of them is that they are coordinate branches of government, meaning they each exist within their own sphere. They're not equal in the sense that the least dangerous branch was, is, always has been, and always will be the judicial branch, for the simple reason you can't reach out. You can't decide where we're going to go today or tomorrow. The judiciary is confined solely to those cases and controversies brought before your jurisdiction. You look not into the future, but in the past. You see the world, as it were, through a rear-view mirror. Your job is to decide what the law says when people disagree as to the law's meaning. Those laws consist of words. Those words used in a particular combination, in a particular context, had a particular meaning on the day of their enactment or their incorporation into the Constitution, and that's your job. And yet, if you were watching today's hearing, and some of the statements made by some of my colleagues, in fact, if you were to look at any of the countless posters put up in here, you'd think that this was a political discussion, a policy discussion, a legislative discussion. You, in fact, are not being reviewed for a legislative position or a policy-making position. You're being reviewed for a position on our nation's highest court, where you'll be asked from time to time to decide cases based on the law, based on the facts. This is not something that should result or properly should be considered by us as something that requires us to examine whether, to what extent, in what way you have compassion for any of the individuals depicted in these photos. I'm certain, just based on my limited interaction with you, that you have compassion for all people. But this isn't the question, nor is the question before us whether you would agree or disagree as to any particular policy embedded within any particular statute. You understand that this isn't your job, not as a judge on the U.S. Court of Appeals for the Seventh Circuit, where you now sit, nor would it be if you were to be confirmed as an associate justice to the United States Supreme Court. One might also have the impression, from watching this morning's proceedings so far, that the Supreme Court of the United States is a remarkably bitter, cynical, and overwhelmingly partisan place. It is not. You and I have both clerked at the U.S. Supreme Court, and we both know that you actually look at the numbers, you'll see something remarkable. Despite its flaws, and despite the fact that it sometimes makes mistakes, the Supreme Court of the United States sits atop something that is the envy of the entire world. A judicial system that, despite the fact that it's run by human beings and therefore is imperfect, is the best judicial system that has ever existed on planet Earth. One of the many ways in which this is manifested is when you look at the 9 members of the Supreme Court and the fact that they come from different backgrounds. They've been appointed by different presidents. They've come at it with somewhat different judicial philosophies, to the extent that some of them have indicated what their political leanings might be. They indicate that they come from different political backgrounds as well. And yet, the most common configuration of a Supreme Court decision is not 5-4. It's not even 6-3. It's, in fact, 9-0, 8-1, and 7-2 make up the vast, overwhelming majority of all Supreme Court decisions. Now, this is especially remarkable when you consider the fact that the Supreme Court typically takes up only those cases, those rare cases, as to which lower courts have been unable to reach an agreement when interpreting the same finite provisions of federal law, a federal statute, or a provision of the United States Constitution. Multiple lower courts, very smart men and women from around the country, highly specialized, skilled in their trade, have been unable to reach the same conclusion as to the meaning of the same group of words. Then and only then does the Supreme Court tend to take up those cases. And yet, the Supreme Court overwhelmingly decides those cases either unanimously or near unanimously. And without these partisan divisions that one from watching this hearing would think is the bread and butter of the Supreme Court's work. The 5-4 configuration is actually relatively rare. When it does arise, it's not even always involving a hot-button political issue. Most of the Supreme Court's docket doesn't even consist of the hot-button issues. A whole lot of it consists of stuff that I find really, really fascinating, like the Dormant Commerce Clause. I mean, what American doesn't sit up late at night and stew over whether it's okay for a state or a political subdivision thereof to treat an article of commerce differently based on its origin or destination out of state or outside the United States? This, of course, is the kind of case that comes before the Supreme Court and might from time to time be decided on a 5-4 basis, but not necessarily along the lines that one would predict based on the appointment of each justice and the political party of each justice's appointing president. There are, of course, some decisions that are politically charged and that Americans do worry about more than others, that might affect more Americans, let's say, than a decision about waste disposal in the context of the Dormant Commerce Clause. I understand that. I get that. But there, too, we can't overstate or overplay the role the Supreme Court of the United States might exert in that context. Even in those circumstances, when the Supreme Court rules that something has been done in a way that's not constitutional, it doesn't mean that that's the end of the policy road there. Sometimes it might mean the wrong government acted. Sometimes it might mean that the federal government acted where a state should have, or the other way around. Other times it might mean that the wrong branch of government acted. Other times it might mean that they went about it the wrong way. There's nearly always another way around a particular policy concern. Whether we are talking about health care, whether we're talking about privacy and individual liberty, each and every person serving anywhere in our government has an obligation to look out for the best interests of those they represent. In fact, each and every person serving as an officer of the United States government is required under Article 6 of the Constitution to take an oath to uphold and protect and defend the Constitution of the United States. The Constitution, in short, this document, written nearly 2.5 centuries ago, that has helped foster the development of the greatest civilization the world has ever known, is not just a judicial thing. This is a thing that works, and works best when every one of us reads it, understands it, and takes and honors an oath to uphold it and protect it and defend it. When we do our jobs in this branch, when our friends in the executive branch do their jobs, it requires us to follow the Constitution just the same way. These tactics of creating fear and uncertainty and doubt, these tactics that result in relentless protests outside of the one branch of government that isn't political, astound me, but they dismay me and they disappoint me. They reflect the fact that we have allowed for the politicization of the one branch of the federal government that is not political. We can turn that around. we ourselves within the legislative branch have got to do a better job by focusing on the fact that the Constitution is not just a judicial thing. It's also a legislative thing. It's also an executive thing. It's an American thing. It's one of the many reasons why I will object anytime anyone tries to attribute to you a policy position and hold you to that. You're not a policymaker, you're a judge. That's what we're here to discuss. Thank you very much, Mr. Chairman.
Well, definitely some good news. Senator Lee's enthusiasm for the dormant Commerce Clause convinces me you've made a full recovery. Senator Whitehouse.
Chairman, Judge Barrett, America's worried about one thing above all else right now, and it's our health. This hearing itself is a microcosm of Trump's dangerous ineptitude in dealing with the COVID pandemic. Trump can't even keep the White House safe. Here it's the chairman's job to see to the committee's safety. And though his words were reassuring, I don't know who has been tested, who should be tested, who is a danger. What contact tracing has been done on infected and exposed senators and staff? Nothing. The whole thing, just like Trump, is an irresponsible botch. The irony is that this slapdash hearing targets the Affordable Care Act. This Supreme Court nominee has signaled in the judicial equivalent of all caps that she believes the Affordable Care Act must go and that the precedent protecting the ACA doesn't matter. The big secretive influences behind this unseemly rush see this nominee as a judicial torpedo they are firing at the ACA. So I hope Republicans consider what's at stake for the many people who depend right now in this pandemic on ACA health coverage. Rhode Islanders are calling, writing, emailing, tweeting me by the thousands, asking me to say no to this nominee, mostly because they too see her as a judicial torpedo aimed at their essential protections. And my constituents want you, my colleagues, members of the Republican Party, to stand up for once to Mitch McConnell and to the big donors who are driving this process, and for the sake of regular people, say stop. Here's one person to consider, Laura, from North Smithfield, Rhode Island. Laura's brother saved her life when he donated one of his kidneys to her. The hereditary nephritis Laura battled was a pre-existing condition protected under the ACA, just like COVID is now a pre-existing condition for nearly 8 million Americans. Laura tells me, without the ACA and its protections for people with pre-existing conditions, insurance premiums, if I'm able to get insurance at all, will be financially out of reach for me, and I will no longer be able to afford the health monitoring, labs, specialist appointments, and treatment that are essential for my kidney to function. My immunosuppressive medications alone would cost about $48,000 annually. Before the ACA, patients like me experienced times when they would come up against a life-threatening wall, not in treatment, but in the annual or lifetime caps on coverage insurers were allowed to impose. I can't imagine what this would have meant for me. Bankruptcy or worse. Laura's not alone. We're in the midst of a relentless, deadly health crisis that Trump has botched, which touches nearly everyone in this country. Americans are dying by the hundreds of thousands. Our economy is down 10 million jobs. Despite all the warnings and all the desperate pleas for help, people on the front line, healthcare workers, teachers, first responders, police officers, countless others, still struggle for the resources they need. More and more small businesses are closing for good. Many hospitals teeter at the edge of insolvency. Rhode Island, like so many other states, faces cruel fiscal challenges brought on by this pandemic. Since May, the House has passed 2 major COVID relief bills to tackle unemployment insurance, aid to the front lines, help to small business, support for hospitals, support for states and localities, and plenty more. Mitch McConnell's Senate Republicans won't budge. No urgency, he said. But 80 minutes after we learned of Justice Ginsburg's death, Mitch McConnell signaled he would fill this vacancy. The White House chose a replacement 3 days later. Justice Ginsburg hadn't been buried when the President and Senate Republicans celebrated Judge Barrett's nomination at the White House super spreader event. This was a hypocritical, tire-squealing 180 for many Republican colleagues. When they blocked Merrick Garland, we heard nonstop about the importance before an election of the American people weighing in at the ballot box. Nonstop that you shouldn't have a nominee appointed to the court after the primary season had begun. Well, now, with Americans voting right now in the general election, we get this mad slapdash rush. Why? Look at the Supreme Court calendar. Exactly 1 week after the election, on November 10th, the Supreme Court is going to hear California v. Texas, a constitutional challenge to the ACA. It survived its last challenge by 1 vote. If the new challenge succeeds with a new justice, the case will tear out the ACA, the law on which over 20 million Americans rely for health insurance, through which 17 million Americans access Medicaid coverage, under which 129 million Americans get pre-existing conditions covered, under which millions of seniors enjoy lower drug costs. Gone. And make no mistake, this nominee's signals on the ACA and on respect for the ACA precedent are clear. Clear enough to move her to the top of the big donors list. Just 3 years ago, she wrote that Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. In 2013, she wrote that stare decisis is not a hard and fact rule in the court's constitutional cases, the ACA being a constitutional case. Clear signals that are likely why she's before this committee now. So back to Laura. With stories like Laura's coming in from around the country, why would we rush forward? Well, the answer isn't pretty. There's a promise to big donors that must be kept. When David Koch ran for vice president, he campaigned on getting rid of Medicare and Medicaid. Imagine his fury when Obamacare passed. His groups are spending millions right now on this nomination. Republicans in Congress tried and failed to repeal the ACA more than 70 times. It's in the Republican Party platform for justices to reverse the ACA decision. Trump has over and over said this is his reason. And now we're in this mad rush to meet the November 10th argument deadline. And colleagues pretend this isn't about the ACA. Right. The travel of the ACA case leads to one senator's doorstep. In a Politico article yesterday, the senior senator from Texas tried to say that this rushed process isn't targeting the ACA. But look at the record. The district judge in Texas who struck down the ACA in the case, now headed for the court, is a former aide to the senator, who's become what the Texas Tribune calls the favorite for Texas Republicans seeking big judicial wins like torpedoing the ACA. The senior senator from Texas introduced in committee the circuit court judge who wrote the decision on appeal striking down the ACA. Senator Cornyn has filed brief after brief arguing for striking down the ACA. He led the failed Senate charge to repeal the ACA in 2017. He said, "I've introduced and co-sponsored 27 bills to repeal or defund Obamacare and have voted to do so at every opportunity. And now, talking about socialized medicine, the old Republican battle cry against Medicare, Senator Cornyn and all of our colleagues on this committee are pushing to get this nominee on by November 10th, the time needed to strike down the Affordable Care Act. Please don't tell us this isn't about the Affordable Care Act." From Cornyn judge to this nominee, hop, hop, hop. When Texans lose their ACA health care protections, hop, 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 to see whose doorstep that sits on. Lost in this hypocritical rush is the legacy of Ruth Bader Ginsburg. Let me close by remembering her for a minute in this unseemly charade. She fought for equality, equity, and dignity. She forged a path for women in the law, to Harvard Law School, to the pinnacle of legal academia, to the apex of legal advocacy, and on to the Supreme Court, where she defended women's reproductive rights, Gonzalez v. Carhart, the rights of workers, Ledbetter v. Goodyear Tire and Rubber, voting rights, Shelby County v. Holder, the rights of immigrants, Homeland Security v. Regents, and countless other freedoms. In her work, she bent the arc of the moral universe toward justice for all Americans. How fitting that she should be the first woman to lie in state in our United States Capitol. As to this charade, big donors may love it, but Americans see what's going on. They see this ugly, hasty, hypocritical power grab, and they know what it means for their health care in the midst of a pandemic. For Republicans, there is no washing your hands of responsibility for the results that your president has told us will ensue. Thank you, Mr. Chairman.
Thank you. Senator Cruz, I think, is with us virtually. Is that correct?
Yes, Mr. Chairman.
All right.
Thank you, Mr. Chairman. Good morning. Welcome. Welcome to Judge Barrett. Welcome to your family. Welcome to your beautiful children who are here with you today. You know, I want to start by making some observations about what we've heard this morning. At the very beginning, let me observe, as Sherlock Holmes famously observed, that what speaks the loudest is the dog that didn't bark, which is, to date, of every Democrat who's spoken, we've heard virtually not a single word about Judge Barrett. We've heard a lot of attacks at President Trump. We understand our Democratic colleagues are not supporters of the president. We've heard a lot of political rhetoric. We just heard the senator from Rhode Island directing some attacks at Senator Cornyn from Texas, and I understand there's an election in a few weeks, so that those political attacks are not surprising. But we've heard very little about the nominee who is here and whose confirmation we're considering. And I think part of the reason for that is that on any measure, Judge Barrett's credentials are impeccable. This is a woman who graduated #1 in her class at Notre Dame Law School. I'd venture to say that there is likely not a single member of this committee who graduated #1 in their class in law school. Perhaps my colleague Mike Lee can disagree with that statement, but it is a very impressive accomplishment. Judge Barrett went on to be a clerk to the great Justice Antonin Scalia, one of the greatest justices ever to serve on the Supreme Court. We heard celebration from Senator Leahy about the fact that he was confirmed 98-0. From there, she became a law professor for 2 decades at Notre Dame Law School, teaching the law to her students, where she was beloved, where she was respected, where she was a serious, careful scholar. And now she is one of the most respected federal court of appeals judges in the country. None of the discussions from our Democratic colleagues addressed any of that, because those impeccables, those credentials are on their face impeccable. Indeed, the American Bar Association, which typically leans hard left and has a long pattern of favoring Democratic nominees over nominees appointed by Republican presidents, had no choice but conclude that she was well qualified, as a majority of the reviewing board did. Judge Barrett's qualifications are remarkable, and I believe she will serve as an excellent Supreme Court justice. So what is it our Democratic friends have focused on? Well, one thing they've focused on is history. And they claim the fact that this nomination is occurring at all is illegitimate. Doesn't matter who Judge Barrett is, doesn't matter what she's done, doesn't matter her record, doesn't matter her extraordinary family story of doing all of this while being a mom to 7 kids. The timing of the nomination, our Democratic friends tell us, makes it illegitimate. Well, except for that history does not accurately reflect what the Senate has done over 2 centuries. This question of what happens when there's a Supreme Court vacancy during a presidential election year, 2020 is not the first time America has faced that question. Indeed, in our country's history, that question has come up a total of 29 times. So 29 times, presidents have faced the same circumstance. And presidents have nominated individuals to fill those positions all 29 times, 100% of it. Doesn't matter if you're a Democrat or Republican. From a president's perspective, it's easy. If there's a vacancy, even during a presidential election year, you make a nomination. 44 individuals have served as president throughout the history of our country. Half of them, 22 of the presidents we have made Supreme Court nominations for vacancies that occurred during a presidential election year. But what has the Senate done? Well, again, the Senate precedent is quite clear and is something that our Democratic friends do not want to address, do not want to confront. Of those 29 times, 19 of them occurred when the president and the Senate were of the same party. And when the president and the Senate are the same party, history shows that those nominees get confirmed. 17 of those 19 were confirmed for vacancies that occurred during a presidential election year. On the other hand, for those doing math at home, the remaining 10 occurred when the Senate and the president were of different parties. When the president and Senate are of different parties, the Senate over history has confirmed only 2 of those 10 nominees. Again, history is clear. The overwhelming majority of instances that the president and Senate are of different parties, that nominee doesn't get confirmed. That is, of course, what happened with Judge Garland, nominated by President Obama. President Obama was a Democrat, the Senate was in Republican hands, and following tradition of 200 years, the Senate did not confirm that nominee. Now, some might think the difference between whether the Senate and the president are of the same party or different party, that's just a question of partisan alignment, of partisan power. But that actually misunderstands the constitutional structure. The framers of the Constitution deliberately set up a system of checks and balances so that nobody can become a Supreme Court nominee without both the president and the Senate. Each was designed to check the other. That system of checks and balances limits power ultimately and protects the voters. And indeed, the voters made a clear choice. You know, one of the things that is clear from this discussion this morning is Democrats and Republicans have fundamentally different visions of the court, of what the Supreme Court is supposed to do, what its function is. Democratic senators view the court as a super legislature, as a policymaking body, as a body that will decree outcomes to the American people. Now, that vision of the court is something found nowhere in the Constitution. And it's a curious way to want to run a country. Even if on any particular policy issue you might happen to agree with wherever a majority of the court is on any given day, who in their right mind would want the United States of America ruled by 5 unelected lawyers wearing black robes? It's hard to think of a less democratic notion than unelected philosopher kings with life tenure decreeing rules for 330 million Americans. That is not, in fact, the court's job. The court's job is to decide cases according to the law and to leave policymaking to the elected legislatures. Now, look, that doesn't mean policymaking is unimportant. In fact, it means to the contrary. Policymaking is very important. And the people need to have a direct check on policymaking. You know what? If a rogue court implements policies you don't like, you, the American people, have very limited ability to check them. If a rogue Congress implements policies you don't like, you have a direct ability to check us by throwing the bums out and voting them out and voting in new representatives. You know, much of the argument this morning has concerned Obamacare. And they've been policy arguments. They're policy arguments that are actually occurring in the Senate, which is the right place for them to occur, a legislative body. But our Democratic colleagues simply want a promise from a judicial nominee that this nominee will work to implement their policy vision of health care. That is not a judge's job. That is not the responsibility of a judge. And in fact, making that promise would be violating the judicial oath. I don't know what will happen in this particular litigation on health care, but I do know that this body should be the one resolving the competing policy questions at issue. Many of our colleagues talked about pre-existing conditions, and I think they have made a political decision. They want this to be the central issue of the confirmation. Well, remember this. Every single member of the Senate agrees that pre-existing conditions can and should be protected. Period. The end. There is complete unanimity on this. Now, it so happens that there are a number of us on the Republican side that also want to see premiums go down. Obamacare has caused premiums to skyrocket. The average family's premiums have risen over $5,000 a year. Millions of Americans can't afford health care because of the policy failures of Obamacare. Those questions should be resolved in this body, in the elected legislature. It's not a justice's job to do that. It's not the court's job to do that. It is the elected legislature's job to do that. Judge Barrett brings impeccable credentials, a judicial temperament, and a faithfulness to the law. That's what we should be looking for in Supreme Court justices. And if Democratic senators want to engage in policy arguments, they can do so here, not by filibustering every bill as they have done over and over and over again, whether it's pandemic relief or Obamacare relief to lower premiums and expand choices. To date, our Democratic colleagues filibuster everything and then complain nothing gets passed. This is the body that has to resolve those questions. This is also the body that, consistent with 2 centuries of precedent, can, should, and I believe will confirm Judge Barrett as Justice Barrett. Thank you.
Senator Klobuchar.
Welcome, Judge Barrett. This committee is gathered today for what I consider one of its most solemn duties and one that I take very seriously. Federal judges, senators, the President of the United States, we all take an oath to uphold the Constitution. We make promises to do justice, to tell the truth. At its core, that's what judges do, right? Figure out the truth, figure out justice. My mom, a 2nd grade teacher, spent her life teaching little kids what was right or wrong, what was true or false. I still believe it matters, and so do the American people. But we are dealing with a president who doesn't think truth matters. And he has allies in Congress who in the past defended our democracy, but are now doing his bidding. Senators who clearly set out that the president, a precedent that the president in an election year should wait, that we should have an election, and that then the people choose the president and the president chooses the nominee. That was your precedent. It has been said that the wheels of justice turn slowly, and justice, on the other hand, can move at lightning speed, as we are seeing here today. We cannot, and you watching at home should not, separate this hearing from the moment we are in and from the judge he is trying to rush through. To respond to Senator Cruz, this isn't a rush to justice. This is a rush to put in a justice whose views are known and who will have a profound impact on your life. And yes, these policies that the court decides, they matter. Where you can go to school, who you can marry, decisions you can make about your own body, and yes, your health care. The president knows this. We have a president who has refused to commit to a peaceful transfer of power after an election. Every candidate does that, but not this guy. We have a president who has fired or replaced 5 inspector generals, Senator Grassley, who has fired an attorney general, an FBI director, and is now going after their replacements. We have a president who divides our country each and every day. He has called our military suckers and losers. He's refused to condemn white supremacists. And he has the gall to hold up a Bible as a prop in front of a church instead of heeding its words to act justly. And now he says this election will end up in court. Why, Senator Cruz? Does President Trump matter? He is putting the Supreme Court in place, in his words, to, quote, look at the ballots, end quote. Well, I won't concede that this election is headed to the court because you know at home exactly what the president is up to. That's why you're voting. That's why you are voting in droves. Why are you voting? Well, you know that your rights, your health care is on the line. You know that they are trying to push through a justice who has been critical of upholding the Affordable Care Act, and they're doing it in the middle of a pandemic. And you can see here in this room the misplaced priorities of this Republican-run Senate. And it's in your hands to change it. Are they working to pass a bill to help Americans to get the testing they need to save their lives? Are they working to help the moms trying to balance a toddler on their lap while balancing a laptop on their desk? Are they trying to help our seniors isolated, missing graduations and birthdays? Are they passing the bill the House passed that would help our economy? That's not the priority. Instead, they choose to do this. So no, we cannot divorce this nominee and her views from the election we are in. We didn't choose to do this now, to plop a Supreme Court nomination hearing in the middle of an election. They did. So the reason people aren't going to fall for this is because it is so personal. The over 210,000 people who have died, the school canceled, the small business closed, the job you don't have, the degree you couldn't get. It's personable to me because my husband got COVID early on. He ended up in the hospital for a week on oxygen with severe pneumonia. And months after he got it, I find out the president knew it was airborne, but he didn't tell us. We were cleaning off every surface in our house, and my husband got it anyway. We didn't know. And my dad at 92, he got it in his assisted living. I stood there outside his window in a mask, and he looked so small and confused. He knew who our family was, but he didn't know what was going on. I thought it was going to be the last time that I saw him. He miraculously survived. But Marnie Zhang, she didn't. Marnie was a rising star, the chairwoman of the St. Paul School Board in just 31 years when COVID took her life. Her dad felt sick. She went with him to the hospital because he was scared, and then she got sick, never got off a ventilator, and died. The daughter of Hmong refugees whose parents fled Laos to a refugee camp in Thailand before arriving in Minnesota. Marnie and her 7 siblings grew up in St. Paul. Their family, the American dream. This is who this virus has taken from us. Someone who has left behind a mother and a father and 7 siblings who loved her, and someone who undoubtedly would have made the world a better place. The president could have saved so many lives. Instead, he's been reckless, packing people in without masks for your nomination party, Judge Barrett. 35 people got sick. The president himself ends up in the hospital, and when he leaves Walter Reed still contagious, he defiantly takes off his mask and walks into the White House. And then he lies and says the virus will magically go away. The truth matters. And the truth is, America, that this judicial nominee has made her views so clear. And this president is trying to put her in a position of power to make decisions about your lives. The Affordable Care Act protects you from getting kicked off of your insurance. That's on the line. The president has been trying to get rid of Obamacare since he got in power. John McCain went in and stopped it with that big thumbs down. Then they went and brought a case to the U.S. Supreme Court, and they're now trying to stack the deck against you right now. The last time this was before the court in a big way was when Justice Roberts, not exactly a blazing liberal, voted the same as Justice Ginsburg to uphold the Affordable Care Act. And this nominee, she criticized him. America, this is about you. It's about these 2 girls up here, Evelyn and Mariah, identical twins from Cambridge, Minnesota, honor roll students, star athletes. They play in the softball team. One's a pitcher, one's a catcher. They also play basketball. One of them got severe diabetes when she was very young. Doesn't matter which one. the pitcher, the catcher, they both deserve good health care. They get that with one stroke of a pen, one judge can decide if millions of Americans, including their family, would lose their insurance. One judge can decide if millions of Americans can lose their right to keep their kids on their insurance till they're 26 years old. One judge can decide that if seniors' prescription drugs, which already are too high, could soar even higher. This is a judgeship that was held by an icon who voted to protect your health care, Ruth Bader Ginsburg, a woman who never took no for an answer. When they told her a girl shouldn't go to law school, she graduated first in her class. And when they told her a man should argue landmark equal protection cases because maybe they'd have a better chance of winning, she did it herself and she won. She never gave up. She had her own hashtag well into her 80s, the notorious RBG. And her last fervent wish was that a new president, the winner of this election, would pick her replacement. When you look at her opinions, you realize she wasn't just writing for today, she was writing for tomorrow. To the women of America, we have come so far, and in the name of RBG, we should not go backwards. As the rabbi said at Justice Ginsburg's memorial in the Capitol, her dissents, her strong words when she would disagree with the Republican-appointed justices, her words were never cries of defeat. They were blueprints for the future. So to all Americans, this hearing, whatever these guys try to do, whatever you hear from me, it will not be a cry of defeat. It will instead be our blueprint for the future. Yes, Judge, I think this hearing is a sham. I think it shows real messed up priorities from the Republican Party. But I am here to do my job, to tell the truth. To all Americans, we don't have some clever procedural way to stop this sham, to stop them from rushing through a nominee, but we have a secret weapon that they don't have. We have Americans who are watching, who work hard every day, believe in our country and the rule of law, whether they are Democrats, Republicans, or independent. They know what this president and the Republican Party are doing right now is very wrong. In fact, 74% of Americans think we should be working on a COVID relief package right now instead of this. Let me tell you a political secret. I doubt that it will be a brilliant cross-examination that's going to change this judge's trajectory this week. No, it is you. It is you calling Republican senators and telling them enough is enough, telling them it is personal, telling them they have their priorities wrong. So do it. And it is you voting even when they try to do everything to stop you. It is you making your own blueprint for the future instead of crying defeat. So do it. This isn't Donald Trump's country. It is yours. This shouldn't be Donald Trump's judge. It should be yours. Thank you, Mr. Chairman.
Senator Sass.
Thank you, Mr. Chairman. Judge Barrett, welcome. Congratulations. Jesse Barrett, congratulations. I just want to say, Senator Klobuchar said a number of things about COVID that I agree with. She cited a bunch of really painful stories in Minnesota, and similar stories could be told from across the country. I even agree with parts of her criticism of the mismanagement of COVID by Washington, D.C. I don't know what any of that has to do with what we're here to do today. Huge parts of what we're doing in this hearing would be really confusing to eighth graders. If civics classes across the country tuned into this hearing and tried to figure out what we're here to do, and they heard as much as they've heard about 2009 Finance Committee debates about what should be in a healthcare reform package. I'm blessed to sit not just on the Judiciary Committee, but also on the Finance Committee. And lots of the discussions we've had in here today fit better in a Finance Committee hearing than in a Judiciary Committee hearing. So I think it would be very useful for us to pause and remind ourselves and do some of our civic duty to eighth graders to help them realize what a president runs for, what a senator runs for, and on the other hand, why Judge Barrett is sitting before us today and what the job is that you're being evaluated for. So if we can back up and do a little bit of eighth grade civics, I think it would benefit us and benefit the watching country, and especially watching eighth grade civics classes. So I'd like to distinguish first between civics and politics, because there was a time, the chairman said at the beginning of this hearing, there was a time when people that would be as different as Ruth Bader Ginsburg, and she was a heroic woman, that's absolutely true, and Antonin Scalia, another brilliant mind and your mentor, people that different could both go through the Senate and get confirmation votes of 95 or 98 votes. And the chairman said at the beginning of the hearing, he doesn't know what happened between then and now. I think some of what happened between then and now is we decided to forget what civics are and allow politics to swallow everything. So if I can start, I'd like to just remind us of the distinction between civics and politics. Civics is the stuff we're all supposed to agree on, regardless of our policy views differences. Civics is another way we talk about the rules of the road. Civics 101 is the stuff like Congress writes laws, the executive branch enforces laws, courts apply them. None of that stuff should be different if you're a Republican or a Democrat or a Libertarian or a Green Party member. This is basic civics. Civics is the stuff that all Americans should agree on, like religious liberty is essential. People should be able to fire the folks who write the laws, and the voters can't fire the judges. Judges should be impartial. This is just Civics 101. Politics is different. Politics is the stuff that happens underneath civics. Civics is the overarching stuff we as Americans agree in common. Politics is the subordinate, less important stuff that we differ about. Politics is like if I look at my friend Chris Coons and I say, listen up, jackwagon, what you want to do on this particular finance committee bill is going to be way too expensive and might bankrupt our kids. Or if Chris looks back at me and says, listen up, jackwagon, you're too much of a cheapskate and you're underinvesting in the next generation. That's a really important debate. That's a political debate. That's not civics. Civics is more important than that. Civics doesn't change every 18 to 24 months because the electoral winds change and because polling changes. I think it's important that we help our kids understand that politics is the legitimate stuff we fight about, and civics is the places where we pull back and say, wait a minute, we have things that are in common, and before we fight again about politics, let's reaffirm some of our civics. So I'd like to have just sort of a basic grammar of civics for 5 minutes. One thing that we should all agree on and two things that we should all disagree with. We should agree on it, but one thing that we agree about and are in favor of, and two things that we agree on that we should all reject. First, a positive, grand, unifying truth about America, and that is religious liberty. Religious liberty is the basic idea that how you worship is none of the government's business. Government can wage wars, government can write parking tickets, but government cannot save souls. Government's really important. War is important. Parking tickets are important. But your soul is something that the government can't touch. So whether you worship in a mosque or a synagogue or a church, your faith or your lack of faith is none of the government's business. It's your business and your families and your neighbors and all sorts of places where people break bread together and argue, but it's not about power, it's not about force, it's not about the government. This is the fundamental American belief. Religious liberty is one of those 5 great freedoms clustered in the First Amendment. Religion, speech, press, assembly, and protest, these 5 freedoms that hang together, that are the basic pre-governmental rights, are sort of Civics 101 that we all agree on well before we ever get to anything as relatively inconsequential as tax policy. So civics should be the stuff we affirm together. And contrary to the belief of some activists, religious liberty is not an exception. You don't need the government's permission to have religious liberty. Religious liberty is the default assumption of our entire system. And because religious liberty is the fundamental 101 rule in American life, we don't have religious tests. This committee isn't in the business of deciding whether the dogma lives too loudly within someone. This committee isn't in the business of deciding which religious beliefs are good and which religious beliefs are bad and which religious beliefs are weird. And I just want to say, as somebody who's self-consciously a Christian, we got a whole bunch more really weird beliefs. Forgiveness of sins, the virgin birth, resurrection from the dead, eternal life. There are a whole bunch of really, really crazy ideas that are a lot weirder than some Catholic moms giving each other advice about parenting. And yet there are places where this committee has acted like it's the job of the committee to delve into people's religious communities. That's nuts. That's a violation of our basic civics. That's a violation of what all of us believe together. This is not a Republican idea. It is not a Democrat idea. It's a Democrat idea and a Republican idea, but more fundamentally, it's an American idea. And the good news is, whether you think your religious beliefs might be judged wacky by someone else, it's none of the business of this committee to delve into any of that in this context, because in this committee and in this Congress and in this constitutional structure, religious liberty is the basic truth. And whatever you or I or Judge Barrett believe about God isn't any of the government's business. We can all believe in that in common. We should all reaffirm that in common, and that should be on display over the course of the next 4 days in this committee. Now, a couple of terms that all of our 8th graders should know as things we should reject in common. And again, shared rejection, not Republican versus Democrat or Democrat versus Republican, but a shared American rejection. And the first is this: judicial activism. Judicial activism is the idea that judges get to advocate for or advance policies, even though they don't have to stand for election before the voters, and even though they have lifetime tenure. Judicial activism is the really bad idea that tries to convince the American people to view the judiciary as a block of progressive votes and conservative votes, Republican justices and Democratic justices. This is the confused idea that the Supreme Court is just another arena for politics. When politicians try to demand that judicial nominees, who are supposed to be fair and impartial, when politicians try to get judicial nominees to give their views on cases or to give their views on policies, to try to get them to pre-commit to certain outcomes in future court cases, we are politicizing the courts, and that is wrong. That is a violation of our oath to the Constitution. Likewise, when politicians refuse to give answers to the pretty basic question of whether or not they want to try to change the number of justices in the court, which is what court packing actually is, when they want to try to change the outcome of what courts do in the future by trying to change the size and composition of the court, that is a bad idea that politicizes the judiciary and reduces public trust. On the other hand, depoliticizing the court looks a lot like letting courts and judges do their jobs and the Congress do our jobs. You don't like the policies in America? Great, elect different people in the House and in the Senate and in the presidency. Fire the politicians at the next election. But voters don't have the freedom to fire the judges. Therefore, we should not view judges, and we should not encourage judges or the public to view them as ultimately politicians who hide behind their robes. The antidote to judicial activism is originalism. Originalism, also known as textualism, is basically the old idea from 8th grade civics that judges don't get to make laws. Judges just apply them. An originalist comes to the court with a fundamental humility and modesty about what the job is that they're there to do. An originalist doesn't think of herself as a super legislator whose opinions will be read by angels from stone tablets in heaven. Judicial activism, on the other hand, is the bad idea that judges' black robes are just fake, and truthfully, they're wearing red or blue partisan jerseys under there. We should reject all such judges. And so today, when we have a nominee before us, we should be asking her questions that are not about trying to predetermine how certain cases will be judged. And a final term that we should be clear about, I mentioned earlier, but I think it's worth underscoring, is we should underscore what is court packing. Court packing is the idea that we should blow up our shared civics, that we should end the deliberative structure of the Senate by making it just another majoritarian body for the purposes of packing the Supreme Court. Court packing would depend on the destruction of the full debate here in the Senate, and it is a partisan suicide bombing that would end the deliberative structure of the United States Senate and make this job less interesting for all 100 of us. Not for 47 or 53, because it's hard to get to a supermajority that tries to protect the American people from 51, 49, 49, 51 swings all the time. What blowing up the filibuster would ultimately do is try to turn the Supreme Court into the ultimate super legislature, Court packing is not judicial reform, as some of you who wrote the memo over the weekend got a lot of media to bite on. Court packing is destroying the system we have now. It is not reforming the system we have now. And anybody who uses that the language that implies filling legitimate vacancies is actually just another form of court packing that's playing the American people for fools. And the American people actually want a Washington, D.C. that depoliticizes more decisions, not politicizes more decisions. So, Judge, I'm glad that you're before us. I'm looking forward to hearing your opening statement later today, and I look forward to the questioning you have to endure over the next 2 or 3 days, even though you probably look forward to it a little bit less. Congratulations and welcome.
Senator Coons.
Thank you, Mr. Chairman. Judge Barrett, to you and your family, welcome. Over the past weeks, I've been flooded with calls, texts, emails from Delawareans. Delawareans who are scared because they are worried about their own health, the health of a parent or child, because they don't know if it's safe for their kids to go to school, if their businesses will survive, or because they're wondering why on earth this Senate is focused on racing forward with a Supreme Court nominee, but is not willing to take a vote to provide needed relief for them and their families. It is an understandable question when we're in the midst of a devastating global pandemic in which more than 210,000 Americans have died, more than 7 million have been infected and have a new pre-existing condition, why there were just 300,000 new cases this week. And today, more than 25 million Americans are collecting unemployment. This is an ongoing national emergency, and as an exercise in civics, not politics, we in Congress should be working day and night to deliver them that relief. Instead, my colleagues are barreling forward with a confirmation hearing that's distracting from our responsibility to our constituents and threatens to further tear our nation apart. Mr. Chairman, as you know, we're just 22 days from an election. There is no precedent, despite my colleagues' lengthy and I think hypocritical lecture about the history. There is no precedent in our nation's history for confirming a Supreme Court nominee by the Senate this close to a presidential election, in which a majority of states are already voting. In fact, 6 million Americans have voted. This process flies in the face of the very rule Republicans set themselves in 2016, when they refused, as a matter of politics, not of civics, to even consider a highly qualified nominee, Judge Merrick Garland, 9 months before an election, simply because it was an election year. And Mr. Chairman, in 2018, you went a step further and said, if an opening on the Supreme Court came up in the last year of President Trump's term, you would wait until the next election and let the voters decide. So what changed? Sadly, nothing. Nothing except the fact that this time, President Trump and his allies in the Senate saw a chance in Justice Ginsburg's untimely passing to shift the balance of the Supreme Court for decades to come, and that will have consequences in the real lives of millions of Americans. Proceeding with this confirmation today is wrong. And if I could, to my colleague who just spoke, religious liberty, I agree, is foundational to our civics and our republic. And I and my colleagues will focus, Judge Barrett, on your legal writings, your opinions, your articles, your speeches as a law professor and judge. And I think when we do that, we will conclude the ways in which you may serve as a justice will do irreparable harm. I think proceeding with this nomination in this way at this time will also do harm to what remaining trust we have in each other, to the Senate as a whole, and potentially to the court itself. As if all of this weren't reason enough for us to delay, we're proceeding despite having 2 members of this committee who've contracted the virus. That's why the Senate's out of session today. That's why all of us, when not speaking, are wearing masks. That's why the distance between us. In light of all of this, in light of the stresses on our country, I think this rushed, hypocritical, partisan process should not proceed. But instead we are. So let me try and help explain to those who've reached out to me why and why it matters. Centrally, it's this. President Trump has promised over and over and over again that he would repeal the Affordable Care Act. He ran on that promise, but despite his very best efforts, he's failed. My Republican colleagues here and in the House have voted over and over and over to repeal the Affordable Care Act since it was passed a decade ago. But thankfully for the people of our nation and my state, they too have been unsuccessful. And yet today, to make good on this promise to achieve what they could not accomplish through the democratic process, they're looking to the courts, in fact, to the court. They're looking to this nominee. President Trump explicitly promised anyone he nominated to the Supreme Court would do the right thing and be a vote to overturn the Affordable Care Act. And just 1 week after the upcoming election, the Supreme Court will hear a case in which the Affordable Care Act is at issue and where the Supreme Court will hear argument that supports the Trump administration and the Trump's Department of Justice position to strike down this landmark law. So let me be clear. Just a week after the upcoming election, the Trump administration will be telling the Supreme Court to tear down the very law that provides health care protections in the middle of an ongoing pandemic. Judge Barrett, you've publicly criticized the Supreme Court's past decisions upholding the Affordable Care Act, and I think that is appropriately at issue in the days to come. The president knows this, and it's one reason why he and my colleagues are rushing to have this confirmation just in time to hear the administration's challenge to the Affordable Care Act. I don't think this is a coincidence. It's beyond ironic that this administration, which has failed to respond to this pandemic, is rushing through a judge they believe will vote to strip away health care protections. Today, because of the Affordable Care Act, insurance companies cannot discriminate against women for being women. They cannot charge more. They cannot treat pregnancy as a pre-existing condition. I cannot think of a sharper irony as we consider the legacy of Justice Ginsburg, who dedicated her life to fighting for gender equality. It also prevents insurance companies from charging any with pre-existing conditions more, so Americans no longer have to worry about going bankrupt because of an unexpected illness or accident. Don't take my word for it. Listen to the voice of Carrie, who's behind me to my right. Carrie from Middletown, Delaware, used to pay $800 a month for junk insurance, as she called it. Coverage so skimpy, she had to live in fear of going to the doctor's office or needing medication. Because of the ACA, she was able to get better coverage to pay what she can afford based on her income. She has diabetes, she has high blood pressure, but thanks to the ACA, she can't be denied care or coverage. She told me when he spoke, this takes the stress and the worry out of it, and then asked me, how is this even at issue? Wasn't that settled years ago? Carrie's right. She should have the peace of mind that you can care for yourself and your family if you get sick. I've heard so many more stories from Delaware. Just over my shoulder here is Debbie from Newcastle, a self-employed small business owner who receives her health insurance through the marketplace. Her pre-existing condition requires her to attend physical therapy and doctor's appointments multiple times each month. Without the ACA, insurance companies would have charged her more because of her condition, and she wouldn't be able to afford her medical bills and support her small business. There's Barb Slater from Newark, Delaware, who was diagnosed with scleroderma 4 years ago. After losing her employer-sponsored health insurance, she was able to find new coverage in the marketplace thanks to the Affordable Care Act. My inbox and the inbox of all my colleagues are filled with stories like Carrie's, Debbie's, Barb's, and they highlight the breadth of what the ACA means to the American people. The ability of young people to stay on their family's insurance, lower out-of-pocket costs for seniors' prescriptions, the elimination of lifetime caps. These protections are on the line in the ballot and on the docket of the Supreme Court. And it's not just the ACA at risk. Judge, I'm deeply concerned about ways in which your approach to something that may sound abstract to folks watching stare decisis or precedent, that means your approach to reviewing and reconsidering and possibly overturning long-settled cases may overturn some of the very principles for which Justice Ginsburg fought her entire adult life, principles that protect settled fundamental rights for all Americans. What might this mean? Cases like Griswold versus Connecticut that establish married couples have a right to obtain and use contraception in the privacy of their own home may be in danger of being struck down. It means cases like Roe versus Wade, which protects a woman's right to make her own critical health care decisions, may be on the line. And it means Obergefell versus Hodges, which made marriage equality the law of this land, could be overruled. Just a day after we celebrated Coming Out Day nationally, stripping LGBTQ individuals of what Justice Kennedy memorably called equal dignity in the eyes of the law. This is what I believe is at stake with this nomination. Judge Barrett, you will be deciding cases that have real daily impacts on the lives of millions of Americans. They deserve to understand why President Trump nominated you and what consequences your decisions may have on them and their lives. I've heard my Republican colleagues say all they care about is finding a future justice who will apply the law as written, as if all this is about today is an abstract fight about interpretive methodology and jurisprudence. They seem shocked we're talking about what the Supreme Court might do if Judge Barrett were to become Justice Barrett. But Judge Barrett, I'm not suggesting you made some secret deal with President Trump, but I believe the reason you were chosen is precisely because your judicial philosophy, as repeatedly stated, could lead to the outcomes President Trump has sought. And I think that has dramatic and potentially very harmful consequences with regards to the election, the Affordable Care Act, and long settled rights. This is what I intend to lay out this week, and this is what I hope the American people will hear in the course of this confirmation hearing. Thank you, Mr. Chairman.
Thanks, Senator Coons. For planning purposes, I think I talked to Senator Feinstein. We will go to Senator Hawley, Blumenthal, and Tillis. We'll take a 30-minute break to grab a bite to eat and take a little bit of a break and come back and finish up. So, Senator Hawley.
Thank you, Mr. Chairman. Judge Barrett, welcome. It's good to see you again. Jesse Barrett, welcome, and to you and to your family as well. I see that some of your children are getting a break. They've earned it, I think. I'm amazed as I've been watching. I've got 2 little boys at home, my wife and I do. I can't believe how calmly your children have been sitting for a couple of hours. So maybe you can give me some tips, Jesse and Judge, when we're finished here. You know, we've gotten to read a lot about your family in the last few weeks. We've gotten to read a lot about you in the press, and in particular about your religious beliefs. One attack after another in the liberal media, one hit piece after another, many of them echoed by members of this committee, like this one, for instance, Barrett long active with Insular Christian Group. We've read stories about your Catholic lifestyle, stories about how you raise your children, stories about how you adopted your children, stories about your Catholic doctrinal beliefs, over and over and over questioning whether you have, I guess, the independence to be a judge, a justice on the United States Supreme Court. And it's not just in the newspapers, it's members of this committee, including the Democratic nominee for Vice President of the United States, who has questioned past nominees who have come before this committee about their membership in Catholic fraternal organizations like the Knights of Columbus. And for those watching at home, that's right, you heard me correctly. Senator Harris and others on this committee have repeatedly questioned judicial nominees' fitness for office because of their membership in the Knights of Columbus. The ranking member, when you were last before this committee, Judge, for your initial confirmation hearings, the ranking member referred to your Catholic convictions as dogma, that's a quote, that lives loudly within you, picking up the very terminology of anti-Catholic bigotry current in this country a century ago. She wasn't alone. Other senators on this committee last time asked you if you were an Orthodox Catholic. One senator said she worried that you would be a Catholic judge if you were confirmed because of your religious beliefs, I guess as opposed to an American judge, as if you can't be both a devout Catholic and a loyal American citizen. And it's not just you, Judge. Other nominees who have come before this committee for years now have been asked by my Democrat colleagues over and over their views on sin, their views on the afterlife, their views about their membership statements of Catholic organizations, about their membership in other Christian organizations, and on and on and on. And let's be clear about what this is. This is an attempt to broach a new frontier, to set up a new standard. Actually, it's an attempt to bring back an old standard that the Constitution of the United States explicitly forbids. I'm talking about a religious test for office. Article 6 of the Constitution of the United States, before we even get to the Bill of Rights, Article 6 of the Constitution of the United States says clearly, and I quote, "No religious test shall ever be required as a qualification to any office or public trust under the United States. Now, that was big news in 1787 when it was written, and it's worth remembering why. It's because no country, no republic in the history of the world had ever guaranteed to its citizens the right to freedom of conscience and religious liberty. Every other country that had ever existed tied together the religious beliefs that would be approved by the powerful and the right to serve in office or to vote or just to be a citizen. In every other country across history, you had to agree with what those in power agreed with in order to hold office or be a citizen in good standing. You had to sign a particular religious confession, or you had to disavow a particular religious group, swear not to follow the Pope, for instance. You had to pledge allegiance to the God of the city or the God of the empire. This was true from 18th century Britain all the way back to ancient Rome. And so when our founders put Article 6 into the Constitution of the United States, they were making a very deliberate choice. They were breaking with all of that past history, and they were saying in America, it would be different. In the United States of America, we would not allow the ruling class to have veto power over your faith, over what Americans believed, over who we gathered with to worship and why and where and how. No, in this country, the people of the United States would be free to follow their own religious convictions, free to worship, free to exercise their religion, and people of faith would be welcome in the public sphere. They'd be welcome there. They'd be welcome without having to get the approval of those in power, like those on this committee. They would be welcome to come and to bring their religious beliefs to bear on their lives, on their office, and all that they do. So long, of course, as they were peaceful citizens who followed the law. Religious people of all backgrounds would be welcome in public life. And no person in power would be able to control what the American people, any American citizen, thought or believed or who they worshiped. This freedom of conscience and religious liberty undergirds all of our other rights because it tells the government that it cannot tell us what to think or who we can assemble with or how we can worship or what we can say. And that's why Article 6 is there even before we get to the Bill of Rights and the First Amendment. But this bedrock principle of American liberty is now under attack. That is what is at stake when we read these stories attacking Judge Barrett for her faith. That is what is at stake when my Democratic colleagues repeatedly question Judge Barrett and many other judicial nominees about their religious beliefs, about their religious membership, about their religious practices, about their family beliefs and practices. That is an attempt to bring back the days of the religious test. That is an attempt to bring back the veto power of the powerful over the religious beliefs and sincerely held convictions of the American people. And that is what is at stake in this confirmation hearing. Judge Barrett is a Catholic. We all know that. She's a devout Catholic. We all know that. She and her husband have chosen to raise their family according to their Catholic beliefs in faithful fellowship with other Catholics. We all know that. Heck, 65 million Americans are Catholics, and many millions more are Christians of other persuasions. Are they to be told that they cannot serve in public office, that they are not welcome in the public sphere unless the members of this committee sign off on their religious beliefs? I, for one, do not want to live in such an America. And the Constitution of the United States flatly prohibits it. Now, the Constitution says that people of faith, like Judge Barrett, are welcome in high office, welcome in any office, welcome throughout our public life here in this country. And I would just say to my Democrat colleagues that these years now, this pattern and practice, as we say in the law, this pattern and practice of religious bigotry, because that's what it is. When you tell somebody that they're too Catholic to be on the bench, when you tell them they're going to be a Catholic judge, not an American judge, that's bigotry. The pattern and practice of bigotry from members of this committee must stop. And I would expect that it be renounced. Now, I just heard my colleague, Senator Coons, make a reference to an old case, the Griswold case, which I can only assume is another hit at Judge Barrett's religious faith, referring to Catholic doctrinal beliefs. I don't know what else it could be, since no one has challenged this case. It is not a live issue and hasn't been for decades. This is the kind of thing I'm talking about, and this is the sort of attacks that must stop. I look forward, Judge Barrett, to getting to the chance to speak with you further about your legal credentials, about your legal views, about your approach to the law and your judicial philosophy. But I hope that one thing that this confirmation process will stand for in the end, I hope when we look back at the confirmation hearings for Judge Amy Barrett, soon I hope to be Justice Amy Barrett, one thing we will say is that was the time, that was the year that the attempt to bring back religious tests for office was finally stopped. Thank you, Mr. Chairman.
Senator Blumenthal.
Thank you, Mr. Chairman. Judge Barrett, and to your family, welcome to the committee. I want to introduce you to one of my constituents, Connor Kern of Ridgefield, Connecticut. He is 10 years old, and he suffers from Duchenne muscular dystrophy. It is a horrible, incurable disease. It slowly deprives children of the strength and their ability to move. Eventually, it robs them of their lives. The costs of providing Connor's care are astronomical, but for Connor and his family, it is worth every penny. Connor is a superhero, but he's always had a real sidekick. He's had the protection of the Affordable Care Act. It has shielded him and his family from arbitrary caps on coverage that would have cut off his care when it became too expensive. It has protected Connor from losing insurance because of this insidious disease that he never caused and chose. The Affordable Care Act has given his family a measure of relief, of hope, of peace. They still worry about Connor's health, but not their coverage or its costs. Connor and millions of others like him are why I will oppose your nomination. Your nomination is about the Republican goal of repealing the Affordable Care Act, the Obamacare they seem to detest so much. It's about people like Connor, protections for people with pre-existing conditions, tax credits that make health insurance more affordable, bans on charging women more simply because they are women. That's what my Republican colleagues have been fighting to repeal for the last decade. They voted dozens and dozens of times to repeal the Affordable Care Act, and they have challenged it twice unsuccessfully in the United States Supreme Court. And each time they failed. But now, just 1 week after the election, as you know, the fate of the Affordable Care Act will be again in the hands of the United States Supreme Court. Republicans have turned again to the court to try to achieve judicially what they cannot achieve legislatively. President Trump has vowed that any judge he nominated would pass the very strong test, his words, and that they would strike down the Affordable Care Act. Judge Barrett, in all honesty, you have auditioned for this job through your academic writing and judicial opinions, and you've passed that test. In fact, you've stated twice in effect that you would have voted to strike down the Affordable Care Act had you been a justice at the time. You've been vetted, you've been screened by the Trump administration and special interests who want an activist judge. They want someone who will legislate from the bench and strike down laws supported by a vast majority of the American people. And that activism uses originalism as a smokescreen. If the American people have any doubts about how dedicated my Republican colleagues are to taking away people's health care, just listen to their own words. They've been remarkably candid and forthright. Senator Graham, our chairman, has said, "You can't repair this monstrosity," I'm quoting, "you can't repair this monstrosity called Obamacare. You have to tear it down and start over." Senator Ernst has said, quote, "I support immediate action to repeal Obamacare and replace it." Senator Cornyn, "It's time to repeal and replace." Senator Tillis, "Repeal Obamacare. Let's end this disaster." And President Trump himself has said, "We want to terminate Obamacare." Millions of Americans, more than 130 million, have a pre-existing condition: asthma, heart disease, diabetes, cancer, Parkinson's, pregnancy, and now, by the cruelest of ironies, COVID-19. COVID-19, the cause of this pandemic, now is a pre-existing condition that could prevent millions of Americans from being covered by health care. Stripping health care from millions of Americans during a pandemic, that's really what is at stake in the Republican lawsuit, now before the Supreme Court, and in this nomination. And sadly, it's not just the Affordable Care Act that's at stake. It's a woman's right to decide when and how to have a family, control over her own body. An activist judge on the bench doing what Congress could not do would also strike down common sense gun safety laws. Connecticut has been at the forefront on gun violence protection. On gun safety, Judge, you acknowledged that your dissenting opinion in Canner sounds kind of radical. That's because it is. But if your views on the Second Amendment are adopted by the Supreme Court, it would imperil common sense state laws like Connecticut's all around the country. Today, we ought to be working on improving American health care. We ought to be fighting COVID-19, which has infected 8 million Americans and killed more than 215,000. We should be producing a national testing strategy, instituting effective contact tracing, and securing sufficient PPE. We ought to be providing assistance to the millions of Americans who have lost their job and face economic hardship and heartbreak. President Trump has failed to do any of it. Instead, he and our Republican colleagues are riveted on rushing a judge through this sham process, dropping everything else. President Trump's failure to act will likely lead to 55,000 additional deaths, 55,000 additional Americans lost over just the next 3 months. Senate Republicans are refusing to address American health care or COVID-19 or economic relief because they care more about putting an extremist ideological judge on the bench and not just on the Supreme Court. I've learned as a senator that there are very few unwritten rules, very few written rules, I should say, in this place. But there is one very important unwritten rule. Keep your word. Republicans have all sorts of excuses for why they are breaking their promise, the promise that they would not confirm a Supreme Court justice during an election year. Each excuse boils down to nothing more than raw political power. They're doing it because they can. But might does not make right. They have boasted they have the votes, but they don't have the American people and they don't have history on their side. The American people want a plan to fight and conquer this disease. They want a plan to put Americans back to work. They want a blueprint for the future, not rolling back rights and turning back the clock. I revere the Supreme Court. I clerk for Justice Harry Blackmun. I've argued cases before the court 4 times. Now I'm really deeply concerned that the Supreme Court is losing the trust and respect of the American people. The authority of the Supreme Court depends on that trust. It has no army or police force to enforce its decisions. The American people follow the Supreme Court's commands, even when they disagree, because they respect its authority. And now, President Trump and the Republican Center are eroding, indeed destroying, that legitimacy. They've stripped the American people of their say in this process simply to confirm a justice who will strike down in court, legislate from the bench, what they can't repeal in Congress. Your participation, let me be very blunt, in any case involving Donald Trump's election would immediately do explosive, enduring harm to the court's legitimacy and to your own credibility. You must recuse yourself. The American people are afraid and they're angry, and for good reason. It's a break the glass moment. Americans must use their voices to speak out and stand up, to contact my colleagues on this committee, despite their boasts about having the votes. Stand up and speak out to protect their own health, public health, and the health of our democracy. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. We will now have Senator Tillis, who's with us remotely. After his opening statement, we will come back at 12:20. And Senator Hirono, you will be the first one to make a statement. So, Senator Tillis.
Thank you, Chairman Graham and Ranking Member Feinstein. I want to take a moment to honor the life and legacy of Justice Ginsburg. She was a living legend and a giant in the legal world as a professor, as a lawyer, and as a judge and a justice. She was an inspirational model and role model, and we honor her legacy. And I just want to make sure that her family knows the nation mourns her loss. But today we're here to consider a nomination of a highly qualified jurist to the United States Supreme Court, Judge Amy Coney Barrett. She's a top legal scholar, a professor in the mold of the late Justice Scalia. Her work is widely respected in the legal community, and it's clear why her former students voted her multiple times to be the Distinguished Professor of the Year at the Notre Dame Law School. It's also why every full-time faculty member of Notre Dame Law supports her nomination. Her legal work and teaching have inspired hundreds of young lawyers, especially aspiring female lawyers. She's a remarkable mother. She has 7 beautiful children. And in spite of being busy working as a Seventh Circuit justice, she makes time to be involved in her community. And this nomination is important because it's going to have a lasting impact on our republic. A justice service on the bench involves every important issue facing our constitutional republic. What are the limits of abusive and intrusive government power? What's the proper role of each branch of government? And what are the fundamental protections that our Constitution grants all Americans? These are foundational questions for the Supreme Court, and they consider them every single term. If confirmed, Judge Barrett will be tasked with answering these questions, and I believe she's going to do a great job. But it's not the rights enshrined in the Constitution that's most important. It's the structure of the document itself that ensures our freedom. Justice Scalia understood this. He was fond of saying, every dictator in the world, every president for life has a Bill of Rights. That's not what makes us free. What makes us free is our Constitution. Think of the word Constitution. It means structure. Justice Scalia went on to note the genius of our founding generation is that it dispersed power across multiple departments. The real danger to our constitutional republic is centralization of power in any one part of government. When that happens, liberty dies and tyranny reigns.
That's why it's critical that Supreme Court justices maintain the proper role. They decide cases. They don't make policy. In recent decades, the court has drifted towards a trend where it decides majority disputes over policy rather than reserving those decisions for the American people through acting through their elected representatives, people like those of us in the U.S. Senate. Article 3 judges cannot and should not be policymakers. We've heard many speak today about policy priorities that they'd like an activist court to pass. Several of my colleagues have engaged in fear-mongering and described Judge Barrett's nomination as an end to health care, abortion rights, labor rights, and the list goes on and on and on. These statements are unfair and they're untrue. This week, they'll attempt to have Judge Barrett commit to policy outcomes rather than do the work for that policy outcome in the U.S. Senate. Just last month, while they were falsely claiming Judge Barrett's nomination would bring an end to the protections for pre-existing conditions, every single Democrat on this committee voted against a measure that would do just that. They're failing to do their job, and they want the court to do it for them. My review of Judge Barrett's record convinces me she's not only one of the most qualified individuals ever to be nominated, but she also understands the proper role of the Article 3 branch. She reaches conclusions dictated by the law, not by personal preference. That's the right thing to do. My Democratic friends decry the idea a nominee has predetermined outcome in mind, while in the same breath, they demand the nominee agree to their preferred outcome of a case. The hypocrisy is incredible. They ignore a central fact. Judge Barrett's rulings aren't meant to be for or against a particular policy outcome. She's not a legislator. That's our job. However, when the minority can't get their bad policies passed in Congress, they turn to the courts to demand that judges interpret the law not as written, but as they prefer. Her opinions simply order the outcome the law dictates. As passed by Congress, a politically accountable branch, nothing more and nothing less. My Democratic colleagues claim they care about the First Amendment, the Fifth Amendment, the 14th Amendment. If they care about our constitutional liberties, then they should care about confirming a judge who understands the proper role of the Supreme Court. Rights granted by none can just as easily be ended by none. To quote Justice Ginsburg, real change, enduring change, happens one step at a time. It doesn't happen by judicial fiat. Judge Barrett understands that principle. She knows the role of the Supreme Court justice, and she is highly qualified to do this job. Judge Barrett, when I met with you in the Capitol, I asked you to sign 2 pocket constitutions for my 2 granddaughters, and in it, you wrote, dream big. When they're old enough to understand the significance, I'm going to explain to them that just like Justice Barrett, they can, with hard work and determination, realize their American dream. So for the next few days, when members of this committee mischaracterize your views, their allies in the liberal media are saying terrible things about you and your family, stand tall, stand proud, and stand true. Rely on your faith. I know that you're an inspiration to millions of young women in this country, like my granddaughters, and we're proud of you. Thank you, Judge Barrett, for being with us today. Congratulations on the recognition of your hard work and your character. I look forward to hearing your testimony. Thank you, Mr. Chairman.
Thank you, Senator Tillis. We'll be in recess until 12:20. We'll start back with Senator Hirono.
Hey there, I'm Joshua Johnson. Thank you for joining us on NBC News Now. We're bringing you live coverage of the Senate confirmation hearing of Amy Coney Barrett, President Trump's nominee to the Supreme Court. She is up for the seat that was once held by the late Justice Ruth Bader Ginsburg. This hearing comes 22 days from Election Day. It's a priority for Republican senators who are laser focused on cementing a conservative majority on the court. The Senate Judiciary Committee is taking a break. Now, today is set aside for opening statements from all the senators. We'll hear from Judge Barrett at the end. Here's a little of what we've heard so far.
There's nothing unconstitutional about this process. This is a vacancy that's occurred through a tragic loss of a great woman, and we're going to fill that vacancy with another great woman. This is going to be a long, contentious week. I would just ask one thing of the committee. To the extent possible, let's make it respectful
Let's make it challenging. Let's remember the world is watching.
Chairman Graham promised, quote, if an opening comes in the last year of President Trump's term and the primary process has started, we'll wait till after the next election. Republicans should honor this word for their promise and let the American people be heard. Simply put, I believe we should not be moving forward on this nomination, not until the election has ended and the next president has taken office.
That's just some of what we've heard so far today. A number of senators have yet to speak, including the Democratic vice presidential candidate, Kamala Harris. Today will end with Judge Barrett's opening remarks. Now, during this break, let's get a little perspective on what we've seen and heard so far, including what's happening behind the scenes on Capitol Hill, and that is where we find NBC's Capitol Hill correspondent, Casey Hunt. Casey, what do you make so far of the opening statements? They seem to have a very clear messaging strategy, at least some clear through lines between what Democrats are saying and what Republicans are saying.
Well, sure, Joshua, and I think that that was all telegraphed very far in advance, with Republicans saying this is what the American people, they believe, want them to do, since they control both the White House and the Senate. But of course, that's markedly different from the approach that was taken when President Obama nominated Merrick Garland and Republicans controlled the Senate. Democrats, of course, have been focused primarily on the Affordable Care Act, and you've seen photos of constituents behind Democrats talking about what is on the line for them in the event that the court were to decide against the ACA. They're going to hear a case related to the Affordable Care Act just a little while after the election, which could potentially put the law in jeopardy. So their focus has really been on that. It has been, while they have included Roe versus Wade on a list of things that they're concerned about, should Amy Coney Barrett be confirmed, as we expect, it hasn't necessarily been right at the forefront. And that's partly because, underscoring cultural wars and divisive issues is something that heading into a presidential election may not serve them as well as trying to make this broad-based argument about health care. But Joshua, I will say a lot of the focus today has been about the pandemic and focus on how this hearing is different because of the pandemic and how different senators are handling it. We saw Mike Lee, who of course tested positive for coronavirus, come here in person, take off his mask to give his opening statement, raising a lot of eyebrows. Senator Ted Cruz, who is quarantining because he was exposed to Lee, appeared virtually, and we're also expecting Senator Kamala Harris to appear virtually. Her argument is that Republicans are putting lives in danger by doing essentially what Mike Lee did. And if you'll look at the pictures, and we were just showing some of them, while there certainly are many fewer people in the hearing room than there normally would be for something of this magnitude, there's still a lot of staffers, other senators, members of Amy Coney Barrett's family, et cetera, who are there in the hearing room. So, of course, today she just has to sit there, as my colleague Pete Williams has noted, and listen to all of the senators give their opening remarks before she gives her own. She will face 2 very long days of questioning tomorrow and Wednesday. So we're on the lookout for that, of course, as the week unfolds, Joshua.
Casey, just to build on the point you were making about how the senators are responding to COVID-19, there was a letter that 3 of the Democratic senators sent detailing their reasons for not attending in person, right?
Yeah, and each one of them has kind of personal reasons for not wanting to show up in person, and there's the letter there on your screen. But the bottom line is that they want to apply the same rules to themselves as Americans are applying in their lives in terms of concern about being around people who may have tested positive. We, of course, know that there are many cases linked, at least, to that White House Rose Garden event where Amy Coney Barrett was nominated, and there are pictures, of course, of everyone sitting outside, but there were also, as we know now, there was an indoor component of that event, and that's where we think at least some of these senators may have been exposed to this. Mike Lee was there, Senator Ben Sasse was there, some others as well. Thom Tillis, of course, appeared remotely. He had also tested positive and had symptoms of COVID-19. So very much at the forefront here, Joshua.
Casey, the optics of this hearing are so fascinating to me already, not just between senators who are appearing in person rather than from a distance, virtually, but also just the dais. I mean, by the time this lunch break came, there were pictures behind pretty much the entire row of senators of people whose stories the Democratic senators told who are relying on the Affordable Care Act. Are we to expect more of this kind of, literal political theater as the hearing goes on?
Yeah, I mean, that's essentially what these hearings are in many ways, Joshua, regardless. The outcome here, we pretty much know how this is going to play out, barring something extraordinarily out of the ordinary. And, this being 2020, we don't want to rule anything out. But we know that it's likely Amy Coney Barrett is going to be approved by the committee and then approved on the floor of the Senate by a party line vote. So the question is, how do you make your argument in the meantime to the American people? And this is how Democrats have chosen to do it. Now, when you're not in the middle of a pandemic, you have other tools at your disposal. Oftentimes, if you were opposing a nominee, you might have many of your supporters fill the seats in the hearing room. We've seen, protests in the past. None of that's an option this time around because the public at large is not inside that hearing room. We saw some protests outside one of the doors. I'm standing in one of the Senate office buildings. We saw some protests outside one of the office building doors earlier today. But this is, of course, a tool that Democrats do have at their disposal, printing out these pictures and talking about this. And, they know health care is a winning political issue for them. It was in 2018. People are struggling to pay for their health care in many instances, but they are also very worried about losing their coverage for pre-existing conditions. And with unemployment as high as it is, the pandemic ongoing, the idea that a COVID-19 infection could become a pre-existing condition, all of that means there's an incredible focus on health care, and it shows up in the polling. I mean, Democrats know that's what Americans are focused on right now, and that's why they're focused on it.
All right. Thank you, Casey. That's NBC congressional correspondent Casey Hunt starting us off from Capitol Hill. President Trump is at the White House today. This afternoon, he heads out for a series of campaign rallies that are scheduled this week. Today, he's been watching the hearings and, naturally, tweeting about them. NBC's Peter Alexander joins us now from the White House. Peter, what is happening there? What have we been hearing or reading from the president?
Yeah, Joshua, you're right. It's a pretty easy way to find out what the president's watching. You just look at his feed, and he has been tweeting about this a matter of moments ago, insulting the Democrat from Connecticut, Senator Blumenthal. And before that, he tweeted the following. I'll put it up for you. He says, the Republicans are giving the Democrats a great deal of time, which he says is not mandated, to make their self-serving statements relative to our great new future Supreme Court justice. Personally, I would pull back, approve, and go for stimulus for the people. So there's a lot there to take a look at very quickly in terms of this idea that it's not mandated. It is not mandated that you hear from both parties during these confirmation hearings, but were we not to hear from Democrats and Republicans in terms of their opening statements or in any form, as the president is suggesting, well, frankly, that would be unprecedented. On the issue of the stimulus here, it's striking that the president's saying, let's go for a stimulus deal right now, given he's been so erratic on this issue to this point. You'll remember just a matter of days ago, he said that he didn't want a big deal. Then later he said that he did. So on that issue, there really has been a significant back and forth from the president. But to give you a sense of how crucial this is to this White House, consider the fact that the president's own chief of staff, Mark Meadows, is physically sitting alongside Pat Cipollone, the president's legal counsel, right behind Judge Amy Coney Barrett in that room today. This really, in many ways, is a reprieve for the president from what has been the headline dogging him for a matter of not just days, but weeks and months, of course, the coronavirus, the president, after his diagnosis, going to Walter Reed. And now, for the first time since leaving Walter Reed, we know over the next 4 days he will go to 4 separate rallies in 4 separate states, among them Florida, later today. The president obviously sort of flouting these guidelines that still exist from the CDC. His press secretary, Kayleigh McEnany, earlier today, saying, among other things, that nothing's really going to change in terms of how they do these rallies, that they will still be handing out masks and encouraging people to wear them. But at the end of the day, they say it's up to those individuals what they want to do. But as we've witnessed at all of these events, Joshua, these folks are side by side packed in. So even if they were looking for a way to social distance, if they're attending, that really isn't a very good option for them.
Well, in the rallies tonight, Peter, the president will have at least some things, I think, to talk about with his supporters from today's hearing, although, as Casey mentioned, we kind of knew what was going to be said by Republican lawmakers. He's also been tweeting a lot today about a number of states with Democratic leadership, California, Illinois, et cetera. Do we have any sense of what else we might expect at the rally this evening in Central Florida?
I think you'll see a lot of the greatest hits, so to speak, the points that he's been hammering home, but certainly this is one of them, the hearing that we're seeing today on Capitol Hill, most notably because for the president, as I bring up that idea of this being a reprieve from the coronavirus, this is one of those items that he really hopes that his supporters will focus on, not just the base that he's confident, like those in attendance tonight, that will vote for him, but other conservatives who Republicans fear that their support of the president has eroded during his time in office, that they may like his policies, they may like what he's done to the court, but they don't like his behavior. His hope is that by putting this front and center today, Amy Coney Barrett on national TV, that will help reinforce for them why there's value in supporting President Trump, who, with the expected confirmation of Barrett, would solidify a conservative court for decades to come. Beyond that, the president obviously will focus on things that he's been claiming in recent days. He says that his handling of the virus has been terrific, going after Democrats on that. But what's notable in those tweets that you said today as he attacked Illinois and California, saying that they've turned into a hellscape in recent years, is that this is a president who, of course, is running for re-election. So the idea that a re-election message would be take a look at parts of the country right now that have gone to hell, doesn't seem like it would be a winning strategy.
Thank you, Peter. That's NBC White House correspondent Peter Alexander joining us live. Now, Senator Lindsey Graham addressed the timing of the nomination. In his words, quote, "The Senate is doing its duty," unquote. Democratic Senator Patrick Leahy from Vermont was among those saying that there should not have been a nomination before Justice Ginsburg was even buried. So what does the pace of all of this tell us? And how do the Supreme Court's upcoming cases factor into it? Let's discuss that with NBC Justice correspondent Pete Williams, who joins us now from our Washington bureau. Pete, walk us through some of the upcoming cases the Supreme Court is expected to take up. At least one of them in particular, for sure, has come up with a number of the Democrats who've spoken as a key reason why they say they positively will not support Judge Barrett's confirmation.
Well, there's nothing mysterious about the pace here. I think the Republicans are fairly candid in saying that they want to try to act as quickly as they can while they still control the Senate and the White House. So there's no mystery there. The rule at the Supreme Court is that a justice cannot participate in a case, cannot vote on a case, unless the justice was present when the case was argued. In other words, sort of like the lottery ticket rule, you have to be present to win. So the earliest that she could get confirmed, the Supreme Court has already heard a week of oral argument. They're hearing more oral arguments starting tomorrow. Obviously, she's not going to be able to vote on any of the cases argued this month. So if they can get her on the court by Election Day, then she will be there in time potentially to hear two important cases. The first one is going to be heard actually the day after the election. And we haven't heard a lot about it, but we'll hear maybe more about it tomorrow. And it's this, it asks the court to decide this question of a balance between religious liberty and laws that make it illegal to discriminate. This question has come up before. You may remember the case of the Colorado baker who said he did not want to make cakes for same-sex weddings because it would violate his religious beliefs. The state of Colorado said that violated a law prohibiting discrimination on the basis of sexual orientation. The Supreme Court took a punt on that case and really didn't decide the issue. It's come back this time in a case from Philadelphia. The city has stopped allowing Catholic Social Services, a charity, to place children into foster care because Catholic Social Services says it won't place them with same-sex parents. So that question has come up again. She could potentially vote on that. And then the week after the election is the challenge, the make-or-break challenge to the Affordable Care Act. And I just want to say a little more about this because you've heard a lot about the fact that in 2012, she was strongly critical of the first Supreme Court decision that upheld the Affordable Care Act. What happened was there was a constitutional challenge to the thing known as the individual mandate, the requirement that everybody has to buy health insurance. The Supreme Court said, well, there may be problems with Congress requiring everybody to buy something. Congress may not have that power, but it upheld the Affordable Care Act, saying it was a legitimate use of the congressional taxing authority because you had to pay a penalty on your income tax if you didn't buy health insurance. Well, since then, Congress has done away with the tax. So now the challengers, led by Texas and a bunch of red states, say, well, there's no tax. You can't say it's a legitimate use of the taxing authority. And she might well agree with the challengers on that question, but that won't be the end of the matter, because I think the real issue, the most important issue in the case, is whether that means the entire law is therefore doomed, or whether you can just surgically remove that offending part of a law and leave the rest of it intact. And I don't know how she would vote on that. And frankly, I'm not sure that there's a majority of justices on the Supreme Court, including some of the conservatives, who would say you have to strike down the whole law. So it's certainly true that the Affordable Care Act, it's a make or break decision for the law, but I think that the big question may be how much of the law can survive even if the court finds that part of it is unconstitutional. That's the real question.
I appreciate you breaking down those two cases, Pete, particularly the Obamacare piece of it. I feel like that, under normal circumstances, would be a big focus of the questioning. It certainly will be, I think.
But it already has been.
It already has been. But even beyond that, there is, as Casey mentioned, healthcare is a key issue. Obviously, Obamacare is a healthcare case. But then there's also the matter of coronavirus and the White House announcement that Dr. Anthony Fauci is now referred to as a super spreader event. I wonder what your sense is of what the questioning might be like in terms of all the drama around Judge Barrett's nomination, not just her jurisprudence, her legal philosophy, her writings over the time that she spent teaching at George Washington University and Notre Dame. There's also just her periphery to the president and the president's actions. We heard Senator Blumenthal say that she would need to recuse herself from any case related to the president, or it would do, in his words, explosive, enduring harm to the court's legitimacy and to your own credibility, unquote. So how much does President Trump himself factor into this?
Well, a lot. I mean, the hearing is as much about him and the nominee and about the process as it is about her. In terms of the coronavirus, I think the questions will come up about her own experience with the disease. She apparently tested positive for it this summer. And now her handlers are saying that she's had several negative tests since then. But I guess that's going to be one question, is a question about her own health. Joshua, another question that has come up today is her Catholic faith. And I think this is a careful line that the Democrats have to walk, because you've heard many of the Republicans say it's not proper to question someone's religious faith. And that certainly can't be a litmus test, or you can't use that as a factor in deciding whether or not someone should be confirmed. That's certainly true. But I think the other side of this is that Judge Barrett herself has really raised this question about the effect of religious faith on decision-making for judges. And she did it when she was a law student, when she co-wrote an article about how Catholic judges have to take extra care when they are asked to decide the death penalty. And she basically said that it's a balance there for a judge to decide on Catholic faith versus their requirement to follow the law. So she's been on the record about that before. Now, she was asked about that in her 2017 confirmation hearing, and she said, well, those were my views as a student. I've certainly moved on since then. But that was where, you've heard Republicans many times mention this quote from Dianne Feinstein during that hearing, when she said, the dogma lives strongly in you. And I think that's going to be the difficult thing for the Democrats here, is how to ask her questions about her judicial philosophy, especially when it comes to abortion, without seeming to attack her religious faith.
Yeah, it's one of the pieces of the Constitution we don't hear much about. There are 7 articles to the Constitution, not including the amendments. The 7th one is just the ratification sentence. The very end of Article 6 says, no religious test shall ever be required as a qualification to any office or public trust under the United States. So that does feel like one of those very prickly areas that could come up in terms of Republicans attacking Democrats for the way they're attacking Judge Barrett. Before I let you go, Pete, do you have any sense of what the strategy would be in terms of who leads the attack in what way, or excuse me, who leads the questioning in what ways on the Republican side or the Democratic side? Everyone seems to have a piece of the Affordable Care Act argument in terms of how it would affect everyday people. Senator Chris Coons, I think, was the only person so far who's actually mentioned Roe v. Wade by name. Some of the other senators have alluded to it. I think he's the only one who's actually said it. But do we have any sense of who might be asking what specifically?
No, but I think you're right to say that the Democrats think that the way to make their case is to make this, to sort of humanize the Affordable Care Act issue. The legal issue in the Affordable Care Act is known as severability, which is to say, can you sever part of the law and keep the rest of it intact? But I think that's not a winner for the Democrats, and they've decided to make this much more about the kind of people who would lose their coverage if the Affordable Care Act is struck down, as the challenging states want it to be. And by the way, as the Trump administration says it should be, the Trump administration has switched sides on this issue, initially saying that, yes, you could salvage part of the law, including the individual or the pre-existing conditions requirements and so forth, even if the individual mandates is unconstitutional. Now they say, no, if any part of it is bad, the whole thing has to go. One other thing, Joshua, that I think is worth thinking about here. So Lindsey Graham said at the very beginning that he thinks what's going to happen here is that all the Republicans will vote yes and all the Democrats will vote no. And if that happens, that's enough to confirm her. And from everything we know, he's right about that. If that happens, I've been going back through Supreme Court votes for, well, I'm back to 1881 so far. I can't find another Supreme Court vote that was strictly partisan, either to confirm or not to confirm someone. There have been very close votes over the years. Brett Kavanaugh got just a single Democrat when he was confirmed the last confirmation hearing. But I can't find one where a Supreme Court nomination was strictly along party line votes. I've asked some legal experts who are better historians than I about that, but certainly it would be the most partisan vote in modern history.
I think that's also one of the points that was made, Pete. Granted, I haven't looked as far back as the 1880s, so I will trust your math on this one. But that was one of the other points that was made, I think, by one of the Republican senators, that despite the partisan nature of our politics today, that often justices are confirmed by overwhelming majorities. Supreme Court rulings tend to come down either unanimously, 8-1 or 7-2, trying to kind of put some of the partisanship of the day in context, but we'll see how long that lasts with this particular hearing. That's NBC Justice correspondent Pete Williams. Pete, really appreciate the context. Thank you very much. Now, critics of this hearing say that it's happening too fast, with little regard to the history of how nominations usually work. Let's get some context on that from NBC News presidential historian Michael Beschloss. Michael, what do you make of that argument in terms of the pace of it? Now, granted, if you look at Brett Kavanaugh, Samuel Alito, they were like a 3-month process overall. This is happening rather quickly, and Democrats made a big point of the fact that Senate Majority Leader Mitch McConnell announced that the president's nominee would get a hearing within less than 2 hours of Ruth Bader Ginsburg's death becoming known.
That's exactly right, Joshua. And this would be the justice of the Supreme Court in the history of the United States confirmed the closest to the moment of a presidential election. It's happened 2 times before where this issue particularly came up. One was 1864, which Kamala Harris actually mentioned in the last debate. She was saying that Abraham Lincoln left the nomination to be made and confirmed until after the choice in the 1864 presidential election was known. And I would add in support of that the fact that Lincoln, as it turns out, Joshua, signed a sealed letter and got his cabinet to all sign the envelope that it was in after he sealed it. And the letter said, if I lose the election, I will have to cooperate with the president-elect, which would have been George McClellan, who would have been elected over Lincoln, had very different views, which would suggest that one reason why Lincoln delayed appointing a new justice to fill the vacancy of Roger Taney, who died literally this day in 1864, was because Lincoln, being Lincoln, felt that, especially at a time of war, he should cooperate with the new president and bring the new president in on decisions like this. The other quick example would be 1968. There was a vacancy in the Supreme Court. Lyndon Johnson appointed Abe Fortas. The nomination failed at the beginning of October. Johnson, although one of the most partisan human beings on earth, said, you know, there's going to be an election on the 5th of November. Americans have the right to choose.
One of the arguments that was made earlier today by Senator Mike Lee was that the judiciary is the least dangerous branch of government, basically, that the justices look into the past and not the future. And he accused the Democrats of using tactics that he described as creating fear and uncertainty and doubt. Alexander Hamilton in Federalist Paper 78, I believe it is, said that the judiciary would be the weakest branch, kind of in a similar argument. Yep. And that's one of the themes that's come up today, Michael, is that so much energy has been put into who this one person is, as opposed to the totality of government. I understand where each side is coming from on this, but historically, is this what usually happens when we're trying to confirm a Supreme Court justice?
Has been since 1987, when Robert Bork's nomination to be Supreme Court Justice by Ronald Reagan was defeated by Democrats who said he was too far out of the mainstream, he was too conservative. You're absolutely right, Joshua. I think what I would come back on at you on is that James Madison would have said, I expect at any given time in the future of the United States, one branch may be more powerful than the others. But what we're dealing with right now is the unanticipated result of the decision they made to give justices life terms. They did not imagine at the time the Constitution was written and the decades after that you would have the miracles of modern medicine that, thank God, are allowing people to live to 80 and 85 and 90. But the result is that, unlike those days when they figured that a lifetime appointment might last until someone died, perhaps in their 40s, we're now dealing with twice that.
One more thing I would ask you about, Michael. Senator Sheldon Whitehouse, a Democrat from Rhode Island, referred to Judge Barrett as, in his words, a judicial torpedo they're firing at the Affordable Care Act. And I'm quoting from Senator Whitehouse. Is this kind of tactic, in terms of at least what he's accusing Republicans of, getting a particular nominee to make a particular kind of ruling on a very particular issue, historically, where does that sit?
That is very much in keeping with modern times. When Bork was up for the Supreme Court in 1987, one poll found that 83% of Americans had an opinion on whether he should be confirmed or not. Can you imagine, Joshua, some of the justices that we've had nominated in history? Most people weren't even aware that a justice had been nominated, but 83% of the people had an opinion, and most of them, by the way, their opinion was that Bork should not be nominated because of his views on civil rights and Roe v. Wade and all sorts of other things. So this is the period that we're in. The thing that I'm surprised that more has not been made of yet is that if, God forbid, we have an election next month that is contested with an indecisive result, there's every possibility that that could come to the Supreme Court, just as it did in 2000 with George W. Bush against Al Gore. Imagine if the deciding vote were cast by then Justice Barrett, who had just been nominated by President Trump, rushed onto the court. There's a lot of bitterness from that decision in 2000, but it would be very little compared to what might result from a decision like this if she did not recuse.
Thank you, Michael. Appreciate the context. That's NBC News presidential historian Michael Beschloss. Now, conservatives have praised Amy Coney Barrett's nomination as an opportunity to cement an ideological majority on the court. So what is the judge's background? Tell us about what kind of justice she might be. Joining us now are NBC News legal analysts Barbara McQuade and Danny Cevallos. Good to see both of you. And Barbara, let me start with you. What are some of the big themes that you have noticed that have come up in the opening statements so far?
Well, clearly the Democrats want to remind the public that the Affordable Care Act is at stake and what that means. And looking at Judge Barrett's background, she has expressed hostility to the Affordable Care Act. She was critical when Justice Roberts cast the deciding vote back in 2012 to uphold the Affordable Care Act. She said at the time that she believed that it was decided wrong under the law. And so that's an issue that we have seen. The other issue I think that we've seen is the Republicans seem to be trying to create the false impression that Democrats oppose Judge Barrett as a Supreme Court justice because of her religion and reminding everyone that there is no religious test. Of course, that is not what is going on. What is really going on is Democrats are correctly and appropriately concerned about her history, expressing hostility to a woman's right to choose. And so that's the issue that's at stake. She has now 3 times as a judge had an opportunity to decide cases relating to abortion rights, and all 3 times she has ruled in favor of more restrictions on abortion rights. And so I think those are legitimate areas of concern. Aside from her religion, what's her view and how might she rule in the future on cases about whether to overturn Roe versus Wade?
Now, Danny, the pushback to that from some Republican senators that we've heard from has partly been invoking the memory of Ruth Bader Ginsburg and her deep friendship with Justice Antonin Scalia in terms of their ability to be reasonable with one another, in terms of their ability to at least hear each other out and be collegial, regardless of whether they were on one side of the ideological aisle or another. How persuasive is that, at least to you?
Minimally persuasive, because the way our Constitution is set up, the president appoints justices without regard to the predecessor justice. Now, of course, it becomes a major political issue whether or not the new justice is ideologically the opposite of the previous justice. And that's exactly what you have here. And to go back to what Barb said, I knew Barb would do this. She took my main takeaway, which is that the Affordable Care Act is, as is perceived, on the chopping block. And I think that's something that's fairly raised at this stage. Judge Barrett has expressed some hostility to the Affordable Care Act, both in the Sebelius case, and she has said that the dissent got it right in the King v. Burwell case. So if that came up, you would expect that Justice Barrett might be hostile to the Affordable Care Act. But I think it's more likely that this is a political issue because the Affordable Care Act is a hot issue in the election. It's not something that Judge Barrett has written on or spoken on all that much. And I would just add that, yes, I think that a Justice Barrett might be more willing to allow restrictions on abortion. She has expressed, though, that Roe v. Wade and Planned Parenthood v. Casey is precedent, has been precedent for a long time. It's been relied upon. So she doesn't appear likely to overturn that. However, there's a pretty good argument that the more you restrict abortion, the more you're effectively overturning Roe v. Wade.
Yeah, about that, Barb. Senator Whitehouse noted that in 2013, Judge Barrett wrote about this legal principle of stare decisis and wrote that it is not a hard and fast rule. I think related to what Danny just said, explain why that's relevant. What is stare decisis?
Stare decisis means to stand by things already decided. And so that's the way the Supreme Court operates. If there is a precedent on the books, they are supposed to follow that precedent. Now, there are a few exceptions where courts will decide to overturn precedent, and there are a number of tests that they look at to decide, like how has it worked operationally in practice? Have other laws changed such that that law is no longer valid? And it should not be simply that, well, the composition of the court has changed. We have different people on the court, and now we just think it was wrong and we'll change our minds and switch it. That's not the way it's supposed to work, because having precedent allows people to conform their behavior about the law and have notice about what the law is. What's concerning about Amy Coney Barrett is she has suggested that the text of the Constitution is more important than precedent. She is a textualist. In fact, it is an area where she is actually even more conservative than her mentor and former boss, Antonin Scalia. She has written about this, where he would say, I believe in textualism, but I also recognize that where there is precedent, we must comply with precedent. She says she considers that a flaw that she was willing to overlook in an otherwise brilliant justice.
Danny, you, like Judge Barrett, went to Notre Dame, I believe around the same time that she was studying there. And there's been a lot of talk going into this hearing about how her faith might factor into this nomination. I understand the arguments about how risky politically, potentially, that can be and how slippery a slope that is. There's a long history in this country of anti-Catholic bias, including in the law and in the courts. How do you think that plays out from here?
Judge Barrett has made it very clear in the 20 or so years since she's written on the topic that in the case of a Catholic judge or any religious judge or a judge of no religion at all, cannot let his or her personal beliefs inform their decisions. And in fact, you're going to hear a lot about a law review note that she co-authored 20 years ago when she was a third-year law student at Notre Dame that is about Catholic judges and the death penalty. But the overarching theme of that law review note was that a Catholic judge or a religious judge of any kind must recuse rather than participate in a case in which religious beliefs would play into his or her decisions. Now, the argument against that is that, look, we get all these nominees and they all say the same thing. I'll never let my personal beliefs enter into my decision making. But I would respectfully suggest that Judge Barrett has consistently written on the importance of that topic, and in hewing to Justice Scalia's views, it would bolster her statement that, look, as a judge, I have opinions, but I look at the text. And if the text is unclear, maybe I look at the legislative history. But I don't look at my feelings, and I don't look at the way I think it should be the outcome based on my religion or my personal morality. I mean, that's the core of textualism, which we're going to hear a ton about over the next few days. Actually, I should be clear, it's more the fundamental tenet of originalism, which we are going to hear a lot about in the coming days. But yet, like I said, there's a strong argument to be made that every nominee comes before the committee and says the same thing.
Hey, last quick question, Barbara. A lot of what we are going to see is political theater in a way, not just the substance of the questions, but the way that they're asked. I'm sure there's not one single person on that dais who does not want to get that good soundbite that they can send back to their constituents for their next campaign. How do you expect that to factor into all of this?
Well, we've already seen, Joshua, as you point out, a lot of references to people, for example, who are very sympathetic individuals from a senator's home state who are suffering from pre-existing conditions, and we've seen photos from that. So I think all of that is going to matter. I'll tell you who I'll be listening for carefully is Kamala Harris, because not only is does she have a lot at stake with regard to this hearing, but she also has to realize that people are listening to her on a larger question, and that is the presidential ticket, because she's the vice presidential candidate. She is also a very skilled questioner, having been a former prosecutor. You'll notice that not only is she good at asking questions, she is very good at the follow-up. She does not allow people to evade her questions with careful semantic tricks. She will come back and push them, as she did with William Barr, asking about not only was it said, was it implied, was there an inference? So I'm looking to her to listen very carefully about the kinds of questions that she'll be asking.
NBC News legal analyst Barbara McQuade and Danny Savalos, good to have you both with us. Thank you very much. Let's get back to Capitol Hill, where NBC's Leanne Caldwell is standing by. And Leanne, Casey mentioned earlier that there were some protesters near the hearing, not in the hearing, of course, because of the restrictions over COVID-19. I understand there were about 24 or so protesters at one point nearby. Can you tell us more about that?
Hey, Joshua. So there were about 24 protesters who were arrested, but we do know that there were dozens, perhaps hundreds of protesters on both sides who were outside the hearing, the building where the hearing is taking place. And they were, people who were supporting Amy Coney Barrett. There were also protesters against her. We do know that both sides of the aisle have been organizing, planning these protests for days now. And on the pro-Amy Coney Barrett side, there's going to be prayer vigils, people supporting who are anti-abortion. And this is something that's very common with these Supreme Court hearings. We saw it during Brett Kavanaugh. We've seen it previously. But the difference, as you mentioned, is that they are not inside the hearing room because of COVID precautions. So they are outside. They're also outside the Supreme Court, as you can see. As far as the 21 who were arrested, we're not sure which side they supported, but we do know that they were taken into custody because of some sort of disorderly conduct, and we'll be following up, and we could expect protests to continue throughout the day and perhaps throughout the week. Joshua.
Thanks, Leanne. That's NBC Capitol Hill correspondent Leanne Caldwell. Now, the confirmation hearings are a big issue, obviously, in the presidential campaigns. Election Day is just over 3 weeks away. NBC's Monica Alba joins us now from the White House. And Monica, as we mentioned, the president weighed in on the hearings. Among other things, he tweeted, quote, "The Republicans are giving the Democrats a great deal of time, which is not mandated to make their self-serving statements," unquote. I guess, Monica, we can infer from that that the president is watching live.
Certainly, Joshua, and I think he's been following this all very closely and will continue to. But something I've heard from the Trump campaign allies and advisors close to this president is that they're happy to have the focus elsewhere today and for the rest of these hearings. The fact that you're watching this take place on most cable and networks, and there's a lot more attention being paid to the president hopefully getting what he wants, which is another Supreme Court pick passed through this confirmation process, as opposed to his handling of the coronavirus, the fact that he came down with the illness himself. They see that as something good and an advantage that they can work. And that's also why you're going to see him on the trail in the next couple of days in this absolute campaign blitz, where he's going to be talking about everything you guys have been discussing here this morning as it relates to the hearing. But something really critical that happened just a little bit ago during this break that I think speaks to some of the tensions here between the White House and top health medical officials and experts is you have Chief of Staff Mark Meadows and, of course, the legal counsel, Pat Cipollone, who were both in the hearing room, who've been essentially the Sherpas for Amy Coney Barrett during this process. But Mark Meadows was going to speak with reporters, and then he removed his mask, and our poolers who were there on the Hill asked him to put his mask back on because of his potential exposure, the fact that they're indoors and these are cramped hallways. And Mark Meadows said, I actually would rather not talk to you than speak through a mask. And that really kind of encapsulates where we are. And with these pandemic restrictions, you see them even in the hearing room with senators wearing their masks, removing them to speak, and such a notable image. And optically, what I think we will remember from this week, seeing the nominee herself, Judge Barrett, wearing a mask, and her children and her family in the hearing room as well, wearing those masks, as is mandatory. But if you fast forward to tonight in Florida, where the president is going to be holding a rally with thousands of his supporters, masks will be encouraged and distributed, but they're not required there. So just quite a juxtaposition of important imagery here as we have these dueling events all day, and then
Monica,
the president is also going to be following them up.
We need to get to Senator Lindsey Graham, who is speaking now. Let's listen.
Work today. Restaurants, police officers, you name it, who can't demand they won't come to work unless everybody around them's tested, whether they need to or not. So we're running this hearing safely. It's been set up CDC compliant, and we'll move forward. Thank you.
Thank you.
Of the Senate Judiciary Committee, basically reiterating what he had said before, that the hearing is being conducted as safely as possible, that he worked, he has said in the past that he's worked with the architect of the Capitol to ensure that all of the safety measures that are required are taken into account, and that is why the hearing is proceeding. Looks like Judge Barrett is making her way back. Being asked questions now, not surprised that she would not respond to that. So the hearing is probably going to come back in just a moment. If Monica Alba is still with us, let me ask you one more thing really quickly. With regard to the president, we know he's hitting the road again for rallies across the country in a moment. He has said that he has beaten the virus and that he now may be immune to it. That is unknowable. We do not yet know scientifically whether that's even possible. Monica, what else could we expect from these rallies?
Yeah, I think you raise a really important question there, Joshua, because also the president has now claimed twice that he tested, in his words, totally negative. We haven't seen that kind of assurance or statement in any declarative way from either the White House or his physicians, who we should point out haven't really briefed the press in an entire week since he left Walter Reed Hospital after that stay, after he was initially diagnosed. And the other giant question is when the president last received a negative test prior to that positive diagnosis. So as he prepares to hit the trail, his campaign held a call just in the last hour or so saying he's as energetic as ever, that he can do these 90-minute rallies, which is what we've become accustomed to. He has, again, 4 in the next 4 days in critical battleground states. Right. But over the weekend at his first in-person event, he spoke for only about 18-20 minutes. So that seems to be more of a preview of what we may see tonight. Whether he'll go for that whole hour and a half, we simply don't know, Joshua, but his campaign is very eager to have him on the trail doing some kind of event for the re-elect effort every day between now and November 3rd, just 22 days away.
Back now to the hearing where Hawaii Senator Mazie Hirono is speaking.
Dreams and livelihoods. The White House has become a COVID-19 hotspot, driven by the president's ongoing denial of how serious this pandemic is. Not even contracting the virus and being hospitalized seems to have shaken him back to reality. In normal times, the Senate would be focusing our attention on passing legislation to help the millions of Americans suffering during this pandemic. But these are not normal times. Instead, Senate Republicans are rushing to put a nominee onto the Supreme Court to be the deciding vote to take health care away from millions of people. President Trump has been very clear about what he's doing. He's repeatedly promised to appoint Supreme Court justices who will strike down the ACA. And by nominating Judge Barrett, the president is keeping his promise. In her speech at the White House COVID super spreader event 2 weeks ago, Judge Barrett aligned herself with her mentor, the late Justice Antonin Scalia, who twice voted to strike down the ACA. To help the president keep his promise, our Republican colleagues are rushing to confirm Judge Barrett in a hypocritical, illegitimate process mere weeks before the election. They want Judge Barrett seated just in time to hear the Republican lawsuit challenging the ACA a week after the election. For Americans dealing with this pandemic, it must seem outrageous that Donald Trump and Senate Republicans are determined to take away their health care and are just as determined to do nothing to help Americans with a new COVID relief bill. And they're right. It is outrageous, but it's not surprising. Republicans have made it clear for the past decade that repealing the Affordable Care Act is at the top of their hit list. We know this because a mere 2 weeks after assuming control of the House in 2011, Republicans voted to repeal the ACA for the first time. And over the next 6 years, Republicans took at least 70 votes in Congress to eliminate provisions of the ACA or to repeal it altogether. These repeal efforts culminated in the early morning hours of July 28, 2017, when our late colleague, Senator John McCain, gave his dramatic thumbs down and saved health care for millions by one vote, his vote. Faced with their 70 failures to get rid of the ACA in Congress, Republicans have taken to the courts. Right now, the Trump administration and 18 Republican state attorneys general, including those from Texas, South Carolina, and Missouri, are at the Supreme Court right now trying to strike down the ACA. All arguments in the case are scheduled for November 10th, a mere week after Election Day. This latest legal effort has been turbocharged because of the death of our champion, Justice Ruth Bader Ginsburg, only 3 weeks ago. Her death has changed everything for Donald Trump and Senate Republicans. They are confident that victory at the Supreme Court is now within their grasp if the Senate confirms Judge Barrett through this hypocritical, illegitimate process. The consequences of Judge Barrett's confirmation would be devastating for millions of Americans who would lose their health care during this pandemic. Even in normal times, without the threat of a pandemic, no one in our country should have to confront a major illness worried that it might bankrupt their family. But we all know these are not normal times. Healthcare is the #1 concern for so many people in our country, and they are rightly terrified that Judge Barrett will provide the deciding vote to overturn the ACA and take away their health care. I want to share 2 of their stories today. Kimberly Dickens is from Raleigh, North Carolina. Before the Affordable Care Act, Kimberly couldn't afford health insurance. Thankfully, the ACA enabled her to get health care. She used that coverage to get a checkup and a mammogram, which found her breast cancer. With her health insurance, she was able to get a mastectomy and has been cancer-free since. Kimberly credits the ACA for saving her life. She said, quote, "If it wasn't for the Affordable Care Act, I probably wouldn't have had that mammogram. I was diagnosed early. It scares me to think, if I didn't have insurance, how far advanced would the cancer have grown?" Kimberly's story is not unique. In the years of all the battles of eliminating the ACA, we've heard from hundreds and thousands of constituents across the country sharing their healthcare stories. Dean Oda and his daughter Jordan are from my home state of Hawaii. Jordan, who is an elementary school teacher at Ewa Beach Elementary School, has PNH, a very rare blood condition. To treat this condition, she gets infusions of a special medicine that costs around $500,000 per year without insurance. Dean told me that, quote, without this medicine, she will die. Dean and Jordan live in fear that Republicans will strike down the ACA, which would allow her insurance company to put lifetime caps on her benefits, and she would be left without coverage for her life-saving medication. Dean wrote to me to share how, quote, extremely terrified he is about his daughter losing access to adequate health care under the ACA. He's asked me to fight for her, and that's what I'm doing today. Healthcare is personal to Kimberly, Dean, Jordan, and it's personal to me too, because I know that having health insurance and access to healthcare saved my life. On the day when the Senate confirmed Neil Gorsuch to the Supreme Court, I got a routine chest x-ray before a scheduled eye surgery. A shadow on that x-ray and a later scan led to my diagnosis of stage 4 kidney cancer and gave me time to receive treatment. My diagnosis came as a total shock, and I'm grateful it came when there was still time. I still have cancer, but I don't need any treatment right now. I receive regular scans so that I will know in time if treatment becomes necessary again. I'm grateful for the care I've received and continue to receive from my doctors. The cost of my treatment, which included surgery to remove a kidney, a second surgery to remove part of a rib replaced with a 7-inch titanium plate, almost 2 years of cutting-edge immunotherapy and regular scans has been enormous. It would bankrupt almost every family in this country if they didn't have health insurance. I'm not special or unique. Serious illness can hit anyone unexpectedly. It did for me. And when it does, no one should have to worry about whether they can afford care that might save their life. The Affordable Care Act provided this peace of mind for so many people over the years who found themselves in positions similar to mine. Their lives and their health are what's at stake. Their lives are what's at stake with this nomination. And at moments like this, where the health care of millions is on the line, I think back to the care and concern so many of you showed me when I was diagnosed with cancer 3.5 years ago. So many of you, including many of my Republican colleagues on this committee, wrote heartfelt notes wishing me well and letting me know you were thinking of me. And to this day, when the chairman of this committee and I find ourselves away from the cameras or sharing an elevator, he never hesitates to ask me about my health. He says, how are you doing? Mr. Chairman, you and I have had our pointed disagreements over the years, particularly during our time together on this committee. But your concern means a lot to me. Moments when we recognize our shared humanity are rare in Congress these days. But this can and should be one of those moments. This can be a moment, Mr. Chairman, for you and your Republican colleagues to show the American people terrified about losing their health care the same care and compassion you showed me and continue to show me when I was diagnosed with cancer. Instead of rushing to jam another ideologically driven nominee onto the Supreme Court in the middle of an election when over 9 million Americans have already voted, Mr. Chairman, let's end this hypocritical, illegitimate hearing, return to the urgent work we have before us to help those suffering during this pandemic. Thank you, Mr. Chairman.
Thank you, Senator Rano. I think it's not just me. I think everybody on this committee and everybody that knows you're passionate about your causes. We have a lot of political differences, but all of us are very encouraged to hear that you're doing well, and we'll keep praying for you. You're an asset to the Senate.
I appreciate that. Thank you. Do the right thing.
Okay. Senator Ernst.
Aloha.
Aloha. Senator Ernst.
Thank you, Mr. Chair. And Judge Barrett, thank you so much for being in front of us today. Welcome to you. And of course, I am so glad that you have had your family join you today as well. Only 100 years ago, women in this country were given the right to vote. And today we consider adding another woman to the highest court in the land. And I can't help but be so proud of all of that every one of our women have accomplished in this incredible nation. This is the first time that I've been a member of the Judiciary Committee during a Supreme Court nomination process. And as you probably know, like most Americans, I'm not a lawyer. I bring a slightly different perspective onto this committee. But one thing is very important to me, and it's something that matters to Iowans, whether they are lawyers or not. I firmly believe in the role of our Supreme Court. It is the defender of our Constitution. At the end of the day, that's my test for a Supreme Court justice. Will you defend the Constitution? It frustrates me and it frustrates my fellow Iowans that the Supreme Court has become a super legislature for a Congress that frankly won't come together, discuss these tough issues, and do its job. What I hear from my colleagues on the left is about judicial activism and what they want to see in their nominees, which is that super legislature. They are projecting that upon you, Judge Barrett. That's what they are projecting as they talk about what cases may or may not come in front of the Supreme Court. Matter of fact, I think it was just the other day that Vice President Joe Biden told the American people they don't deserve to know whether he is going to pack the court. They don't deserve to know who his judicial nominees would be. I think we do need to know, again, because it's what the left is projecting on you today, is what they want to see in their nominees. But that's not what our founders intended the court to be. I hope that this hearing will be an open, fair conversation about how Judge Barrett would be as Justice Barrett. I am concerned, however, that not everyone involved in this hearing shares that goal. We've already seen hints in that over the past few weeks, immediately attacking your faith and your precious family. Instead of entering into this nomination process with an open mind and a desire to understand this woman who has been nominated for the highest court in the land, the focus is on a plan or a strategy, a series of tactics to undermine, coerce, and confuse the American people. A plan, Judge Barrett, to undermine you as a person, undermine your family, and undermine what you hold dear. Women all over the world are painfully familiar with this strategy. We are all too often perceived and judged based on who someone else needs or wants us to be, not on who we actually are. I cannot speak for those that would attempt to undermine your nomination, but as a fellow woman, a fellow mom, a fellow Midwesterner, I see you for who you are. And I'm glad the American people have the opportunity to get to know Amy Coney Barrett. This week will be an opportunity to dig into your background further and understand more about your judicial philosophy. But what your political opponents want to paint you as is a TV or cartoon version of a religious radical, a so-called handmaid that feeds into all of the ridiculous stereotypes they have set out to lambast people of faith in America. And that's wrong. It might be less comical if this was the first time the left has trotted out this partisan playbook. Your political opponents have made these types of religious attacks on nearly every Supreme Court candidate nominated by a Republican president in the modern era. And every time, like clockwork, they say they really mean it this time. This nominee, this woman in front of us, she is the absolute worst. I'm struck by the irony of how demeaning to women their accusations really are. That you, a working mother of 7, with a strong record of professional and academic accomplishment, couldn't possibly respect the goals and desires of today's women. That you, as a practicing Catholic, with a detailed record of service, lack compassion. I know you to be compassionate. Your record on the Seventh Circuit says that you are. And more importantly, it shows that your demonstrated commitment is to defending the Constitution. The great freedom of being an American woman is that we can decide how to build our lives, whom to marry, what kind of person we are, and where we want to go. I served in the Army, something not exactly popular at various points in America's history. We don't have to fit the narrow definition of womanhood. We create our own path. Justice Ginsburg was one such woman, and I would like to pay tribute to her for what she did to pave the way for women of today. It's really quite simple what your opponents are doing. They are attacking you as a mom and a woman of faith because they cannot attack your qualifications. Every year, I travel to every single one of Iowa's 99 counties and talk to men and women from all walks of life. Whether they are farmers or nurses or small business owners, they want a government that is accountable to them. When Congress makes a law that oversteps the Constitution, the ripples can be felt, whether it's on farms in Montgomery County, where I'm from, and the manufacturing facilities of Dubuque. It can be felt in the church services of Sioux City and the community meetings in Waterloo. The Supreme Court's only job is to rule on the cases before it and defend the Constitution. To do that well, a justice needs to be thoughtful, restrained, and wise. Judge Barrett, so far I have seen all of those things in you. I am so glad that we have you in front of us. I look forward to learning more about you. I want to thank you and your family for being in this nomination today. And certainly, this, folks, is what a mom can do. Thank you, Judge Barrett, very much. Thank you, Mr. Chair.
Senator Booker.
Thank you, Mr. Chairman. Behind me, Merritt Bowman is a 49-year-old father of twin boys, which you could see, and a football coach and paraprofessional at Deptford High School in New Jersey. For years, Merritt put off going to the doctor because he was, like many Americans, afraid he could not afford it. But when the Affordable Care Act was passed, he finally got the coverage he could afford. 4 years ago, after not feeling well, Merritt made the doctor's appointment and was diagnosed with type 2 diabetes, a disease that affects over 10% of Americans and disproportionately impacts Black Americans like Merritt, who are 60% more likely to be diagnosed with diabetes and twice as likely to die from it. Today, Merritt takes insulin and other medications, and his condition has thankfully improved. Merritt said, and I quote, "Obamacare made it so I was not afraid of the costs of going to the doctor. If I didn't have insurance and didn't get diagnosed, who knows where I would be right now. But Merritt is worried about what will happen if the Affordable Care Act gets overturned. He said, and I quote, "Now I have a pre-existing condition. My insurance covers my medications, my equipment to monitor my diabetes. If that's taken away from me, what's going to happen? I can't afford those on my own." Michelle Luris from Palisades Park, New Jersey, lost her husband, John, last year when he passed away suddenly at the age of 58. Michelle relied on health insurance through John's job, but when he died, their insurance went away. She was given the option to continue his plan, but she couldn't afford the cost of $800 a month. So Michelle signed up for coverage on the insurance marketplace, where she qualified for a subsidy that made it more affordable. Today, she's insured and she can manage her diabetes, heart disease, and an autoimmune disease because of her coverage. Like Merritt, Michelle also relies on insulin and other prescription medications. If the ACA was overturned, Michelle said, quote, "I could lose my house if I didn't have affordable health care. I would have to sell my home. I like where I live. I don't want to lose my home." People like Merritt and Michelle are understandably scared right now. President Trump has told America he would end the ACA. He promised explicitly that he would only nominate judges that would do the right thing and eliminate the Affordable Care Act. People like Merritt and Michelle know what a future without the ACA looks like. It looks like 130 million Americans with pre-existing conditions, from cancer survivors to people with disabilities, being charged more or denied coverage completely. It looks like 20 million Americans losing their access to potentially life-saving care in the middle of a pandemic that's already killed over 214,000 Americans. In New Jersey, we've lost over 16,000 people to COVID-19. 595,000 people would lose their coverage without the ACA. For millions of Americans, a future without the ACA looks like being forced to sell your house if you can't afford your health care. It looks like not having access to a doctor when you're sick. It looks like having to choose between paying for groceries and paying for medicine. And people are scared right now for another reason, because they know what a future without the protections of Roe v. Wade looks like, because President Trump has explicitly stated that he would only put up Supreme Court nominees that would overturn Roe v. Wade. He said it clearly. We should believe him. And that, without Roe v. Wade, our country looks like people being denied the ability to make decisions about their own bodies, not just while they're pregnant, but being stripped of the right to plan for their futures. It looks like women of color, low-income women, and women living in rural areas who can't just pack up and leave if abortion is restricted or criminalized where they live. It looks like them being left with no options. It looks like state laws proliferating throughout our country that seek to control and criminalize women. It looks like the government interfering with women making the most personal medical decisions. It looks like a country in which states may write laws that could subject women who have miscarriages to investigations to ensure they didn't have abortions. In America today, people are scared. You've heard from my colleagues, we are getting calls to our office where people are afraid. More than 214,000 Americans have died, many of them isolated and alone, away from friends and families. Tens of millions of jobs have been lost. 1 in 3 American families with children aren't getting enough food to eat. More than 100,000 small businesses have closed permanently. Lines at food banks in the wealthiest nation on the planet have stretched for miles. We could be, as the Senate, we should be, as the Senate, working in a bipartisan way to try to get this virus under control, to get relief to people who are hurting, who are struggling, who are afraid, to help people who are unemployed, to let doctors and nurses and hospital staffs putting their lives on the line right now in state after state where COVID is rising, know that we have their backs in a pandemic. But instead of doing anything to help people who are struggling right now, we are here. We're here. I'm so glad, I'm really glad that my colleagues who contracted COVID-19 at the Rose Garden Super Spreader event for Judge Barrett had access to the care that you and your families needed. That is right. This is a blessing. The problem is the people who will come through here today to wipe down the desks and empty the garbage, that will vacuum the floor, like people all over our country who are working today in factories, teaching children in schools. They don't have direct line to the nation's top health experts. They can't show up to work sick, and they might not have space to distance themselves at home to protect their families. We literally stopped the Senate from functioning with the exception of this hearing. That's why we're here. We're not just 22 days from an election. We're in the middle of an ongoing election when millions of people have already started voting because Donald Trump and most of my Senate Republican colleagues know the truth. They won't be able to get away with this after the American people have spoken in this election. Donald Trump and my Senate Republican colleagues in this room today know that the American people don't want the ACA overturned. Donald Trump and my Senate Republican colleagues know that the majority of Americans actually don't want Roe v. Wade overturned, that the majority of Americans don't want to see abortion criminalized in our states. But that is exactly why we are here today, because Donald Trump and Senate Republicans know that the American people don't want this, so they have to act now. They don't trust the American people, which is so painful because that's what they said. They said we should trust the American people and what the American people say under President Obama 269 days from an election. And then after that election, they tried time and time again to overturn the Affordable Care Act, but a handful of Republicans stopped them. You see, they tried in the Senate, they tried in the House, over 70 attempts to rip down the Affordable Care Act, but now Donald Trump has said explicitly he's going to do it through the courts by making the nomination we see here today. That's why we are here. The American people should know that that is what this is all about, rushing this nomination through to sit a Supreme Court justice in time to hear a case before the Supreme Court that will end the Affordable Care Act. We're here because in the middle of a deadly pandemic, in the middle of an ongoing election, Senate Republicans have found a nominee in Judge Barrett who they know will do what they couldn't do, subvert the will of the American people and overturn the ACA and overturn Roe v. Wade. That's what this is about. That's why we're here. It's very simple. Senate Republicans know the American people don't want this, but they don't care because they have only one small window of opportunity to work the system, betray what the American people want. And so they're desperately rushing to complete this process before America starts voting, but they don't have to do this. If one of my colleagues will stand up on this committee, we can hold this over until after an election. If two of my colleagues on the Senate floor agree with their other two colleagues, Republicans, we can stop this. Otherwise, this is a charade when they say this is a normal Judiciary Committee hearing for a Supreme Court nomination. There's nothing about this that's normal. It's not normal that Senate Republicans are rushing through a confirmation hearing, violating their own words, their own statements, betraying the trust of the American people and their colleagues, and failing to take in this hearing even the most basic safety protections to protect people around them, all to ensure that tens of millions of people will lose their health care when we're 7 months into one of the worst public health crises in the history of our country. It's not normal. This is not normal that millions of Americans like Michelle and Merritt are just scared of a deadly virus They're scared of their fellow Americans who are sitting in this room right now. They're scared that their government and their institutions will be manipulated by people who could not work through the democratic process to take away their health care and are trying an end run to achieve that. Nothing about this today is normal. This is not normal. What is going on in America today, in the midst of a deadly pandemic and an ongoing election, having a rushed Supreme Court nomination hearing is not normal, and we cannot normalize it. People are voting right now. The American people should decide. The American people should decide. The American people should decide. I will not be voting to confirm Judge Barrett's nomination.
Thank you. Senator Crapo.
I would like to submit a letter for the record, if I may. We should not be rushing, as I said, this process. My colleagues agree with me that we should be working to protect the health and safety of Americans across the country and taking the precautions, greater precautions in this workplace. I'd like to enter into the record a letter from Senators Leahy, Senator Harris, and myself that we sent to the chairman last week, asking that these hearings not proceed without proper testing measures, without all of us being tested and a COVID safety protocol being put into place.
Thank you. Without objection. Senator Crapo.
Thank you, Mr. Chairman. And Judge Barrett, welcome and congratulations on the high honor of your nomination. I have some prepared remarks here, which I will give. But having sat through the speeches that I've heard already and listened to the attacks that have been made, both on Republican members of the committee and on you, I think it's important to just set the record straight on a few items before I then talk about why we are here, and that is you and your qualifications to serve as a justice. So what were the attacks? I'd say the first one is that we're rushing too fast, and that we are violating the rules and norms and precedents of the Senate and speeding into these proceedings. What are the facts? Well, I had my staff check while we were sitting here. This hearing is 16 days after Judge Barrett's announced nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. This case is no different. A couple of examples. Justice Stevens, 10 days. Justice Rehnquist, 13 days. Justice Powell, 13 days. Justice Blackmun, 15 days. Justice Berger, 13 days. These proceedings are following right along in the same kind of process that has historically been the process of the Senate. So then the argument is made that, well, this is an election year, and the Republicans said back in 2016 that in an election year they wouldn't move forward with then President Obama's nomination. What are the facts? A vacancy has arisen in a presidential election year 29 times. Every single one, and this is important to note, every single one of those 29 times, whoever was the sitting president made a nomination to replace the vacancy, to fill the vacancy. Every one of those 29 times. 19 of those 29 times, the parties of the president and the Senate majority were the same. And 17 of those 19 nominees were confirmed. By contrast, of the 10 times in which the Senate was controlled by the party opposite to the president, only one time did the Senate that was not of the party of the president proceed to fill that vacancy. In fact, vacancies under a divided government, meaning a Senate and a presidency from different parties, have not been filled for over 130 years, going back to 1888. So much like when the Senate exercised its constitutional right, fully consistent with precedent in 2016, not to fill the vacancy when there was divided government, the Senate is today exercising its duty to move forward with processing this nomination, just like the vast majority of Senates in the past have done every time this has happened. And it's important to note that. Any claim that this process is unusual or that it violates the clear precedent of the Senate is simply false. So then, back to the attacks on the members of this committee on the Republican side, and frankly against the president. It says that we're trying to engage in court packing. Now, that's a novel one because it's actually the Senate following standard procedure with regard to a vacancy that is now being accused of being court packing, when my colleagues on the other side are actually proposing court packing. That is, to statutorily and with the signature of a president, change the law so that they can add more members to the court. FDR tried this, and his effort was rejected. That effort should be rejected now, but let's be clear about it. This is not court packing. That, threatening to pass a law and change the court, is court packing. So then what were the arguments that were actually leveled against Judge Barrett? Well, the standard arguments. She is going to overturn all protections for women. She is going to change all of the laws in the country that protect people's health care. And everyone in this country who has a pre-existing condition or has any kind of a worry about getting support needs to worry that she's going to be an activist judge and a justice and go in there and change the law. She's not, and we all know that. This is simply the tired, worn-out argument that is constantly made every time a Republican president nominates a candidate for the bench for the Supreme Court of the United States. And it's never been true, and it will not be true with Judge Barrett. So then the attack is, well, the Republicans don't care about people's health. They won't even try to get COVID relief out. And we're here in a hearing in the Judiciary Committee when we ought to be passing COVID relief legislation. And I've heard several of my colleagues basically say the Republicans are refusing to work on helping to address the COVID crisis. This coming from colleagues who just a month or so ago voted unanimously to filibuster a $500 to $600 billion COVID relief package in the Senate. A COVID relief package, I asked my staff to get me a quick summary of it, that put, as I indicated, somewhere between $500 and $600 billion into more small business loans, unemployment insurance, agriculture and farming assistance, postal service assistance, education assistance, both at the higher education levels and at K through 12, healthcare assistance for pandemic preparation, for strategic stockpiles, for testing, for contact tracing, billions for vaccine and therapeutic and diagnostic development, and the list goes on. We were stopped from proceeding with this legislation by a filibuster of those who now accuse us of not wanting to try to do something. We stand ready if you'll simply let us go to the legislation and pass it. So now, Judge Barrett, let me talk about you. Judge, you have an exemplary academic record and legal credentials, and you are preeminently qualified to serve on our Supreme Court. Following your graduation from law school, you clerked for both the U.S. Court of Appeals for the District of Columbia and the U.S. Supreme Court. At the Supreme Court, you clerked, as everyone knows, for none other than the late Justice Antonin Scalia. Upon receiving your nomination to the Supreme Court, Judge Barrett reflected on her clerkship for Justice Scalia, citing his incalculable influence on her life. She also stated that his judicial philosophy is hers too, and that a judge must apply the law as written. That's what we need in our next Supreme Court justice. Rather than the activist justice that you are being accused of being. Judges are not policymakers, and they must be resolute in setting aside policy views that they may hold. And I know you know that. Should we not take Judge Barrett at her word? As a judge, Supreme Court or otherwise, She must be dedicated to interpreting the law as written with an unparalleled commitment to our Constitution. I've visited with her privately. I've reviewed her record. I have seen nothing that would indicate that she is not telling the truth when she says that is her view of how a judge should conduct herself. I've met with a number of Supreme Court nominees in my service in the Senate, and throughout I've continued to maintain an emphasis on following the law and upholding our Constitution, and that must be a central characteristic of the justices we select for this highly influential part of our government. Judges have a great responsibility to carefully exercise their authority within the limits of the law. Our court system has the responsibility to preserve our constitutional rights, ensure a limited government, and provide speedy and fair justice. Following her clerkships, Judge Barrett spent time in private practice before beginning her tenure as a professor. Her academic scholarship and lengthy analysis of issues facing the federal courts make her uniquely well qualified to serve on our nation's highest court. In particular, Judge Barrett's thoughtful exploration of the precedent and the doctrine of stare decisis demonstrates that she is both intellectual and deliberative in her understanding of the law. Moreover, it's evident that she understands the role of a fair and proper judge. In September 2017, Judge Amy Coney Barrett came before the Senate Judiciary Committee, this committee, after being nominated to the U.S. Circuit Court of Appeals for the Seventh Circuit. During that hearing, she repeatedly expressed her commitment to independent and unbiased decision-making. I was proud to support her confirmation to the Court of Appeals in both the committee and on the Senate floor. Judge Barrett's remarkable resume shows she is a pioneer in the legal field. She will be the 5th woman and the first mother of school-age children to serve on the Supreme Court. In many ways, she's the ideal candidate to fill this current vacancy. Mr. Chairman, I look forward to hearing more from the nominee about her experience and her judicial philosophy. The next few days will prove invaluable as we discuss with Judge Barrett at length the proper role of a judge in our legal system. I look forward to this hearing. Thank you, Mr. Chairman.
Thank you. I believe Senator Harris.
Can you hear me?
Yes, hello.
Hello?
We hear you.
This hearing has brought together more than 50 people to sit inside a room for hours. A closed door. Yes.
Just wait just 1 second. We don't see you.
Of course. You don't see me.
One, congratulations on being on the ticket. I hadn't told you that. There we go. All right.
Can you see me now?
Yeah, I can see you now. Hear you loud and clear. The floor is yours.
Mr. Chairman, can you see me and hear me?
I see you. I hear you. The floor is yours.
Okay, I appreciate it. Thank you, Mr. Chairman. This hearing has brought together more than 50 people to sit inside of a closed-door room for hours while our nation is facing a deadly airborne virus. This committee has ignored common sense requests to keep people safe, including not requiring testing for all members, despite a coronavirus outbreak among senators of this very committee. By contrast, in response to this recent Senate outbreak, the leaders of Senate Republicans rightly postponed business on the Senate floor this week to protect the health and safety of senators and staff. Mr. Chairman, for the same reasons, this hearing should have been postponed. The decision to hold this hearing now is reckless and places facilities workers, janitorial staff, and congressional aides and Capitol Police at risk. Not to mention that while tens of millions of Americans are struggling to pay their bills, the Senate should be prioritizing coronavirus relief and providing financial support to those families. The American people need to have help to make rent or their mortgage payment. We should provide financial assistance to those who have lost their job and help parents put food on the table. Small businesses need help, as do the cities, towns, and hospitals that this crisis has pushed to the brink. The House bill would help families and small businesses get through this crisis. But Senate Republicans have not lifted a finger for 150 days, which is how long that bill has been here in the Senate, to move the bill. Yet, this committee is determined to rush a Supreme Court confirmation hearing through in just 16 days. Senate Republicans have made it crystal clear that rushing a Supreme Court nomination is more important than helping and supporting the American people who are suffering from a deadly pandemic and a devastating economic crisis. Their priorities are not the American people's priorities. But for the moment, Senate Republicans hold the majority in the Senate and determine the schedule. So here we are. The Constitution of the United States entrusts the Senate with the solemn duty to carefully consider nominations for lifetime appointments to the United States Supreme Court. Yet the Senate majority is rushing this process and jamming President Trump's nominee through the Senate while people are actually voting, just 22 days before the end of the election. More than 9 million Americans have already voted, and millions more will vote while this illegitimate committee process is underway. A clear majority of Americans want whomever wins this election to fill this seat, and my Republican colleagues know that. Yet they are deliberately defying the will of the people in their attempt to roll back the rights and protections provided under the Affordable Care Act. And let's remember, in 2017, President Trump and congressional Republicans repeatedly tried to get rid of the Affordable Care Act. But remember, people from all walks of life spoke out and demanded Republicans stop trying to take away the American people's health care. Republicans finally realized that the Affordable Care Act is too popular to repeal in Congress. So now they are trying to bypass the will of the voters and have the Supreme Court do their dirty work. That's why President Trump promised to only nominate judges who will get rid of the Affordable Care Act. This administration, with the support of Senate Republicans, will be in front of the Supreme Court on November 10th to argue that the entire Affordable Care Act should be struck down. That's in 29 days that that'll happen. And that's a big reason why Senate Republicans are rushing this process. They are trying to get a justice onto the court in time to ensure they can strip away the protections of the Affordable Care Act. And if they succeed, it will result in millions of people losing access to health care at the worst possible time, in the middle of a pandemic. 23 million Americans could lose their health insurance altogether. If they succeed, they will eliminate protections for 135 million Americans with pre-existing conditions like diabetes and asthma, heart disease, or cancer, a list that now will include over 7 million Americans who have contracted COVID-19. Insurance companies could deny you coverage or could sell you a plan that won't pay a dime toward treating anything related to your pre-existing condition. If the Affordable Care Act is struck down, you will have to once again pay for things like mammograms and cancer screenings and birth control. Seniors will pay more for prescription drugs, and young adults will be kicked off of their parents' plans. And these are not abstract issues. We need to be clear about how overturning the Affordable Care Act will impact the people we all represent. For example, Micah, who is 11 years old, and she lives in Southern California. So Micah enjoys being a Girl Scout, and ice skating, and reading, and eating pasta, and baking. Her mother says the only reason Micah is able to live her life as she does now is because the Affordable Care Act guarantees that her health insurance cannot deny her coverage or limit her care because it's too expensive. You see, Micah has a congenital heart defect. She goes to multiple specialists throughout the year and gets an MRI with anesthesia every 6 months. At just 11 months old, Micah's family had already hit $50,000 in medical expenses, and her biannual MRI cost were $15,000 a session. And so, correction, by 11 months old, her family had hit $500,000 in medical expenses. If Republicans succeed in striking down the Affordable Care Act, insurance companies will be able to deny coverage for children with serious conditions. Children like Micah. And parents, well, they'll be on their own. No one should face financial ruin to get their child or their spouse or their parent the care they need. And no family should be kept from seeing a doctor or getting treatment because an insurance company says that the treatment is too expensive. In America, access to health care should not be determined based on how much money you have. Health care and access to health care should be a right. Micah and millions of others who are protected by the Affordable Care Act know this is fundamentally what is at stake with this Supreme Court nomination. And of course, there's more at stake. Throughout our history, Americans have brought cases to the United States Supreme Court in our ongoing fight for civil rights, human rights, and equal justice. Decisions like Brown versus Board of Education, which opened up educational opportunities for Black boys and girls. Roe versus Wade, which recognized a woman's right to control her own body. Loving v. Virginia and Obergefell v. Hodges, which recognized that love is love and that marriage equality is the law of the land. The United States Supreme Court is often the last refuge for equal justice when our constitutional rights are being violated. Justice Ruth Bader Ginsburg devoted her life to fight for equal justice, and she defended the Constitution. She advocated for human rights and equality. She stood up for the rights of women. She protected workers. She fought for the rights of consumers against big corporations. She supported LGBTQ rights, and she did so much more. But now, her legacy and the rights she fought so hard to protect are in jeopardy. By replacing Justice Ruth Bader Ginsburg with someone who will undo her legacy, President Trump is attempting to roll back Americans' rights for decades to come. Every American must understand that with this nomination, equal justice under law is at stake. Our voting rights are at stake. Workers' rights are at stake. Consumer rights are at stake. The right to a safe and legal abortion is at stake. And holding corporations accountable is at stake. And again, there's so much more. So, Mr. Chairman, I do believe this hearing is a clear attempt to jam through a Supreme Court nominee who will take health care away from millions of people during a deadly pandemic that has already killed more than 214,000 Americans. I believe we must listen to our constituents and protect their access to health care and wait to confirm a new Supreme Court justice until after Americans decide who they want in the White House. Thank you.
Thanks, Senator Harris. Senator Kennedy.
You have a beautiful family, Judge. We claim you in Louisiana. We're proud of the fact in Louisiana that you were born in Metairie, a suburb of New Orleans. We're proud of the fact that you got a solid education at St. Mary's Dominican High School. Come back and visit us. I know your mom and dad still live there, and we're very proud of you and your career. This is a solemn occasion, as it should be. I can't think of another position, at least not a position that is for life, not a position in which the occupant is not elected by the people, that is more powerful, at least not in the Western world, than an Associate Justice of the Supreme Court. And this process is not supposed to be the Big Rock Candy Mountain. Our job is to advise and consent. And that's one way of saying that we're supposed to make sure that the president hasn't whatever president makes the nomination, hasn't made a mistake. And we all, as you can see, take that job seriously, as you can see, and we know you respect that. That's why I think over the next several days, it's appropriate for us to talk about your intellect, which is obvious, by the way, and your temperament, your character, and your judicial philosophy. And I hope we can talk about something else. And that's the role of the federal judiciary in American life. Now, look, Judge, I'm not naive. I understand this thing can turn sour real fast. We all watched the hearings for Justice Kavanaugh. It was a freak show. It looked like the cantina bar scene out of Star Wars. And I know, for someone unaccustomed to it, that it hurts to be called a racist. I think it's one of the worst things you can call an American. I know that it hurts to be called a white colonialist. And I know it must hurt for someone of deep Christian faith like yourself to be called a religious bigot. And to have it implied that because you are a devout Christian, that you're somehow unfit for public service. Before it's over with, they may call you Rosemary's Baby, for all I know. I hope not. And I know, as we've seen this morning, I know you think it's unfair. It is unfair for my colleagues to suggest, some overtly, some more indirectly, that if you're put on the United States Supreme Court, you will be on a mission from God to deny health care coverage for pre-existing conditions for every American. I know that seems preposterous to you, and it seems that way because it is. Take comfort in the fact that the American people, some of my colleagues disagree with this statement. They believe in government. I believe in people. The American people are not morons. They can see drivel when they see it, and they can appreciate it when they see it for being what it is. Now, let me turn to what I hope quickly we can talk about today. Americans love democracy. We'll even fight for it, and we have. And that's a wonderful thing. It's an important thing in today's world as this world becomes more authoritarian. And our founders, but we don't have a pure democracy. As a columnist I read this morning said, when we have to decide a complex issue dealing with social norms or economic issues, we don't all put on a toga and go down to the forum and vote. We have elected representatives. Those are members of Congress. And it is our elected representatives' job to decide social and economic policy. And if we don't like what they do, they're accountable. We vote them out. But in the last 50 years, certainly in the last 25, the United States Congress, either voluntarily or involuntarily, has ceded a lot of its power to the executive branch and to the federal judiciary. When I say the executive branch, I'm not necessarily talking about the president. I'm talking about the administrative state, the bureaucracy, as some call it. It's this giant rogue beast that enjoys power now that only kings once enjoyed. Members of the administrative state write their own laws. They interpret their own laws. They litigate their own laws in their own courts before judges that they appoint. And Congress has allowed that to happen. I think Congress has also abdicated a lot of power to the federal judiciary. I do. And I'm not saying that federal judges don't make law. Of course they make law. They make law in the context of a specific case. It's called judicial precedent. But our founders intended federal judges to exercise judicial restraint and to understand the special role, scope, and mission of the federal judiciary vis-a-vis the United States Congress. I don't think our founders intended judges to be politicians in robes. I think our founders intended judges, federal judges, to tell us what the law is, not what the law ought to be. I think our founders intended, as the Chief Justice put it, I think our founders intended federal judges to call balls and strikes. I don't think our founders intended for federal judges to be able to redraw the strike zone. I don't think our founders intended for judges to be politicians in robes. Politicians, you don't want the United States Supreme Court to turn into this. Trust me. Politicians get to vote their preferences under our democracy. Judges do not. Judges do not. And finally, unlike some of my colleagues, I don't think our founders intended the United States Supreme Court to become a mini Congress. I don't think our founders intended members of the United States Supreme Court to try to rewrite our statutes or the United States Constitution every other Thursday because to prosecute a social or an economic agenda that they can't get by the voters. And that goes on in America every day. We've reached the point where one single solitary federal judge in a limited venue can enjoin a federal statute or an executive order of the President of the United States for the entire country. And our founders never intended that. I want to close with two very short quotations. The first, stated much more eloquently than I can, is Justice Curtis in 1857. You probably read it. He was dissenting in the Dred Scott case. This is what Judge Curtis said. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We're under the government of individual men who for the time being have power to declare what their Constitution is according to their own views of what it ought to mean. And finally, a more contemporary statement from a gentleman that you're very familiar with, Justice Scalia. He said it in real world terms. This is what he said. The American people love democracy, and the American people are not fools. The American people know their value judgments are quite as good as those taught in any law school, maybe better. Value judgments, after all, should be voted on, not dictated. Thank you, Mr. Chairman.
Thanks, Senator Kennedy. Senator Blackburn.
Thank you, Mr. Chairman. Judge Barrett, congratulations to you and to your family. I'm delighted to see that they are back in the room, and I'm thrilled that they are here with us today. You know, we have had 164 American citizens come before this committee for nomination to the Supreme Court, and today is the 5th time that we have had a female judge come before us, so we welcome you. And I will say this, unfortunately, it's neither rare nor remarkable to see the kind of performances my Democratic colleagues have put on today. What they're trying to do is to convince the American people that they should be terrified of Judge Amy Coney Barrett. If you listen closely to their full statements, it betrays their true intent. If you go back through the transcript, you're going to find not a coherent legal counterargument, but a panicked stump speech on behalf of their controversial platform. Rather than reviewing your judicial philosophies, they're instead choosing to project their own desires and their fears onto the American people. It sounds as if they are trying to create a panic. They decided to drum up indignation over the fact that you dared to present a counter-argument against the constitutionality of the Affordable Care Act. Apparently, a difference of opinion between two brilliant jurists who often disagree is just too much for them. The rhetoric is unsettling, but after listening to them, I worry more about its underpinnings because my colleagues' remarks have displayed their troubling belief that nothing but an activist judiciary will do for them. Given your track record, you'd think that my colleagues would jump at the opportunity to support a successful female legal superstar who is highly regarded by both her Democratic and Republican colleagues and who is a working mom. But as today's increasingly paternalistic and frankly disrespectful arguments have shown, if they had their way, only certain kinds of women would be allowed into this hearing room. On that note, not so long ago in another hearing, they scrutinized your commitment to your Catholic faith and tried to use that as a way to question your competency and your professionalism. They know that that is unconstitutional. The Constitution forbids it. You are a brilliant jurist and a constitutional law expert. You will be an intellectual powerhouse on the Supreme Court, and you will steer the panel's focus toward textualism and originalism as rightful guiding philosophies. I love Justice Scalia's definition of textualism. Textualism in its present form begins and ends with what the text says and fairly implies. He goes on to defend textualism and explains that this method can lead to both conservative and liberal outcomes. Similarly, originalism doesn't always lead a jurist down the path they'd most like to follow. This method of interpretation holds that the meaning of a legal document, such as the Constitution, remains fixed, even when applied over time to new questions. Staying true to these guidelines requires more study and patience than other methods that allow judges to reinvent the law or be activists when things get tricky. Since taking the bench, I appreciate that you have written over 100 opinions and have participated in over 900 appeals where you have applied this complex reasoning. Thank you for that. We know that you are a prolific scholar and author of over a dozen articles on the courts and the Constitution. The ABA has rated you as well qualified to serve as a Supreme Court justice. I appreciate that many times you've probably done this with the child in your arms, on your hip, or somewhere in tow, maybe waiting for a ball game to begin. You have done all of this as you have been a friend, a mentor, a wife, and a mom. These are impressive qualifications by any standard. So it is no surprise that you are fielding attacks from other angles. Many of my colleagues have wasted a lot of their time complaining that the process, in an effort to delay and obstruct a legitimate, constitutionally sound confirmation hearing. Let's not forget, it was the Democrats who took an axe to process in 2018. when they dropped last-minute, unsubstantiated sexual assault allegations against Justice Kavanaugh. We still don't have the full story about their level and manner of coordination with activists and mainstream media outlets, but what we do know is that they turned that confirmation into a circus. And on that note, it is hard to take seriously their complaints about moving too quickly. We've heard about the timeline for Justice O'Connor, 33 days, Justice Ginsburg, 43 days. And just a word on Justice Ginsburg, whose seat we are filling. She was indeed a role model for many because she fought to open more doors for women in the law and beyond, and I sincerely hope that I am as effective an advocate in the Senate as she was on the court. We know from studying American history that women have had to always fight for a seat at the table. This goes back to Abigail Adams, who urged her husband, John, to please remember the ladies in their fight for independence. And we know it took 150 years for women to get that right to vote, but the Constitution allowed for that amendment process. Unfortunately, what we see today is that radical activists would like nothing more than to take a hatchet to process. Their favorite play is confronting the American people with the supposed illegitimacy of the Constitution. They argue that our founders' flaws, and yes, they were flawed. All humans are. That the flaws invalidate the principles that bind this country together. This betrays a dangerously naive understanding of the point and purpose of our founding legal document. The timeless principles contained in that document were written to protect individual rights, absolutely. These principles, of course, include the separation of powers and federalism in our government, a system of checks and balances that prevents encroachment by one branch or another. If Congress acts beyond the scope of its legislative authority or the president grows too power hungry, the judiciary has the authority to rein that branch back in. And if the vast bureaucracy dares to overregulate, states and their citizens have the right to stand up and challenge that overreach as being beyond the scope of federal power. Together, the separation of powers and federalism have protected our republic from falling into the hands of tyrants. But keep in mind that the founders despised the tyranny of British rule just as much as they despised the whims of the mob. Flash forward to today, when American exceptionalism is under bitter attack from yet another mob. While most Americans take pride in our heritage, a vocal minority finds fault at every turn. They demand to know, can we still call the Constitution a relevant, valid source of law, even if no women or people of color participated in the drafting? Are the principles in that document still capable of curbing abuses of power and safeguarding freedom? Can we have faith that the future of democracy remains strong despite a summer of looting and violence in the streets? The answer to each is yes. And over the next few days, I expect that you, Judge Barrett, will explain why. So many families are watching today, and we're all going to be listening. Thank you for appearing before us. We look forward to your answers.
Thanks, Senator Blackburn. I have two letters I'd like to submit for the record. One from the architect of the Capitol, showing that the room is CDC compliant. We'll introduce that. And we do have the ABA rating regarding Judge Barrett. I'll introduce it in the record, but it's fairly short, so I'll just read it if that's okay. The American Bar Association Standing Committee on the Federal Judiciary has completed its evaluation of the professional qualifications of Judge Amy Coney Barrett, who has been nominated by the President to be an Associate Justice of the Supreme Court of the United States. As you know, the Standing Committee confines its evaluation to the qualities of integrity, professional competence, and judicial temperament. A substantial majority of the Standing Committee determined that Judge Barrett is well qualified and a minority is of the opinion that she is qualified to serve on the Supreme Court of the United States. The majority rating represents the Standing Committee's official rating. Enter that into the record. Now we have a...
Mr. Chairman.
Yes.
Could you explain what CDC compliant means?
It means that the room is set up, social distancing regarding the virus, that the architect of the Capitol measured the space. And as to me, I was tested a week ago Friday, had brief contact with Senator Lee. I was negative. I've been told by Senator Moynihan and a physician in South Carolina, there's no requirement to test me. I feel fine. My exposure is not such that I should be quarantined or tested. Anybody that wants to get tested, they can. And I made a decision to try to make the room as safe as possible, but to come to work. Well, millions of Americans are going to work today. Somebody may have tested positive in a restaurant, a military unit, fire department, or police department. You make it as safe as possible, you manage the risk, and you go to work. I'm not going to be told to be tested by political opponents. I'm going to be tested as an individual when the CDC requires it. I think we can safely conduct this hearing. We have, and I think it's off to a good start. So I do care about everybody's safety. But as a lot of Americans out there, we have to go to work, and you can't demand not to show up to work unless everybody you may come in contact with is tested whether they need to or not. And we're not going to do that here. Now we have a panel.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy, for that question. We have three people, our two colleagues from Indiana, Senator Todd Young and Senator Mike Braun. I know Louisiana adopts our judge here, but she is living now in Indiana. And the third is Professor Patricia O'Hara, who I'd like to briefly introduce. Professor O'Hara is Professor Emerita, I hope I got that right, of law at Notre Dame Law School. She has served on the faculty for 40 years. She first arrived in Notre Dame in 1971 as a first-year law student. She graduated summa cum laude and first in her class in 1974. Described as the heart and soul of Notre Dame for over 40 years by current Notre Dame Law Dean G. Marcus Cole, Professor O'Hara's career at Notre Dame was that of a trailblazer. She was the first woman to graduate first in her class from Notre Dame, the first woman appointed by the Board of Trustees to serve as an officer of the university as Vice President for Student Affairs, and the first woman to serve as Dean of the Law School. So with that, we'll start with Senator Todd. I think all these individuals are remote. Senator Todd. Todd Young.
Well, thank you, Chairman Graham, Ranking Member Feinstein, and members of the committee. Today, I join you in the shadow of Monument Circle in Indianapolis, Indiana. I am honored to appear before you to introduce Judge Amy Coney Barrett, a remarkable Hoosier poised to make her mark on our country. She truly is an American original. In 2017, when there was an opening on the U.S. Court of Appeals for the Seventh Circuit, my office began looking for an extraordinary American who would uphold the rule of law. In response, we received dozens of applications from many of the finest legal minds in the state of Indiana. My staff and I began researching in earnest to learn everything we could about each candidate to determine who among them would make the best judge. And I interviewed the best of the best. One of those was a constitutional law professor from the University of Notre Dame by the name of Amy Coney Barrett. I first met with then Professor Barrett in the spring of 2017, and it was abundantly clear that she was a star. A brilliant legal scholar, she was and is held in the highest regard by her peers in the legal world. Her integrity and character are unimpeachable. She's a model of collegiality and fairness. And simply, she possessed all of the necessary qualities to be a great appellate court judge then and to be a great Supreme Court justice now. My colleague, former Senator Joe Donnelly, and I approved of her nomination, and a hearing was set. Unfortunately, some resorted to attacks on Judge Barrett's religious convictions. I can tell you that in Indiana and much of the country, faith is viewed as an asset in a public servant, not a liability. As Notre Dame President Father Jenkins reminded us then, being a person of faith doesn't interfere with one's ability to apply the law. Thankfully, Judge Barrett's qualifications outshone personal attacks, and she was confirmed by a bipartisan majority to the U.S. Court of Appeals for the Seventh Circuit. As a member of that court, Judge Barrett's proven that she is a rather brilliant jurist who interprets the Constitution as written and carefully weighs the facts of a given case. She's heard more than 600 cases on the Seventh Circuit and authored nearly 100 opinions. And I should note, she is the first woman from Indiana ever to serve on that esteemed court. During that Seventh Circuit interview back in 2017, it was obvious that Judge Barrett loved the law and the Constitution. Her love for her family, her husband Jesse, and their 7 children was also clear. If confirmed, Judge Barrett will be the 5th woman and the first mother of school-aged children to serve as a Supreme Court justice. Now, being a parent doesn't qualify one to sit on the Supreme Court, but it does give us Hoosiers yet another reason to be proud of Amy Coney Barrett and the trail she's blazed leading her to this moment. Education, faith, family, community, equal justice under the law. These are all values that Midwesterners hold dear. Indeed, they are values that Americans hold dear, and they are all values embodied by Judge Barrett. Author Kurt Vonnegut, another American original from Indiana, once said, "I don't know what it is about Hoosiers, but wherever you go, there's always a Hoosier doing something very important." Where Amy Coney Barrett has gone, she has always been doing something very important, from raising a family to educating the next generation of scholars to administering justice on the Court of Appeals. It's my hope that this body will confirm Judge Barrett in a bipartisan fashion so that we will soon find another Hoosier doing something very important on the Supreme Court of the United States. Thank you, Mr. Chairman.
Thank you very much, Senator Young. Senator Braun, were we able to connect with him? We're having some technical problems. We're good? Senator Braun.
Yeah, you're good. Okay, we're good.
Mike,
Tell Jason.
can you hear me?
I can hear you.
All right, floor is yours.
Chairman Graham?
Yeah.
Hey, Chairman Graham, Ranking Member Feinstein, it's an honor for me to join Senator Young and Professor Emerita O'Hara to introduce a fellow Hoosier who makes our state proud. I'm doing this from my hometown, Jasper, Indiana, at City Hall, literally, and we're on Main Street. And figuratively, from a place, town, state that represents a broad cross-section of our country. In 2013, Justice Antonin Scalia wrote that the federal judiciary is hardly a cross-section of America. Today, it's still easy to see what he meant. When confirmed, Amy Coney Barrett would become the only justice of the Supreme Court who spent the majority of her professional life in Middle America, not on the East Coast. When confirmed, she will be the only sitting justice who did not receive her law degree from Harvard or Yale. Yet her Notre Dame law credentials are also from a first-rate university. When confirmed, she will be only the 2nd current justice to join the court from west of the nation's capital. When this vacancy arose, I was the first to voice my support for a nominee from the Midwest because I believe we need more judges who understand those Midwestern values that guide our lives: faith, family, community, and a respect for the law. Amy Coney Barrett is that quintessential Midwesterner, hardworking, generous, humble. She's a top-flight law scholar who's just as comfortable at the Saturday morning tailgate as she is in the ivory tower a legal titan who drives a minivan. I immediately supported Judge Barrett's nomination, not only because she is a highly qualified jurist, but because she's proven both on and off the bench that she has the decency and fundamental respect for our country and its Constitution to serve honorably. And now I'd like to say a word about faith. Much will certainly be made in the coming days of Judge Barrett's Catholic faith and how she practices it. It's a faith that I and many Americans share. Our founders anticipated this question, and as they so often do, got it right. Liberals and conservatives alike are bound by the Constitution's firm edict that no religious test should ever be required as a qualification to any office or public trust under the United States. I believe hostility toward Judge Barrett's religious beliefs today could set a dangerous precedent of hostility toward other religious beliefs tomorrow. Judge Barrett has been clear in her public life where she falls on the question of faith and the law. As she concluded in a 1998 essay, we're sure to hear cherry-picked over the next few weeks, judges cannot, nor should they try to, align our legal system with the church's moral teaching whenever the two diverge. Faith is very important to most Americans, and I agree that faith should be a key word in Judge Barrett's confirmation. But I believe the most important question of faith should be, is she willing to faithfully interpret the Constitution? Judge Barrett's record shows that she will. Throughout her nearly 100 written opinions on the appellate court, Judge Barrett has proven that she is a strong constitutional originalist who will not cut the American people out of their own government by treating the Supreme Court as a third chamber of Congress. On the bench, her qualifications are beyond question. Off the bench, she exemplifies the generosity and character Hoosiers are known for. And she has lived a life rooted in those heartland values I mentioned before: faith, family, community, and respect for the law. Hoosiers should be proud to have Amy Coney Barrett serving and representing our state currently. And I believe she will make all Americans proud as a justice of the Supreme Court. Thank you.
Thank you, Senator. Professor O'Hara. Professor?
Pop back up.
Is the professor with us? Professor, could you count to 10, please? Could you speak? If you can hear me. Professor O'Hara, if you can speak up. If you hear me, please speak up. Okay. I don't know, she must be in the 3G part of Indiana.
Photograph him?
Can see if we're in contact with her at all. Is it working? Professor, could you speak up, please?
Suggest that she unmute her mic.
You need to unmute your mic, I've been told, Professor O'Hara. How did she do that?
She just tapped it. Must have said the code.
Put a quarter in it, I don't know. You're not going to give us a quarter, I know that. Can she hear us? Well, I'm afraid we have technical difficulties, and I guess what we'll do now, if you can fix them in the next 30 seconds, let me know. If not, Judge Barrett, we will hear from you. Any progress with Professor O'Hara? Okay, Judge, if you don't mind, you can take your mask off, please. Raise your right hand. Stand up, please. Do you solemnly swear that the testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Welcome to the committee, to your family. Y'all have done a great job over there. The floor is yours, Judge.
I'm not sure this is on. Ranking Member Feinstein and members of the committee, I'm honored and humbled to appear before you today as a nominee for Associate Justice of the Supreme Court. I thank the President for entrusting me with this profound responsibility, as well as for the graciousness that he and the First Lady have shown my family throughout this process. I thank Senator Young for introducing me, as he did at my hearing, to serve on the Seventh Circuit. And I also thank Senator Braun for his support. And while she could not be with us via the satellite, I am also grateful to former Dean Patty O'Hara of the Notre Dame Law School. She hired me as a professor nearly 20 years ago, and she has been a mentor, colleague, and friend ever since. I thank the members of this committee and your other colleagues in the Senate who've taken the time to meet with me since my nomination. It's been a privilege to meet you. As I said when I was nominated to serve as a justice, I'm used to being in a group of 9, my family. Nothing is more important to me, and I'm very proud to have them behind me. My husband, Jesse, and I have been married for 21 years. He has been a selfless and wonderful partner every step of the way. I once asked my sister, "Why do you think marriage is hard? People are always saying that." "I think it's easy." And she looked at me and said, "Well, maybe you should ask Jesse if he agrees with that." I decided not to take her advice because I know that I am far luckier in love than I deserve. Jesse and I are parents to 7 wonderful children. Our oldest daughter, Emma, is a sophomore in college who just might follow her parents into a career in the law. Next is Vivian, who came to us from Haiti. When Vivian arrived, she was so weak that we were told she might never talk or walk normally. But now she deadlifts as much as the male athletes in our gym, and I assure you she has no trouble talking. Tess is 16, and while she shares her parents' love for the liberal arts, she also has a math gene that seems to have skipped her parents' generation. John Peter joined us shortly after the devastating earthquake in Haiti. And Jesse, who brought him home, still describes the shock on JP's face when he got off the plane in wintertime Chicago. Once that shock wore off, JP assumed the happy-go-lucky attitude that is still his signature trait. Liam is smart, strong, and kind, and to our delight, he still loves watching movies with Mom and Dad. 10-year-old Juliet is already pursuing her goal of becoming an author by writing multiple essays and short stories, one of which she recently submitted for publication. And our youngest, Benjamin, is at home with friends. Benjamin has Down syndrome, and he is the unanimous favorite of the family. He was watching the hearing this morning, I'm told, and he was calling out our names as he saw the kids in the back. My own siblings are here, some in the hearing room and some nearby. Carrie, Megan, Eileen, Amanda, Vivian, and Michael are my oldest and dearest friends. We've seen each other through both the happy and hard parts of life, and I am so grateful that they are with me now. My parents, Mike and Linda Coney, are watching from their New Orleans home. My father was a lawyer and my mother was a teacher, which explains why I became a law professor. More important, my parents modeled for me and my 6 siblings a life of service, principle, faith, and love. I remember preparing for a grade school spelling bee against a boy in my class, and to boost my confidence, my dad saying, "Anything boys can do, girls can do better." And at least as I remember it, I spelled my way to victory. I received similar encouragement from the devoted teachers at St. Mary's Dominican, my all-girls high school in New Orleans. When I went to college, it never occurred to me that anyone would consider girls less capable than boys. My freshman year, I took a literature class filled with upperclassmen English majors. And when I did my first presentation, which was on Breakfast at Tiffany's, I feared I had failed. But my professor took the time to talk to me. She filled me with confidence about how well I had done, and she became a mentor. And when I graduated with a degree in English, she gave me Truman Capote's collected works as a gift. Although I considered graduate studies in English, I decided that my passion for words was better suited to deciphering statutes than novels. I was fortunate to have wonderful legal mentors, in particular, the judges for whom I clerked. The legendary Judge Lawrence Silberman of the D.C. Circuit gave me my first job in the law, and he continues to teach me today. He was by my side during my Seventh Circuit hearing. He swore me in at my investiture, and he's cheering me on from his living room right now. I also clerked for Justice Scalia, and like many law students, I felt like I knew the justice before I ever met him, because I had read so many of his colorful, accessible opinions. More than the style of his writing, though, it was the content of Justice Scalia's reasoning that shaped me. His judicial philosophy was straightforward. A judge must apply the law as it is written, not as she wishes it were. Sometimes that approach meant reaching results that he did not like. But as he put it in one of his best-known opinions, that is what it means to say that we have a government of laws and not of men. Justice Scalia taught me more than just law. He was devoted to his family, resolute in his beliefs, and fearless of criticism. And as I embarked on my own legal career, I resolved to maintain that same perspective. There's a tendency in our profession to treat the practice of law as all-consuming while losing sight of everything else. But that makes for a shallow and unfulfilling life. I worked hard as a lawyer and as a professor. I owed that to my clients, to my students, and to myself. But I never let the law define my identity or crowd out the rest of my life. A similar principle applies to the role of courts. Courts have a vital responsibility to the rule of law, which is critical to a free society. But courts are not designed to solve every problem or right every wrong in our public life. The policy decisions and value judgments of government must be made by the political branches, elected by and accountable to the people. The public should not expect courts to do so, and courts should not try. That is the approach that I have strived to follow as a judge on the Seventh Circuit. In every case, I have carefully considered the arguments presented by the parties, discussed the issues with my colleagues on the court, and done my utmost to reach the result required by the law, whatever my own preferences might be. I try to remain mindful that while my court decides thousands of cases a year, each case is the most important one to the litigants involved. After all, cases are not like statutes, which are often named for their authors. Cases are named for the parties who stand to gain or lose in the real world, often through their liberty or livelihood. When I write an opinion resolving a case, I read every word from the perspective of the losing party. I ask myself how I would view the decision if one of my children was the party that I was ruling against. Even though I would not like the result, would I understand that the decision was fairly reasoned and grounded in law? That is the standard that I set for myself in every case, and it is the standard that I will follow so long as I am a judge on any court. When the President offered me this nomination, I was deeply honored. But it was not a position I had sought out and I thought carefully before accepting. The confirmation process and the work of serving on the court, if confirmed, requires sacrifices, particularly from my family. I chose to accept the nomination because I believe deeply in the rule of law and the place of the Supreme Court in our nation. I believe Americans of all backgrounds deserve an independent Supreme Court that interprets our Constitution and laws as they are written. And I believe I can serve my country by playing that role. I come before this committee with humility about the responsibility that I have been asked to undertake, and with appreciation for those who have come before me. I was 9 years old when Sandra Day O'Connor became the first woman to sit in this seat. She was a model of grace and dignity throughout her distinguished tenure on the court. When I was 21 years old and just beginning my career, Ruth Bader Ginsburg sat in this seat. She told the committee, "What has become of me could only happen in America." I have been nominated to fill Justice Ginsburg's seat, but no one will ever take her place. I will be forever grateful for the path she marked and the life she led. If confirmed, it would be the honor of a lifetime to serve alongside the Chief Justice and 7 Associate Justices. I admire them all and would consider each a valued colleague. And I might bring a few new perspectives to the bench. As the President noted when he announced my nomination, I would be the first mother of school-aged children to serve on the court. And I know that it would make Senators Young and Braun happy to know that I would be the first justice to join the court from the 7th Circuit in 45 years. I would be the only sitting justice who didn't attend school at Harvard or Yale, but I am confident that Notre Dame could hold its own, and maybe I could even teach them a thing or two about football. As a final note, Mr. Chairman, I would like to thank the many Americans from all walks of life who have reached out with messages of support over the course of my nomination. I believe in the power of prayer, and it has been uplifting to hear that so many people are praying for me. I look forward to answering the committee's questions over the coming days. And if I am fortunate enough to be confirmed, I pledge to faithfully and impartially discharge my duties to the American people as an Associate Justice of the Supreme Court. Thank you.
Thank you very much, Judge Barrett. Let's try Professor O'Hara. Any luck with her?
I'm here, Chairman Graham.
Thank you. I apologize for the problem.
We should let you know what's happening there is there were 3 individuals who were to introduce Judge Barrett, including the former law professor, former dean at Notre Dame, but they had apparently some issues, technical issues, and she was not able to speak. But nonetheless, you've heard the opening remarks from Judge Amy Coney Barrett at the beginning of these confirmation hearings. The real questioning will take place tomorrow in what's expected to be a marathon session here before the Judiciary Committee. I want to go to Justice Correspondent Pete Williams right now, who covers the Supreme Court. There was a lot said today about the speed of this process, 16 days from the point of nomination. We heard Lindsey Graham at one point, Pete, talk about the fact, well, we could have pushed this through, but we decided to hold hearings. Tell us what's normal and what's abnormal here about this process.
I think what's abnormal about it is to do it this fast at a time when the Senate has become so contentious. Yes, it's true, as many Republicans pointed out, that there were times in the past where the time from nomination to confirmation was very short. But in modern times, it's been much longer. So this is certainly compressed. But Lester, you know, the people supporting her nomination make no bones about it. The Republicans are rushing to do this while they still control the Senate and while their president is still in the White House. So that's really what this is all about. But it certainly is a compressed time frame, no question about that.
All right, let me go to our senior Washington correspondent, Andrea Mitchell. She's been covering the Supreme Court nominations for more than 30 years. Andrea, we heard both sides, as we noted earlier, really sticking to their kind of prepared talking points here. Democrats obviously wanted to focus on the vulnerability of the Affordable Care Act, all this happening in the middle of a presidential election. How fine a line do Democrats walk here?
Well, it's very difficult for them because they don't have the votes, and she is obviously, according to her biography, a very appealing nominee, the mother of 7, obviously a young woman who has good academic credentials. But that said, this is the first time ever in memory that a nomination has been pushed through after July of an election year. That is unusual. And also, as Pete points out, at a time of such poisonous divisions in our society, they stuck very closely, the Democrats did, to their strategy of pointing out that the Affordable Care Act, as you say, will come up before the court on November 10th, just a week after the election, and that hangs in the balance if she is put on the court, because she has spoken out very frequently against that and against Justice Roberts, siding in favor of it in a 5-4 decision which upheld Obamacare. So that is notable, as well as sticking together. We don't often see Democrats sticking together so completely, with all of them focusing on health care. In the backdrop is, of course, the pandemic. Their concerns about 2 members of the committee, including one, Mike Lee, who showed up at times without a mask today, who were only diagnosed positive last week, and Tom Tillis, who was virtual in his presentation. Kamala Harris, of course, the nominee for vice president, doing it as a member of the committee from her office on the Capitol, but not coming in because of her concerns she expressed for lack of testing and lack of universal mask wearing by key members of the committee, and the risks to the staff, to the Capitol policemen, to all of the sanitation people on the Hill, to all of those who could be vulnerable in cleaning up that hearing room, Lester.
All right, Andrea Mitchell, thank you. President Trump likely paying close attention to these hearings before heading to a campaign stop in Florida later today. Peter Alexander at the White House. What do you know about that, Peter?
Yeah, Lester, we know the president was watching, as evidenced by some of his tweets today, insulting one of the Democratic senators, speaking, saying that the Democrats were being given, in effect, too much time that he says was not mandated in a process like this. But takeaway, I think, from here is that for the president, this really is a reprieve from what has been foremost in the headlines for the course of the last several weeks, frankly, months, the topic of coronavirus, including the president's own diagnosis here. And to give you a sense of just how important this nomination, this confirmation process is to the president, to this White House, the fact that his own legal counsel, the White House counsel, Pat Cipollone, and his chief of staff, Mark Meadows, are physically sitting behind Amy Coney Barrett in the room there today. You talk about the president's travel. The president will return to the campaign trail later today and again over the next 3 days, 4 straight days in 4 separate states, where critics say he'll again be ignoring those CDC guidelines. The president saying that he has tested negative. His doctor has not yet said that he has tested negative. The president saying that he is now immune, that he can't spread the virus, even though at this point it's not entirely clear how long any immunity would last and how good that type of a protection is for someone who had the virus in the past. But the president recognizes that trying to focus on this court seat is better for him politically, perhaps than anything else right now, a chance to try to say to those conservatives in the country, some who may not be satisfied with the president's behavior in office, that look what I have done in terms of the courts and in terms of some of my policies, and he hopes that will bring them back around to him and to his party.
All right, Peter, thank you. Let's stay at the White House now and bring in Yamiche Alcindor, correspondent for the PBS NewsHour and an NBC News political contributor. Yamiche, it became fairly clear from Democrats in their opening statements that they want to make this partially a referendum on the future of the Affordable Care Act. The president continues to suggest that he's got something to replace the ACA should the Supreme Court strike it down. Is it clear that he actually has that? Is there, as voters begin to pay close attention, is there a Republican option?
As of right now, there has not been a Republican option presented by President Trump or by any Republican in the Senate or in the House. The president has continued to say now for years that the Republicans do have a plan to replace Obamacare or the Affordable Care Act, but it has not materialized. What we have seen is the president say that he's going to continue to cover pre-existing conditions, that he's going to make sure that people's premiums are lower, but there isn't actually any sort of plan in place. So what you have is, instead is the president saying, trust me, I will give you something as soon as I take away your health care. I think it was really telling that Republicans have been really focusing on defending the merits of Judge Barrett, defending all of her credentials, her faith, but they haven't wanted to talk about policy. Instead, it's been the Democrats who've been talking about that. And of course, the president has said a bunch of things about policy and how conservative goals would be embodied by his nominations to the Supreme Court, but Republicans just haven't gone there, likely because they know that people would point out the fact that they have not put forth a plan.
All right, Yamiche, thank you. Let me quickly bring in Barbara McQuaid, a professor of law at the University of Michigan, a former assistant U.S. attorney, and an NBC News legal analyst. Barbara, let me ask you this. We keep hearing that Judge Barrett has left kind of a roadmap to her thoughts on Affordable Care Act, on Roe v. Wade. Are a person's writings or previous statements, I mean, looking at previous justices, do they often have detours and that roadmap not as solid as it may appear?
Well, sure, Lester. I mean, when a person is acting as a scholar, they may have different viewpoints than they have as a judge or a justice. And certainly the first time around when Amy Coney Barrett was being considered to be on the Seventh Circuit Court of Appeals, she repeatedly said in defense of things that she had written, as a judge on an appellate court, an intermediate court, I don't have even the ability to overturn Supreme Court precedent. It would be my duty to follow it. But the stakes are much higher when somebody is up for the Supreme Court. There she does have the ability to overturn precedent. And so I think looking at all of those things as a roadmap to how she might decide cases in the future becomes very relevant because of the unique and incredible power that Supreme Court justices enjoy.
All right, Barbara, thank you. And we look into that hearing room. It appears the hearing is over for today. Judge Barrett having delivered her opening statements, sworn in. The questioning begins tomorrow. That is going to conclude this portion of our coverage of the Senate confirmation hearing for Supreme Court nominee Amy Coney Barrett. For continuing coverage, you can go to NBC News Now. I'll be back with a complete wrap-up on nightly news, and tomorrow morning we'll bring you live coverage as senators begin to question Judge Barrett. For now, I'm Lester Holt in New York. For all of us at NBC News, thank you for joining us. Have a good day, everyone.
You're watching NBC News Now. We've got some breaking news.
If they do go back to their jobs, they want to make sure that they are protected.
It's news made for your streaming world. Live weekdays starting at 6 a.m. Eastern.